public hearing of the General Law Committee to order at 1:31. Just some operational announcements. Just given the number of speakers we have today, what we're going to do is take a break around 5:02, and we're going to move up to 2D, which has got a lot more space for everybody. That way we can make sure everybody's accommodated if they need to sit down and want to get more comfortable. So we'll do that. And then we're going to start today with our normal procedure and sort of historical process where we will allow our elected officials, legislators, to testify first. A number of them have other committee meetings and obligations today, so we're going to jiggle the order a little bit with respect to that. And then finally, for those of you who are here, I know there's a number of people here with respect to particular concepts that we're hearing today. And we'll stay as late as we need to hear everybody, obviously. We always do that. If, however, you are together with a group and you signed up individually and you want to come up together, either in person or online or a mix of both, we're going to encourage you to do that. It'll just make it easier for the day to go on. You can get home by dinner if you need to, but also it helps us, frankly, if you're all here talking about a particular concept and you've got a particular story to tell on that concept. If we can hear you all together, it makes sense. We can ask the questions. We can have a more robust dialogue. We'll relax the 3-minute rule if you choose to do that. Just let us know. Let MJ know. If you're online in a group, shoot him a note online. Let us know that that's what you want to do. We're encouraging you to do that today. So, for example, if a bunch of hemp farmers who might be here, if you want to sit down together and come up and tell your stories and testify on a particular aspect of the bill, let's do that. It's something we don't normally do, but I think given the overlap in concepts and speakers today, it might make some sense. So we're happy to do that today. Just let us know that that's what you want to do. So with that, we'll get going, and we'll start with the House Majority Leader, Representative Candelora.
Thank you. Good afternoon, Chairman D'Agostino and Maroney and Ranking Member Ritigliano. I'm here to testify on 2 bills. I'm just going to mention and reference our testimony on Senate Bill 135, dealing with the licensing fees. We fully support that piece of legislation. I'm also here to testify in favor of House Bill 5150, which is trying to address our hemp and cannabis regulations. And I'm asking for an addition to be considered in that bill, specifically to contemplate adding in the illegal sale of cannabis to be included as a CUPPA violation under Connecticut law. And this request is specifically arising out of a situation in my community where we have voted for a moratorium on any dispensaries, on any sales. And we have basically a very active storefront that's essentially distributing large quantities of THC products. I've also heard even beyond THC products, but actual hallucinogenics and other drugs. And our law enforcement are in a situation under our current laws, it's impossible and very difficult to be able to shut this establishment down. DCP has no jurisdiction because they're not licensed in the state of Connecticut. My thought is if we add the CUPPA provisions, it gives the ability for private individuals to come in and remove these bad actors from our community, putting aside the impact that it has on our cannabis industry to have an unregulated seller effectively in the state of Connecticut. It's also putting us in a situation, our community, they're violating zoning laws, they're violating healthcare laws, and there's just no way to get our agencies to be able to come in and shut it down. But a private course of action, if we're able to hit these organizations in the pocketbook, we may have a shot of tamping down this illegal market. And so with that, I'm happy to answer any questions.
Thank you, Leader Candelora. I think just as a sort of initial comments, I want to note, obviously, we've worked well together on this committee and then in the House and Senate. I think there's large, broad bipartisan support for strengthening our enforcement members. We created a regulated market and we want the products to be sold in that regulated market. And a lot of what we're considering today, that theme is going to permeate a lot of the testimony and questions today, because that's really what you're seeing from this committee in the past and this year. So I'm appreciative of the suggestion, and I like the idea of building in a per se cut the violation for violations. There's separate things we need to do, frankly, on the criminal enforcement side, which is not under the jurisdiction of this committee. Obviously, that's judiciary. But speaking for myself, I mean, here's the majority Republican leader in the House and Democratic chair of the committee agreeing on the need for enforcement. And again, I like conceptually the idea of a per se cut the violation. I'm a little uncomfortable with the idea of the private right of action. You probably understand why. I certainly like the idea of building in the CUPA violation that then arms DCP and the AG's office, our regulatory bodies, to enforce. On the private right of action, I mean, where does that money go? You know what I mean?
Yeah, I would agree on that piece. I think under our current CUPA laws, TCP could create the regulations and then give the authority to the AG. I much more prefer that as well. And I think it would give them the ability to come in, because frankly, yeah, it isn't about individuals being able to privately collect on these. It's about stopping this illegal activity. So I would agree with you. I think that avenue, which is already in current law, if there's a way we can make it specifically for DCP, I would have no problem with that.
Yeah, and that we could take your concept and build off of that, and then there's no question they have that enforcement power under CUPA, which gives them the power to for $5,000 in fines per violation, disgorgement of profits. We're also considering a separate bill this year that will actually make sure that DCP can take away licensure. But as you mentioned, a number of these entities aren't within the regulated marketplace, and so that sort of neuters that. But I like arming our enforcement agencies and making it a per se violation, and then they can go in and use all those enforcement powers under CUPA the way you're envisioning it. Representative Rutigliano?
Just on the general topic, can a municipality be included in the one able to bring a per se CUPA?
I mean, that's not in our statutes right now, and I think we'd all have to sort of think about that, whether we want to expand the Connecticut Unfair Trade Practices Act to be enforced by municipality. Keep in mind, of course, municipalities have broad zoning power right now. So maybe there's something we can do in conjunction with planning development and zoning powers to say that a violation here not only is a CUPA violation, but automatically refers that entity to a local zoning enforcement agency for further penalty or review or something like that.
I only bring that up because it does seem that a lot of the complaints come up from the municipalities and then they get frustrated, either local PD or local zoning or just the municipality itself. I don't know.
I mean, what we're experiencing in our community, we have, local zoning that is having trouble even just enforcing their own zoning. So in my mind, they already have the ability to shut this establishment down, but they're having hurdles. I mean, there's already health code violations in that they're selling food in this establishment without a license, but we don't have our health district coming in to enforce that. And the third piece is for our police. They've gone in, they have gathered information. Who do they serve the arrest warrant to? Because it sort of is a corporate entity, which complicates it. So they're still working with the state, and this has been going on for 8 months. And it's gotten so brazen that driving up here today, I'm a big fan of WPLR. If you turn on Chaz and AJ, they were advertising and talking about an activity that's going to occur next Wednesday at this facility. And so we're at a point now. I know these laws are put into place to stop the black market, but it really is starting to get so brazen and out of control that there is nobody there to be able to regulate this market. And that's why I'm thinking, well, maybe the AG has already shown an interest in going after the licensed ones that are illegally selling these products. Maybe as an extension, this will give them more tools.
Yeah, I think you've got full agreement here from me, certainly. I like the idea of building in that power, and that way there's no question. You can go right in for the injunction. You can go right in for the penalties and not have to worry about meeting that sort of threshold hurdle. So thank you for bringing it to us. Other questions from committee members for the minority leader, excuse me. I promoted you there. No offense to
I'm
Representative
not
Rojas.
correcting you.
Yeah, online, MJ?
No questions online, Mr. Chairman.
Thank you, Representative. Appreciate your time.
Thank you.
MJ?
Did you want to keep going with
Yeah.
our?
With elected representatives.
Let's go next to Representative Amy Berger-Gavallo.
I think representatives online.
Yes, I'm adding her right now.
Got her, MJ?
Yeah, it's just taking. So she's actually she's online, but she's actually yielding her time to him.
Yeah, I just want to make sure we recognize the
Yes,
representative.
yes, I'm
She's
just trying to
available.
add her. For some reason, it's not working.
Amy, can you hear me?
Oh, now she's in.
Amy? Yes, MJ? No? Got her?
She's in, Mr. Chairman. I'm guessing she can hear you.
Representative, can you hear me? Mm,
Okay.
No?
We could move on for a sec. Sorry.
Yeah, let me come back to Amy. Let's go. Who else do we have here live?
Live. Is we can do Rep Santiago. Is she in here?
Any other representatives in the room? I don't see anybody. Oh, there you go. Representative Cheeseman. Let me get Representative Representative Vale? Yeah, why don't you come on? Come up. And then Representative Cheeseman, I see. Afternoon, Representative.
Good afternoon. Like a little bit like sardines in here today. Very popular committee. Chairman D'Agostino and Maroney, ranking members, Ciccarella and Retigliano, and the honorable members of the General Law Committee. I'm here today to support Senate Bill 135 with some changes. Specifically, I'm hopeful that the committee will add language. I had to put my glasses on.
Like Washington, you have grown blind in the service of your country, of your state.
Exactly. Well put. I'm hopeful that this committee will add language to this bill to support small businesses and ensure a timely chain of payment between owners, contractors, and subcontractors on construction projects in this state. I've submitted lengthy written testimony that I would ask you if you could please look with a lot more detail. And specifically, my suggestion is that section 42-158J of the Connecticut General Statutes be amended to model the terms of a portion of the Virginia's law. And again, I've submitted all that with my testimony. And I would like to yield my time to one of my constituents who brought this to my attention, Carmen Barker, and also Michelle Lemoy.
Thank you, Representative Vale, for yielding your time. Good afternoon, Legislative Committee. My name is Carmen Barker, and besides me is Michelle Lemoy, the Senior Project Manager and also the Senior Business Development Manager for Division 5 LLC. And I would also like to acknowledge the owner of the company, Conrad Barker, is also sitting out there. Okay. Just continue?
Yes.
Okay, alrighty. We are here on behalf of Division 5 LLC. We are a small minority-owned business. We have been in business for going on 11 years in April. We have about 16 employees combined of full-time and part-time employees. We fabricate and install miscellaneous and structural steel. The majority of our work come from commercial properties. So basically, if we win a bid on a project, the next step is to get the contract signed from both parties, from the owner and the general contractor. And the contract will detail the cost of the project and other pertinent information. We are here today because one, some owners slash general contractors fail to pay in a timely manner, which causes us to lose our lien rights. As per Connecticut Lien Statute 49-35, a notice of intent to lien in Connecticut must be sent no later than 90 days after your last day of work. And this happens quite too often. We are promised either we would be paid or there's been a delay in payment, which leaves us with the burden of being unable to pay our vendors, not being able to pay our vendors on time, or looking for other ways to fund paying our vendors. This is a trickle-down effect for everyone involved. If we don't pay our vendors on time, then we're not able to place an order to start another project. So this is why it is important for our owners and general contractors to pay us in a timely manner. The second issue we face is how the contracts are written. They will say paid when paid or paid if paid. So where does this leave us? This has caused us many headaches. General contractors have been known to be untruthful and say we have not been paid. And this leaves us, completing work, satisfactory work, and not receiving any payment from them. Sometimes the general contractor's already moved on to another project, so now we have to take on the burden of hiring an attorney to find out if they were paid. And there have been times when the owners have said, yes, I did pay them. So now that's another burden for us to try to either bring them to small claims court. The verbiage in this contract does go against the Connecticut Lien Statute, and it should not be enforceable. Connecticut's small business are not the only ones facing this issue. In April of 2022, the Virginia General Assembly passed Senate Bill 550, which makes paid when paid or paid if paid clauses unenforceable, and in most circumstances requires both public and private construction contracts to include specific payment clauses that obligates the contractors to be liable for the entire amount owed to any subcontract with which it contracts. I am asking that owners slash general contractors who fail to make timely payments should result in interest penalties. Payment should be made within 60 days of satisfactory completion of the subcontractor portion of the work, and remove verbiage from contracts that say paid if paid or paid when paid. And any construction contract that runs counter to these requirements should be voided and unenforceable. Thank you for your time. Michelle Lemoy, would you like to add something to that?
Let me just see if there's any questions.
Oh, yeah.
Any members? I'm not good. Do you have? Yeah, go ahead.
Good afternoon. How are
Good
you?
afternoon.
Do you have the ability to negotiate on your own the terms of the contract? Do they just present you with a contract? And are you able to say, disagree or make modifications to whatever they present you? You're not offered that ability by
No,
law
not
or just
really.
because?
It's really flow down, right? So whatever the owner goes down to the general contractor, goes down to the subcontractor. And really it's, if this is, you want to do the work, you need to sign the contract and here are the terms. So there's really, even though our attorney reviews all of our contracts and she advises us of notice clauses and lien requirements and all these things, if we want to do the work, we really as subcontractors have to say yes and hope for the best that if we do the work and we do it well, we're going to get paid at the end of the job within the confines of the contract.
And how do you determine, you said in the beginning that one of the payment switches, the flips of switches, you're completed. Who determines that you're completed? What is that, the contractor that does that, or is it like, say you're getting inspected and the inspector says, okay, you're good to go. So that would be your completion date. Thus the payment term
Right.
would happen after that.
So from our point of view, or any subcontractor, really, it's the scope of work that's been determined in the contract. Once that is completed, but that can be at any point during the length of the project. So for our structural steel, let's say that's 6 months before the end of the substantial completion of the project, we then have to file a 90-day lien against the project after we're done, last day on the job, but the job is still going, just so that we can make sure that we get paid because the lien rights are from the last day that we were on the job.
Did you understand?
Yeah, I do. I mean, I guess I have the other concern, which is if we did this, I mean, what if the contractor is not paid? And
Right, so the lien, when we file the lien,
no, if we did what you're asking and the
yeah.
contractor isn't paid by the owner, they can't pay you, but then you've got the hammer on them to say, well, no, you have to pay me under state law within 60 days. I don't care if the owner has paid you or not.
right.
Is that fair?
Well, no, so the idea is that it would be flow down, right? So those clauses should be non-existent from top down.
Right. So really to do this right, we'd have to do that, which is kind of a sea change to the whole industry that you'd be asking for, which I get. I'm not saying I'm opposed to it. It's just to bite off just the snippet here. My concern would be then I've flipped the, I mean, you're concerned about an imbalance in the law, but if we do it just the way you're asking to, it flips it the other way, which is now you can go to the contractor and say, I don't care if you got paid by the owner or not. You got 60 days to pay me.
Well, again, I think following this Virginia law
Uh,
has specifics in
yeah.
there as to what they were able to get passed
Mhm.
and how that affects all
All right,
parties.
we'll take a look at it. Other questions?
Yeah, the
Anyway.
law does specify between private projects, high-tier contractors, state agency, and local governments. So
Yeah.
it does kind of break it down in those three areas. Again, we are more than willing to have a conversation with the general contractor if he's proven he has not been paid, but they also have to take on some responsibility and follow up with the owners and do their due diligence and get their attorneys or whoever involved to follow up with the owner and hold them responsible. We get that, but we don't have the conversation with the owner, so we just, the sub that is just going by what the general
Yeah,
contractor says.
look, listen, I get the point. And I think from a policy perspective, I'm not opposed to this. My concern is that this is a pretty broad
Yeah.
issue that we probably need to hear from a bunch of parties in the chain here to make sure we understand the ramifications of just curing your issue. My concern is that I'm creating other ones. So I think we want to, but I really appreciate you bringing this to us. This is a
Yes.
interesting issue that I'm interested in moving forward with. I'd like to hear more about it. Senator.
I wanted to just
Yeah.
finish on that was, I am supportive, but I just wanted to make sure that there's nothing in law, like, or regulatory or in law that stops you, A, from negotiating, or B, from getting paid. And really, with our regulation of DCP or DCP's regulation over a contractor, maybe it's their license that's in peril, as opposed to, I don't know if we have the ability to impose fines or interest, but maybe their license is in peril to operate if they're not paying in a timely manner. I'm not really sure what that would look like, but I know you have a language in front of you. I just want to make sure there isn't anything currently in law that stops you from negotiating on your own behalf. So that's a question out there in the ether for legislative research or something, but
Yeah.
because that would be unacceptable.
Senator, please.
Thank you very much, Mr. Chair. Kurt, great to see you, Representative Vale and your constituents. I was just wondering, it sounds like you're sort of beholden to a contract of adhesion. You're sort of last in the food chain, and I get it. And you're going to be scrambling for business. What prevents you, though, and I can understand why it may rile them a little bit, but just as a matter of course, assuming like it's just part of your practice within 30 days of when you conclude your work, you just file the mechanics lien. And then if they get, there's no reason that should bother them unless they have some sort of refinancing and like right along the horizon. And if they say, why'd you do that? Just say, we just want to secure your payment. As soon as you pay us, we'll be happy to include a release of that mechanics lien. Why can't you just do that to keep yourself safe?
Yeah, I think we have been doing that as of recently because we've had some situations that have been a problem, but there's a cost associated with that, right? An attorney that requires having an attorney on retainer that can do all these and file all these liens. And so, as a small business, when, we're running margins that are pretty tight with competition and just the fact of the scope of the work, it just becomes another burden that's on the subcontractor's hands to make sure that we get paid for a job that we've completed.
Okay. Well, I appreciate the fact that, I feel bad that you have to spend that extra money to secure your payment, but there is a mechanism out there. I appreciate the fact that it may not always be the best way to interact with the other folks that you're dealing with. But it may be a heavy lift in trying to turn the whole system around. But I appreciate you coming and testifying today. Thank you very much, Mr. Chair.
Thank you, Senator. Other questions from committee members? Online? Representative, please.
Yeah, and again, this is something we just want to look into. They did it in Virginia and we want to do more research on how it's working there. And certainly we're willing to work with this committee to try to find language that will make everybody comfortable and not create any unforeseen, like the chairman said, any unforeseen issues with another part of the payment process. But we're more than happy to work with this committee to try to find language that will work for everybody.
No, thank you for providing the Virginia law. Actually, it does, my co-chair here pointed out to me that it does kind of address the situation I was concerned with, because it does say the earlier of the invoicing or the contractor actually being paid. So there's a safety mechanism in there that basically says if you're paid as a contractor, then you have to pay the sub, which was my issue that I was raising. But Representative Osborne.
Thank you, Mr. Chair. So just to clarify, as the subcontractor, you do not have any ability to go to the person or the entity for which you have performed the work and try to collect on that contract yourself. You are entirely at sort of the mercy of the general contractor, correct?
That is correct.
So it's only the general contractor who can engage in any kind of self-help or legal recourse against the entity for which you have done the work, correct?
Correct.
Okay, thank you very much. No further questions, Mr. Chair.
Can I just add
Thank you.
one more
Go
thing?
ahead, please.
There have been situations where we did have to go directly to the owner because what we designed, the railings we designed and installed was on their property, which increased the value of their property, which now it's now price has gone up and everything. So there have been situations where we actually had to go to the owner and sue the owner directly because the general contractor is gone on another project. There are some very small cases where we can go directly to the owner.
So if I might follow up, Mr. Chair?
Please.
So you don't need privity of direct contract with the client themselves in order to be able to pursue that legally?
Our attorney handles that. Yeah.
Okay, thank you.
The owner probably makes that very argument, Representative
You're
Osborne.
right.
Some very good, we've got some very good attorneys on this committee. She's one of them. Thank you, Representative Vale. I want to keep this moving. Thank you very much for
Thank
bringing
you
this
very
to us.
much.
Thank you for the Virginia. I'm sorry, Vaughn, you good? Okay. Yeah. You want to go? Okay. All right. We're good. Representative Cheeseman. Afternoon, Holly. Welcome back.
Thank you. It's like old home week, went from higher ed to general law. So thank you, Chairs D'Agostino, Maroney, ranking members, Retigliano and Ciccarella. I appreciate the opportunity to testify in support of your bill 5150 and 135. I want to commend this committee. Having let the genie out of the bottle, you're doing the best to keep her under control. So I don't have to, you know my history with this, any legislation dealing with cannabis. In fact, you must have known the minute a title came out containing cannabis, you were going to see Representative Cheeseman. But I particularly welcome the move with regarding redefinition of high THC, restricting substances containing THC to dispensaries, getting rid of the whole promotional coupon thing, I think is very important. So I'm very appreciative of those moves. However, I have some further suggestions of things we could do to make this market, I believe, safer. The more, again, research is done, the more we find out, particularly about the damaging effects of cannabis use on the developing fetus and indeed on breastfed babies. There was a study that recently came out of Duke that linked significant increase in neurological cancers in infants to cannabis use by pregnant women. And indeed, a study by the Colorado Department of Public Health in Denver post-legalization of retail cannabis, when surveyed, 70% of the retail outlets recommended the use of cannabis for the treatment of morning sickness. This is a dangerous, dangerous thing, and I believe our warnings on our cannabis products should make that much clearer. I know the warnings with regard to the dangers of use during pregnancy and breastfeeding only appear quarterly and state consumption while pregnant or breastfeeding may be harmful. I would suggest we go to the California wording, which says explicitly, warning, do not use while pregnant or breastfeeding. Cannabis, substances in cannabis are transferred from mother to child and can harm your baby. I think that's much more clear. It's based on the science that's out there. And I believe there is no mother who knowingly wants to ingest a substance that's going to damage her child. I would also like to see, given the increase in child poisonings from the use of edibles, truly child-proof packaging. And as 4 states do, I would like the number of the Poison Control Center printed on the packaging. And briefly, SB 135, any moves that would improve the licensing structure in Connecticut and remove barriers to entry into trades and professions is welcomed. I would love to see this go further, but I think this is a great first step in leveling the fee structure for those licenses. And that concludes my testimony, and I would be happy to take any questions. And again, thank you for raising these 2 bills.
Thank you. Questions for Representative Cheeseman? Committee members, online, MJ, anyone? Yep.
No question.
Yep, concisely done, Holly. Thank you. We appreciate it.
Thank you.
Why don't we take a break and go up to, is it 2D, MJ? Which has got more room. We can reconvene at 2:15 in 2D. All right, MJ, we good online?
Yes, Mr. Chairman.
And you were able to transfer everything over here nicely?
Yes.
So great. Okay, we'll call the committee meeting back to order. Thank you for the quick move, folks. Appreciate you coming up to 2D here. Hopefully this gives you all a little bit more room. We will pick right up with the Deputy Commissioner of DCP, Ms. Skyers Thomas. Afternoon, Commissioner.
Now we're on. Good afternoon, everyone. Senator Maroney, Representative D'Agostino, Senator Ciccarella, Representative Retigliano. Oh my gosh, Representative Retigliano. I'm so sorry. And the esteemed members of the General Law Committee, thank you for having us this afternoon. We're here to speak very briefly on our support of Senate Bill 15 and our acknowledgement of an aspect of House Bill 5150. And we're so greatly appreciative of being able to work with the committee on different aspects. Rather than reading my testimony, I'm just going to suggest that I quiet myself and allow you to ask questions, please.
What's the 5150 issue?
With regard to 5150, we are not in favor of the provision that suggests that there should be elimination of the in-person pharmacist oversight. So we believe that there is a benefit to telehealth, but in this instance, it's really imperative that there is that in-person presence for continuity of care, for familiarity, and we think it just makes for a better aspect and a better program. So we are not in favor of that elimination.
And that's the proposal of the committee to eliminate or to allow telehealth for the medical cannabis patients coming in. Right now, it's in person.
Exactly, sir.
Right. Perfect. Thank you. Appreciate DCP weighing in on the issue. Questions for the commissioner, please. Representative Retigliano.
Thank you, Mr. Chairman. Unless you want to go first. Up to you. So as in regards to the pharmacists, this is my question. So everywhere you go, CVS, Walmart, all the pharmacies are closing for a couple hours a day. It seems to me that in the industry that there seems to be a shortage. Now, I know that DCP has said there isn't a shortage, but out in the real world, there are times during the day where these pharmacies are closed for an extended period of time. So the thought was that if we sort of allowed the dispensaries to go with a telehealth option, that maybe some of these pharmacists will end up back in pharmacies. You could agree, disagree, or have a conversation about it.
So that's an interesting perspective. I believe that where we stand on that is rather than assessing how helpful that would be, we're seeing that it would be truly a detriment to the patients. So having a telehealth, where there's inconsistencies might be a detriment more so than allowing there to be flexibility and movement within the pharmaceutical aspect right there.
So a pharmacist inside of a dispensary, so when somebody's prescribed the medication, is it their job or the doctor's job to sort of see if there's a conflict with other medicine they're taking?
I think I might have,
No,
say
go
more,
ahead.
say more.
I just want to make sure I said that correctly. I don't think conflict is the right word. I think it's a reaction or anyway, go ahead.
Thankfully, today we have our subject matter experts. So I'm not sure about that question, but the subject matter experts can address
I
that a little bit
appreciate
more
that.
clearly.
Thank you.
Good afternoon, and thanks for having me. My name is Rod Marriott. I'm the Director of the Drug Control Division for the Department of Consumer Protection. In the medical marijuana program, the way it's structured is the physician provides a certification, which is slightly different than a traditional prescription. In many cases, they certify that the patient has a debilitating condition on the list of approved conditions. In this case, those drug interactions are more likely identified by the pharmacist than the practitioner in those particular circumstances.
Okay. You and I have talked offline about it. The only reason I brought it up is because we did an entire bill last year for Senator Ciccarella and others, because the pharmacies were closing without notifications. And we asked them, why are you closing? And they said that they were closing because they didn't have a pharmacist. So I didn't know if that was just a holdover from COVID or if we really do have a shortage of pharmacists.
Yeah, I don't know that we have a shortage of pharmacists, but in Tuesday's hearing, you heard a bill, Senate Bill 3133, that offered potential relief to the pharmacist work conditions, which are very stressful these days with the additional opportunities for their practice, things like vaccinations. We have hormonal contraception prescribing coming soon. So this ability to delegate tasks safely is an opportunity to hopefully relieve that issue.
I hear you. The only thing that concerns me is that even though we're going to allow the techs to do a little bit more, a pharmacist has to be present in order for them to do a little bit more. So, but if you say we have enough licensed pharmacists, then I'll take that under advisement.
There's roughly 6,600 pharmacists licensed in the state.
Historically, how does that compare to 5 or 10 years ago?
Fairly consistent, but I'll get those numbers for you more specifically.
So if we have the same number for all those years, we didn't have, well, I guess we did have medical dispensaries 10 years ago that required a pharmacy. So we'd have to go back even further. All right. So I guess I'll move on from pharmacists. And I'll just ask their Deputy Commissioner
Yes,
one
sir.
question about the fee bill, which I'm in favor of disclosure. As you know, we did the ticket bill last year, but say down the road, a business wants to put a fee on or a service fee for something or another. Does this bill make it that illegal or just as a disclosure?
Disclosure, clear and conspicuous, and we're completely in favor of that. So whatever the fees are, let us know in advance.
So if somebody has a room service menu and on that menu, they're reading in the room, it would have to be clear and conspicuous on the bottom what the service fee is. So you're basically not banning the service fee. It's a disclosure bill.
Disclosure. Yes, sir.
Thank you for that clarification.
Thank you.
Thank you, Mr. Chairman.
Thank you, Representative. Other questions for the Deputy Commissioner or DCP staff, please? Senator, you good? Okay. Online, MJ?
No questions online, Mr. Chairman.
Okay. All right. I mean, Rod, I think you heard our concern on not concern, but I mean, I think was motivating the pharmacy piece was the telehealth piece was this maybe misinformed belief of ours in terms of a shortage. Well, we're interested to hear from, obviously, we've got medical patients here today. We've got dispensaries here today who all may be testifying on this issue. So we'll take it under advisement. But we appreciate the DCP perspective on our bill. Thank you. Thank you.
Thank you to the committee.
Thank you. Appreciate it. MJ?
Next up online, we have Representative Berger Gavallo.
And can who else do we have for representatives available?
Rep Hilda Santiago and Senator Ryan Fazio.
All right, we'll go in that order after Amy Berger. Thank you.
Thank you so much, Mr. Chair, and thank you for trying to say that long name. It is Berger Gavallo. I see am I freezing up? I
No, you're good.
apologize. We're
Yep.
doing
Coming
they're
through
doing
loud and clear.
Xfinity work in my neighborhood, which is why the phone wouldn't connect before. So my deep apologies for the technical difficulty. I actually am here to cede my testimony to a gentleman who is a constituent, a local businessman, who offers his insight whenever and wherever I may need it as it applies to our work. Most importantly, he's a guy with great taste in prestige TV too. But I would like to offer my time to Mitch Ancona, who is actually there with you in person. So thank you again to the entire committee for allowing me this opportunity.
Thank you, Representative. Good to see you. Go ahead, sir.
Thank you. Members of Connecticut General Law Committee, my name is Mitch Ancona. I currently own 3 liquor stores in Fairfield County. The first was started by my grandfather right after the end of Prohibition. So we are now celebrating our 91st year. I mention that only to say that I literally grew up in this industry. And I'm going to make a simple point right off the bat. Never in the history of our industry has a legal product been introduced that directly competes with beverage alcohol. It's never happened. I want to commend you all, right? It's been a difficult situation, I'm sure, in recognizing that this has to be regulated. It has to be thought out. It has to be thoroughly vetted to see exactly who gets to sell what, when, and where. Currently, I'm finding our consumers are searching for alternatives to alcohol. The rise of Dry January and Sober October should be seen as a clear message that the consumer is rethinking their alcohol consumption. The increase in number of alcohol-free and alcohol alternative beverages, including hemp-based THC beverages in Connecticut marketplace, is another clear indication that the consumer is designing substitutes to their glass of wine, cocktail, or beer. The majority of the wholesalers that we work with have added new alcohol-free and alcohol alternative products to their portfolio. Our sales figures support the change in consumers' desires. Our beverage alcohol sales have been declining since 2022, while our alcohol-free product sales have been increasing. We now carry over 120 different alcohol-free, alcohol alternative beverages, including non-alc wine, non-alc beer, CBD-based beverages, adaptogen drinks, alcohol-free mixers, non-alc spirits, mocktails, and hemp-based THC seltzers and mocktails. After doing our due diligence as far as the legality of selling hemp-based derived THC beverages, we began stocking these items in all 3 of our locations. From day one, we treated these products as if they were another liquor-based product. Honestly, I didn't know it wasn't age-gated. I assumed it was. I personally tried these products. Since it was a brand new category, I wanted to be able to educate our curious clients with real-life personal experience. I find them to be a nice alternative to drinking beverage alcohol, and our sales figures confirm that our consumers feel the same way. We currently stock 30 different hemp-based THC beverages. We've sold close to 400 cases of these items since mid-2023. This is second in sales only to our alcohol-free beer sales, with over 700 cases for the same time frame. My thoughts would be to treat hemp-based THC beverages similar to the way we treat spirit-based alcohol products. 21 plus to purchase, only available in dispensaries and liquor stores. Flows through the traditional 3-tier distribution system. Product labels registered with the state, impose similar taxation, keep the 5 milligram THC per container, 1 milligram THC per serving regulation in place, but keep an open mind to where this new segment might go in the future. Same penalties for selling to a minor that are currently in place for selling alcohol. Some other aspects that could be considered or should be: hemp-based THC beverages being shipped direct to consumer from out of state, on-premise consumption, and perhaps an additional license to actually be able to sell these THC beverages. I also think that each one of the products should be registered with the state label-wise. I really think there's a middle ground here that can make not only the retailer, wholesaler, and supplier, consumer, and the state happy. How'd I do? 3 minutes less, I think, hopefully?
Perfect. Thank you. Questions from committee members? Representative Ackert.
Thank you. Thank you for your testimony. And so your comments now make sense. How does your comments differ from what today's practice is?
What do you mean?
Well, you said they should be. So,
So the way I understand it, this product is not age gated right now, right? There, in theory, you could, in theory, sell it to a minor. Am I correct with this? Right? I could, in theory, as a store, buy from someone out of state, put it on my shelf, and there's no regulation there. The labeling could be whatever, although you guys cleaned up the labeling nicely. Thank you. Those are it's sort of a wild, wild west out there. And I would like to see it narrowed. Safety. Yeah. I don't want kids getting this.
yeah, I appreciate your comments. I'm one of those ones that has gone to, I'm an IPA drinker. Now I'm drinking, I won't use the company's name, but near beer, they're called. They're not low. So it's a better choice for me. Yeah.
I had one last night. Listen, I said I'm
Yeah.
57 now.
Yeah.
I don't bounce back from things nearly as well as I used to.
I'm older than that. So, but thank you for your testimony, sir.
You're welcome.
Yeah. Yeah. And so just in terms of your question with respect to the current structure. So what the committee has proposed in the bill is, and we're going to hear a lot on today, is to lower the threshold limit of THC. Anything 0.5 above per package would have to be sold at through our regulated marketplace, or regulated dispensaries. So over 21, carded, all the requirements that are applicable to cannabis, you go in, you can buy that product there. The issue I'm here, correct me if I'm wrong, what you want to do is be able to sell these things in package stores.
Correct. We can put the same, regulations on that you would in a dispensary It's fine with me. I don't know.
Yeah, I
You have to
think,
be
I think
21, you
the
have to
issue
be-
that,
Yes,
that I know I have,
Okay.
and that what prompted the committee's bill, at least coming from leadership, just so the committee members are aware, is we've got one marketplace for cannabis products. And that marketplace is our heavily regulated through this committee dispensary marketplace labeling. We've got an enforcement structure that we're trying to strengthen. And if we continue to allow these to be sold in liquor stores, for example, we've got now two marketplaces, and you're proposing a separate structure, a separate regulatory environment, rigorous as it may be. My concern is we've got then two marketplaces for cannabis products. And our struggle has been our ability to control what the market is producing with respect to these cannabis products. And we feel like, at least I feel like, we have more control over that entire marketplace when it's funneled through that one path, which is the regulated dispensaries. So that's what prompted the committee bill. But I appreciate what this gentleman's proposing here is he wants the liquor stores, which currently are selling these products without age gating, without any processes to follow the 3-tier system. I'm reluctant to creating an entire parallel structure for THC drinks and cannabis infused drinks versus our whole cannabis marketplace. So that's what I think is before the committee. So you're aware what is before you today in the bill, what the bill proposed does, and what you're going to hear from speakers today on reactions to that. So Representative Particularly, I don't know if you had any.
Thank you, Mr. Chairman. So just to be clear, you're saying that these seltzers have THC in them. Do they have intoxicating properties? Are they an
They-
intoxicant?
Do they change your mindset?
Sure.
100%, just like alcohol would.
So, but it's not alcohol, it's THC, which is completely different than alcohol.
Correct.
Right. So if you spent, I don't know, a couple $1 million to get a license to sell THC in a dispensary, would you be upset that somebody else was allowed to sell THC products without that license at all? Because it's not just, these products aren't just in package stores. These products they're everywhere. They're in convenience stores, they're in gas stations, they're literally everywhere.
And that's why I'm suggesting that we treat it exactly like a spirit-based product. We already have a system in place, checks and balances, to make sure the right people are selling it to the right people. I don't want to see it in gas stations. I don't want to see it in convenience stores. As of right this second, I'm just trying to narrow the focus, right?
I feel that we need to be a little intellectually honest.
Okay.
I don't know if the package store folks would be up here in favor of this if the dispensaries came and said, geez, why can't I sell beer? People like a nice, refreshing beer with my cannabis product, right or wrong?
I guess you could make that argument, but you would also have to make the argument that you have allowed the dispensaries to sell beer, and now you're telling them they can't anymore, right? Is that correct as
Intellectually, I
well?
don't think it's one.
Well, because
It's not regulated, people didn't know that there's an intoxicant in the can, doesn't make it that it's okay to just keep going.
People
We did
didn't
lots
know-
of things in the past.
people didn't know there was an intoxicant
I
in the
didn't know
can?
this. Yeah, I wasn't even familiar with this product up until about a year ago, so.
Okay. Nor was I.
Right.
I think our first product rolled in March. Again, consumer seems to be attracted to it. Do I think that consumer is going to go to the dispensary? I don't think so. It's not the same person. This is a person that's looking to replace their 16-ounce IPA, their 220 calories. Maybe they drink one of those and a THC cocktail. They've now cut their alcohol consumption in half, right? They've saved their calories. There's a movement today towards health conscious, right? I don't want to just live longer. I want to live better. And that's what I'm hearing from my consumers. I am one of my consumers.
So I have a hard time. I struggle with it. I struggle with the reasoning that says, hey, just because I've been able to do it since last March, I should keep going. Because if we could extend that argument would be, because next week we're going to sit here, right? We're going to sit here and we're
Yep.
going to talk about beer in Target and Walmart, right?
Correct.
And we can make an intellectual argument why they don't have it. There's not enough floor space. It's not a grocery store. They can open up their own thing. But you're saying, hey, it's okay for me to sell THC, but so why isn't it okay for them to sell beer?
Well, I think I would comment that this is a brand new product. This is a realm that, to your point, you didn't know about a year ago, nor did I. And you're comparing it to something that I would classify one of the three pillars to our industry. What do we have? We have beer, we have wine, and we have spirits. Okay, now you're talking about the deterioration of one of the three main pillars versus a brand new product. This product is only being sold, in my viewpoint, legally through package stores. I know there's gray market out there. I know I'm concerned too. I don't want to see it everywhere, right? But by us having it, I'm not taking anything away from anybody. And we didn't ask for it.
But you
Okay.
can't have it both ways with your argument, though. You can't sit
Okay.
there and say, oh, it's brand new and therefore it's different from beer. You want along with dispensaries the exclusive right to sell this. You already have in fact, let me finish. You have package stores have exclusive rights to sell alcohol in this state. Beer, I mean, you name it. You guys have the monopoly, and we've gone through here on this committee many times about how you protect that. And we're going to have a hearing next week where they're going to come out in full force and protect that again in terms of, as the representative said, why can't we sell it in wine and grocery stores? Why can't we sell beer at where there's food being sold at Target? So you guys are doing fine. And now you want to come here and say, well, don't take away this little snippet of the sales that I have. Either it's a pillar or it's not. If it's a little snippet of your market, then it really isn't going to impact your bottom line if we say this should be sold only at dispensaries, where we've got, frankly, a very strong health, safety, and welfare argument to make, where we have said as a state, and we've been very consistent on this, there is a regulated marketplace for cannabis products. And what we've seen is the marketplace producing new products that say, oh, well, this doesn't really qualify. So we have to react. So now we're reacting. And what we're proposing is saying anything above a certain minimal level of THC is cannabis. And once we say that, there's one regulated marketplace for cannabis that's clean, that's bipartisan, and that gives us overarching regulatory power over these particular products. Once they get into the package stores, my concern is then I face the same thing I faced with the package stores on other issues, which we've been able to work through, but you guys don't give anything up once you get it, you know, and you want that monopoly power over what you have, beer, wine, spirits, and now you want it over cannabis products as well, along with our regular marketplace. And I'm not willing to do that just from a consumer standpoint in the first instance, but most importantly, from a regulatory perspective. Again, it's most important to me, and I think bipartisan members of this committee and this legislature, to say cannabis is cannabis, and there's a lane for cannabis that this state has established, and that's where those products go. So you see where we're coming from on that?
100%.
Yeah.
If I was to sort of go through some of the things that you mentioned, I don't agree with the definition of monopoly and the fact that that would be just package stores selling it. And we all know just package stores don't sell alcohol anymore. I also would, the word get, we didn't get anything. At the end of Prohibition, we set up a system, right? So that package stores would sell alcohol. We didn't ask for anything.
And
then
we've set up a system after prohibition of cannabis where there's one marketplace for it. And that's what we're going to do, at least for a little while.
Right.
I think,
I got you. And I respect that. And I respect your views.
Yeah.
And I like having open, candid conversation.
Yeah.
I would also argue that the idea of THC is THC is a little different. It'd almost be like saying alcohol is alcohol. And we've already proved that that's not the case because we've carved out certain segments within the alcohol community that can be sold in different establishments. Correct?
Well, I think we're figuring out. Yeah,
I didn't ask for that.
Yeah, I don't know what you mean on that, but I think the point is THC products. we look. This is a brave new world. It's a new market for us. All right. And we've set up a structure for those products. We want to at least funnel those products through that structure and see how it works. We're 2 years into this, right?
And I'm simply questioning the structure.
Yeah. Well, you're questioning it because you want to sell the product and make a profit.
Well, and I already have. And talking as a consumer, because I am my own consumer, there is a desire for this product.
Yeah, and we're not saying it's going to be banned. We're just going to say this is the place you have to buy it, like we do with beer, wine, and liquor.
Fantastic.
All right.
How is
other questions from committee members? Go ahead, Senator.
You said you got these in March, started getting these March. Where
Yes.
were you getting them from? A distributor? Are you
Yeah.
getting online? Where?
Serene. So I didn't know there was any other option too. It was brought to us. So dry January is a thing. And maybe you guys, it is a thing. It hurt us 2 years ago. I made a conscious decision that you can't convince people to drink, but I can support their decision not to drink. So that's when I wanted to be basically the hub of alcohol free, right? So that's why I started bringing on as much of these products as possible. This was just an extension of an alcohol-free, alcohol alternative product. I brought it in.
But so it is alcohol free, and I understand you have non-alcoholic beer, which would, not affect somebody that's, trying to remain sober.
Correct.
If they drink one of these seltzers that have the THC in them, it's going to alter their chemical balance and basically make them intoxicated in some way. Is that correct? He says it makes you feel
It's
different, correct?
It's difficult. I don't know what language to use. I don't like the, yes, it's kind of an all body calmness. It's similar, but different than drinking alcohol.
So if I came to your store and said, I'm sober, can I
Okay.
have one of those? Would you say, yes, you could have one of those?
I would say, well, have you had them before?
No, I've never had that. That's why I'm asking the
Okay.
question. I'm trying to understand.
Right, exactly. No, I was role playing. If you were the client, I would say, have you had them before?
getting
You would
into
say no. Well, I'd say, well, if you are curious about this, I would try to go with the least amount of THC, drink a small amount and see how you feel. I'm not going to speak to the concept of a recovering alcoholic and what's going to happen with that person if they consume a beverage that is also mind altering. I do know that I have clients that have given up alcohol for whatever reasons. I don't delve too much into those things, that are enjoying the THC because it's a social elixir that allows them to be at a party with a drink in their hand and not feel like they're just drinking a club soda with cranberry. And the argument that THC is THC, you can smoke a pre-rolled, you can vape, right? You can eat a gummy, or you can drink a 5 milligram THC cocktail. Those are three vastly different. And in fact, two of them get in your blood system considerably different, right? Vape and smoke.
I get that, but that's my concern, that if somebody is remaining sober, not only from alcohol, but any type of a narcotic in any way, or they may have to take a drug test for whatever reason.
Mhm.
If somebody ingests that and they're not realizing it, like I want a non-alcoholic drink, and we provide them with that seltzer, is there a warning that there is in
Right.
fact-
Okay, so
That's where I think I was going with this.
it's clearly marked in all our stores that is hemp-based THC. And because it is so new and the consumer has really no working idea, especially if they've never experienced THC, we walk them through and try to explain to them exactly what to expect and that it is going to alter how they feel, their brain chemistry.
Got it.
So, yeah.
Okay.
Okay.
Thank you for answering those questions. Just one last one. If somebody couldn't get them at your store and they weren't yet in the dispensaries, can you get these online anywhere, or can you?
Yes, 100%. In fact, I tested it. So I had this company Nowadays. They offer, it's a very nice package. It's a little different thing. It looks like a 750 of tequila. Looks like a liquor bottle. It has 750 milliliters in it, and it tells you 1 ounce is 2 milligrams of THC. So what you would do with this is you would maybe make a cocktail with it, which I have. So you take 1 ounce of that, which would be 2 milligrams of THC, and add it.
But you're able, I'm sorry, but you're
Yes.
able to
Oh, yeah,
get them
100%.
online
And I have
right
two,
now.
and I have two other orders standing with two other companies. One is Clarity, which is about Oregon. For the point, I wanted to test that because where I'm at, my consumer base, if they can't get it in my store and they're not comfortable driving to the closest dispensary is Danbury, and then I think there's one in Stanford. Richfield put a moratorium on it. Wilton did. A lot of these towns don't. They're going to have to drive. They're not going to drive to the dispensary. They're going to go online, drinking their coffee in the morning. They're going to go to one of these sites, and it's going to be delivered to their door 3 days later. And I'm not sure how you stop that.
Yeah, but I guess part of my concern, or just trying to process this, is if they're going to go online, they're clearly looking for it. If you get somebody that's going into your store for a non-alcoholic beverage, and that's maybe an option, you have somebody that's new at your establishment, just started working there, directs them towards that. Next thing you know, they're ingesting I would assume is something that would be considered a controlled substance like alcohol.
It
And they
is.
would think they're drinking a seltzer or possibly a non-alcoholic beer. So I was just trying to process how else they would get it, just so there wasn't any, somebody ingesting that by
Right.
accident. I know if I drank that,
Unknowingly.
I might,
Unknowingly.
feel a little funny. I'd be a little upset that thought I was getting a non-alcoholic drink or a seltzer
Right.
and couldn't drive home. But
I did lump it into that general category of sort of alcohol alternative, but we do have it sort of broken out in the stores.
Got it.
So it's clearly labeled.
got it. Thank you.
You're
Thank you,
welcome.
Senator. Representative Osborne.
Thank you, Mr. Chair. So, sir, I heard you speak previously about, or we discussed previously, the 3 pillars of your business.
Mhm.
And is it correct to say that you consider this to be almost a 4th pillar that is developing and that it is a direct competitor to the other 3 pillars in the way that other forms of THC have not previously been?
Well, THC's just become legal in the state. We knew once it did that we all as human beings only have so much time to alter,
Mhm.
and let's face it, one of the reasons I love the flavor of wine, but it's also a calming, relaxing thing. Same thing with the THC. So to think that they're buying these products not for that effect would be sort of silly. So
you
in the fact that,
noticed-
yes, so
Have you noticed in your consumers who do come in for these products, are there people who are choosing not to purchase an alcohol or spirit-based product and are moving to a THC beverage option instead?
I think what I've seen, there are probably a few clients that come in just for the THC cocktails, but it's more so it's like, okay, I'm going to pick up a 4-pack of beer, maybe a bottle of wine, and a 4-pack of THC, right? So they might spend one night and just have a THC cocktail. One night they might have a glass of wine and then switch to that before bed.
Do you have any experience knowing whether there are people who may be willing to experiment with THC in a beverage-based form who would not smoke a joint or vape?
Yeah.
And so if they're willing to consume a THC-based beverage and they would not have consumed a smoke or a vape-based THC product, that would end up cutting into your other 3 pillars, correct?
Correct.
Thank you very much. Thank you for helping me understand that. Thank you, Mr. Chair.
Thank you, Representative. Other questions from committee members? Online, MJ?
No questions online, Mr. Chairman.
Great. Thank you very much. Appreciate it.
Thank you.
Representative Santiago? Right, MJ?
Yes, Mr. Chairman, she is online.
Great. Thank you.
Thank you. Good afternoon. Buenas tardes. Thank you, Senator Maroney, Representative D'Agostino, the ranking members, and distinguished members of the General Law Committee. Thank you for having this public meeting. I would like to now yield my 3 minutes to Jason Teal from Meriden, who will comment on Bill 5150. Thank you.
Thank you, Representative. Good seeing you. Go ahead, sir.
Thank you, Hilda. Chairperson Maroney, D'Agostino, ranking members Rutigliano, Ciccarella, members of General Law. My name is Jason Teal. I'm a community activist and a social entrepreneur who develops businesses and nonprofits that work in an integrated fashion to better my community, create jobs, and build brands. I'm the vice president of the Connecticut NAACP, and I founded a nonprofit called Change the Play that works with at-risk youth around career development and entrepreneurship. Today, I'm addressing you as CEO of Nova Farms. Nova Farms is the largest fully integrated outdoor cultivator in the Northeast. We've been approved by the Social Equity Council as a social equity applicant, and we're excited to bring our top-notch experience to Connecticut. I thank this committee for yielding Representative Santiago's time to me to testify in support of Section 9 of House Bill 5150, which will simply allow outdoor cultivation to operate in the towns that have a disproportionately impacted area within its borders. Outdoor cultivation made the most sense to me due to the low economic barrier, speed to market, and environmental benefits of the business. Instead of a $20 million plus build, I can have a farm up in for a couple $1 million. Now I don't have to take a convertible note and lose my business. Instead of an 18-month build out, I can have a farm up in a few months. We use rainwater and light to power our farm. Far less water consumption, and we won't tax the energy grid, which we already know is not in the best shape. Originally, we set out to site our farm in Morris, and the town implemented a referendum banning cultivation just as I was going for zoning. I proceeded to search for a farm in the DIA over the next several months, but finding a farm in a small census tract of the DIA was nearly impossible. I began to speak to legislators last session, but I think it was a little too late to really get any movement, to really get anything done. And I don't really recall any legislators telling me that a small tweak to allow farms to operate on farmland was unreasonable. This is a common sense issue. You may hear from a small number of wealthy protectionists that have more money and power than I do, who are going to say that a farm should be located in urban parts of a city instead of a farm. This was a minor mistake in the legislation. They may claim that you're moving the goalposts, but then ask you to move the post for them on other issues that need correction. They may say that you'll create an oversupply when outdoor has not done so in any other market. In fact, there's a supply issue currently in our state. 95% of cultivators have a completely different business model, and they produce indoor top shelf flower, which is not our goal. This tweak will not realistically impact my fellow competitors or my fellow cultivators. We are asking for a minor fine tuning of the legislation to allow outdoor farms to operate on farmland. This adjustment would not realistically hurt my fellow cultivators. It will only help the industry and create more tax revenue. This will increase the opportunity for true social equity applicants to engage in the most economical way to enter the market. We're simply just asking to please allow outdoor farms to farm on farmland. Thank you.
Thank you. You sort of defended that portion of what we proposed better than probably we could. So thank you for that. Just a question for just from a grower perspective, actually. Can you just, in terms of what you're seeing in your other experience, how long does it take to get from seed to product? What are we looking at here from a growth cycle?
Yeah, from the outdoor, we're looking at, we usually try to plant in around June, early part of the year, and then we're usually harvesting around late October.
Okay. All right. So what is that? 4 or 5 months, something like that. June, July, August, September, October, something like that. Okay. That's not bad.
No.
So do you anticipate folks getting online this year?
Yes, I mean, if God willing, if this section passes, and then especially if we pass it if you enact it
Effective on passage,
yeah, effective on passage, then we can, it'll be very easy for us to have product in the market.
And one thing we did, I just want to be clear, one thing we did embed into the proposal that we're considering, I believe it's in there, is this is all still subject to local approval.
Yes,
right?
yes, and that was some of the scare that people had, that it was just going to open up to everywhere, and that's not true. It's still subject to local approval, and it still has to only be on farmland, so some of those myths were dispelled, really.
Great, thank you very much, Representative Chigliano.
Thank you. Good afternoon. Just a couple questions. Is your license for what you want to do any different from what everybody else paid to get into the space? Is the fee?
No, my fee is the same.
Fees the same. And a question that came from others that they wanted me to ask: how do you secure outdoor grow? Because I would imagine you have security concerns. How do you address that? Are there any regulations for that, or would that be up to the local municipality?
Yeah, I think the security concerns are a little overstated. We already have to have a 12-foot fence, and then we have these, cameras that are like basically on the Pentagon that can see everything, right? And then to even logistically to really make off of something, you'd have to scale a 12-foot fence, right? Then rip a tree out of the ground. But then not only would you have to rip the tree out of the ground, you have to guess the exact time when the tree was budding, right? Because then you're just going to pull the tree out and it's going to be nothing. So then you have to guess the exact time the tree is budding. You got to scale a 12-foot fence. You got to rip a tree out of the ground. Then you got to scale the fence you got to scale the 12-foot fence all the way back to get what, a half a pound of weed, a quarter pound of weed. So I think there's a lot better ways to make a little bit of money if you want to be a robber, right? So, so it just logistically, it's very difficult, right? But yeah, and then also we have security. We'll have, if anyone touches that fence, authorities will be called. So by the time you do all that, you're not going to be looking really pretty.
Great. I appreciate the answer. Thank you very much.
Representative Acker, please.
Thank you, and I appreciate your testimony. When we first started talking this bill, I don't know how many years ago it's been, and I only thought we were growing these outside. I never thought about the greenhouse component. I'm in a trade practice, so I'm an electrician. I was brought in to give a quote on a dispensary. So we walked in and they were saying, yeah, we're going to need 3,000 amps of 480 volts. And I go, what? And they go, yeah, but that's only 1/3 of what we're going to use. We'll use essentially 9,000 amps of power. They go, oh, yeah, we grow a green product, but we're not a green company. And so you're coming here and chatting up this is that you just think about it at points. You just go, yet. We can grow. We're not the best place to grow with our temperatures, but thank you for being here and bringing your story to us.
Well, appreciate it.
Thank you, Mr. Chairman.
That's great perspective, Representative Eckert. Thank you for actually bringing the committee's attention to that. Other questions from committee members in person or online? MJ, we good? Thank you very much. Appreciate you
Thank
testifying.
you guys. Appreciate it.
Next, MJ.
Next
up, we have
Senator Fabio.
Senator Fabio.
Great. You online?
Yep.
Right. Senator, good to see you.
Good to see you. Good afternoon, Chairman Maroney and D'Agostino and ranking members Ciccarella and Rutigliano, all the best Italian and Irish names in the building, and distinguished colleagues. I'm excited to testify again this year in support of SB 135, an act establishing a maximum charge for occupational licensings. SB 135 reflects language of a bill I introduced and general law passed last year, and a bill I co-introduced with Senators Maroney, Needleman, Gordon, and Representatives Cavros DeGraw and Cheeseman this year. It will cap annual fees paid by licensed workers in our state at no more than $100 in order to reduce burdens on those workers. It will improve economic opportunity for workers, make Connecticut more affordable, and help our economy grow. It should benefit all our residents, but especially working class residents most in need of economic support. Currently, state policy that imposes exorbitant fees on workers who are already licensed and qualified to work can amount to many hundreds of dollars annually. This not only reduces opportunities for those workers, but also stymies economic growth and inflates costs to consumers, to whom the costs are passed on in the form of the price for the goods and services that they buy at the store. A study published by the Pioneer Institute reveals a concerning trend. In 1950, only 5% of the US workforce required a license to do their jobs, but today that figure sits around 25%. Unfortunately, Connecticut's licensing fees and requirements are higher than most states, according to the Institute for Justice, and place our state at a competitive disadvantage. The cost of licenses can surpass $700 for occupations ranging from preschool teachers to sheet metal contractors to tree trimmers and more. The necessity to alleviate this burden is underscored in a study by the National Bureau of Economic Research, which found that licensing reduces labor supply by about 20%, depending on the state. At a time when employers are struggling to fill jobs, it's counterintuitive to make it harder for qualified workers to fill them. IJ has also noted that licensing, by acting as a bottleneck to entry in an occupation, restricts the supply of practitioners, which raises the overall costs of goods and services in the economy. By passing SB 135 this year, we can reduce cost of living in our state, support working class families, and help create opportunity for all. Thanks for the opportunity to testify. Obviously, happy to discuss or answer any questions about the bill.
Thank you, Senator. Questions from committee members? Senator? Great.
Thank you. And thank you, Senator, for testifying on this bill. I understand, as you mentioned, it was proposed last year. Can you just refresh our memory? Department of Consumer Protection, I believe, was in favor of this. Is that correct?
Yeah, I don't know that there's been testimonies submitted by DCP this year on this bill specifically. I think, my understanding is that there is support for the concept in DCP and the administration.
That was my understanding as well. I think it's a great idea. I think it's going to help our professionals, as well as all of the businesses that need these licensed and skilled professionals, as well as the end user. So I think it's a good piece of legislation, and thank you for testifying today.
Thank you, Senator.
Bipartisan support, I would add. I think we'd love to make this happen. We got to try to find some money for it, but it just will make Connecticut more competitive. It'll even the playing field. There's no reason for people to be paying what they're paying to just do their job.
Totally agree. And I think the fiscal note on last year's bill was $13 million.
That's really, if you think about it, a drop in the bucket of a $20 billion budget. So
well said.
Other questions from committee members? Online, MJ? Senator, thank you for your time.
Thank you, sir.
MJ?
Next up, we're going to have Charles Jackson.
You have some other folks with you? You can come on, all the producers can come on up together. We can pull some chairs from the sides there. Great. Appreciate you coming up as a group. It's very helpful, actually. We moved him up because he's a constable in Windsor, and also because they were able to bring their whole group up together, which we appreciate the efficiency of doing that. Go ahead, sir. Please introduce everybody and let us know what you
Hi,
testify.
my name is Charles Jackson. I am a constable for the town of Windsor, and words matter. And well, I'm elected, so that's how I get up here. So anyhow, I have brought up the people that I see the most in the social equity and also the general lottery to come and speak and educate you because I can't do it alone. I have a food and beverage license. I also have a product packaging license. I'm going to yield my time to the rest of these fine folks, and I got other things to do, so they're going to take over for me. Jenny, this is the first time for my social equity license, my social equity plan. I've got a lot of places to appear at, and I hope to see you at some of them. So I'll let you go. Have a good one, Louis. I want you to sit here. Louis.
Good. Yeah. And just introduce everybody and tell us again the industry that you're here for and what you're testifying on.
Good afternoon. My name is Luis Vega. I'm the CEO of Nautilus Botanicals. We're a DIA cultivator, and I have a provisional license, which means I've already paid my fee. There's a couple things that are going on. The program has been really difficult for the social equity applicants. There's been tons of things up and down. There's been a lot of places that have really limited us from moving forward. We've come a really long way from where we were, but there's still a lot of work to be done. There's a couple things that are really limiting. I'm also a past hemp farmer. I've maintained the hemp license just right up till I got my cannabis licenses, and then we had to transition over, which was very detrimental to my family farm and a couple other things. But the amount of regulations that you guys are trying to propose on the hemp and hemp-derived items are absolutely hard. They're demolishing a lot of the small brands and producers right now. My license for production is still valid to the end of this year, and I've had to almost stop production completely. So in the long drawn out processes to get the cannabis license, to find space, to find funding, to be able to build your brand, to be able to build your business, even just to start breaking walls down, to start growing, has limited substantially, and not only cut off funding for a lot of us, or the cost that makes it very cost prohibitive for somebody that you would call a social equity applicant. I'm also one of the only people that have been incarcerated for cannabis that has gotten a license to date. Repairing the war on drugs hasn't really been repaired, and it's really tough. I make my way up here. It's kind of made me somebody that's terrified to even walk outside at these times. It is tough. You know, it for a process that should have gone so much smoother.
Can you tell us what focus on what you guys are looking for?
Oh, I apologize. The biggest thing is I didn't get to convey everything. I will give everybody a couple moments as we go down. So I'll yield my time now. I'm Luis. If I'm around, if you guys need me, I've submitted some more information, and I guess we get to speak later.
No, tell me what do you have a specific ask?
So there are we need to be able to have multiple people on our EJVs. We need to be able to work with the local farmers that are putting into their place. You guys can't be limiting the size of what the products are going to be made. And then there's not even regulation. There's at the very bottom. Once again, I submitted this all on paper. I apologize. I got thrown up here a little bit quicker, but at the end, the wording is so vague still, and limits so much on the hemp side that you can't, it's just destroying us realistically. Thank you guys. We're coming down.
All right, go ahead. Yeah, you got mics in front of you too. You can hit me. Yeah, go ahead.
Good
Good afternoon, everyone. My name is Angelique Fritz, and I'm here with Tyler Ohasso, George Kingsley, and Stella Johnsons, and we are the Packagers Coalition. We also have Erin Gorman Kirk, Paul, I'm going to screw up your name, Travaglino, and Brian Essenter. I'm specifically talking about the packager language that was added on Bill 5150. I'd like to express the support of our Packager Coalition on the amendment that aims at broadening the scope of authorized activities of product packagers to those of product manufacturers. The current wording and interpretation of the product packager language renders the standalone packaging license unviable and incapable of meeting the current demands of our state cannabis industry. This restriction not only impedes the potential contributions of product packagers, but also places an unjust financial burden on us, equating our renewal fees with those of manufacturers with no comparable privileges. So this amendment is crucial to breathe viability into the license, allowing packagers to serve the market aligned with the true spirit of the law by ensuring product safety, compliance, and operational efficiency within the industry. Without this amendment, this license type is going to fail prospective license applications, our applications as well, the local industry, patients, and consumers as well. It is essential to recognize that without this amendment, the viability of these provisional licenses is at stake, and this was certainly not the intention of our state cannabis program. Moreover, I'd like to highlight that in the limited license context of our cannabis industry, all of us will operate within free market principles of voluntary exchange of goods and services determined by supply and demand. We want an opportunity not only to participate in healthy competition, but also in collaboration with other licenses so we all have the best chance to succeed in our businesses. Lastly, I'd like to support updates on the transporter license and changes that allow cultivators to put out adequate biomass in a timely fashion. I'm sure you will hear more about that later on. Particularly on the transport license, the limitation to hold finished product for less than 24 hours will impede the long-term efficiency and viability of our cannabis supply chain. Manufacturers and cultivators firmly believe that there is an urgent need for third-party storage facilities. As you may know, the regulations that are implied in building the necessary vault to store cannabis products, it's insanely costly, and that's going to affect how the supply chain works as the market grows. Allowing transporters to hold cannabis and hemp products in secure facilities approved by the Department of Consumer Protection will prove beneficial to establishments that have outgrown their existing vault space and require additional storage options to meet demand. So the transport license is ideally suited for this purpose, which is why I, Angelique, support this update in my testimony. And again, we need cultivators to be able to get up online so they can put adequate biomass in the market. Otherwise, us licenses won't be able to have any business. So thank you for your attention and all.
Great. No, thank you for your advocacy on that. But look, I mean, we created a new marketplace and, we didn't get everything 100% right. This is, I've said this many, many times. This is an evolving marketplace, evolving licenses. So we appreciate feedback from the industry. We've tried to correct some of the things in the original legislation, thanks to your suggestions that will hopefully make your license more viable. The vault issue is something we are looking at. It's not in the bill right now, but we'd encourage you to have, if you aren't already, a dialogue with DCP on that, because they will obviously be the enforcement arm. But we appreciate that maybe we went too far with some of the security requirements on the transportation. So we prevented actually the movement of the product in an efficient manner. So, this is the sort of feedback we need to be able to adjust our marketplace to make sure it's working, but is obviously still safe and regulated. So I could encourage you to continue that dialogue with DCP on the security issue. And we're interested in trying to do that this year as well, if we can arrive at some language that they're comfortable with as well. So
thank you.
But appreciate the advocacy of the packagers for the past year on these issues, and hopefully the bill goes ways to addressing some of your concerns. Other comments from the group?
I just want to thank the esteemed members of the committee for giving us this opportunity. Up here a little earlier than expected, but the first thing I was going to speak to is the Food and Beverage Alliance wholeheartedly accepts and agrees the drafted language to allow packagers to be manufacturers. And in fact, Honestly, I think we should just collapse the 3 manufacturing licenses into one. We are happy to facilitate that language. We support the transporter idea about, we actually helped draft that to allow, transporters, it's very inefficient to do same-day transportation. So what we believe is an optimal way to do this is to allow excess inventory to be stored at the transporter's facility and then delivered to retail when it's manifested. We also think that we could use all of our licensees a little more time. We know you gave us more, from 14 months to 24 months, but given that there is no biomass in the market, we would ask for an extra 12 months and would be happy to help you draft that. We also would like, as food and beverage manufacturers and product manufacturers, to be able to do what packagers were given last year, and that's to go to growers or producers and pick up biomass. There's a sensitivity issue when a grower goes to chop a crop, you have to be there. And so relying on a transporter to do that, particularly when you do, like I want to do live rosin, so it's flash frozen right after it's topped. It's much easier for me to send a truck, bring it there, nitrogen tank, bring it back to my facility. So we have drafted language. We're happy to bring that to you. We know that combining the 3 licenses might be a big lift in a short session, but we're happy to collaborate with you on that language.
I think we'd like to see the transportation language that you're thinking about and.
Very good. I think we- yeah.
Right, terrific.
Right. There are definitions in DCP's bill, which I think may be in another public hearing about cannabinoids, synthetic. But I don't think anybody wants to play with synthetic, so we're good with that. The definition of manufactured cannabinoids, I spoke to DCP's legal director earlier. I'd like to present to them and to you language that at least gives the commissioner some additional discretion. I'm not smart enough to know what light and heat doesn't let me do. And I don't think anybody's here to try to create novel cannabinoids. But since we only have once a year to come back to you, it'd be great to not close the door on processes that have not yet been invented or that we don't understand and can't speak to, and at least let the, commissioner vet those novel ideas and then, allow them to happen. I'd also like to speak, since I'm sitting here, about the further advertising restrictions. I appreciate that. We're not even up and running. It would be great if we could work with DCP on what those restrictions are rather than codifying something before we even start. And I'm happy to.
Fair enough.
any
That's great.
feedback on
I
that.
think we appreciate you guys when you guys send us language, it's usually in statutory format. That's very, very helpful.
Right.
Just continue the dialogue with DCP. Send us what you've got on these issues. This bill will, obviously change a little bit.
Yeah.
So when the committee votes on it at the end of the month or early March, and then there's always tweaks along the way. But
So the last thing I want to talk about is just the grow license, because there are a couple provisions in the bill. One is hemp with DIA cultivators. The other one's letting DIA cultivator become a micro cultivator. We support those pathways. We support the tribal definition. Look, indoor flower is not the same as outdoor flower. They're really quite different. I personally think the DIA definition and the restriction on growing in a DIA should be expanded to allow outdoor to be in a DIA town. I happen to think that the DIA definition altogether ought to be eliminated. And I know some people had to, adhere to that. But you're essentially, look, I've been looking for real estate for 2.5 years. I don't mean to be too colorful here, but I have not met a landlord that is not in their 50s, 60s, or 70s and white. And that's what you're forcing a social equity applicant to do, is to go fix up a not so great old building in a downtown core. And so the DIA designation is a great way to define who qualifies as social equity. It's a terrible place to grow weed. And so I might ask you to kind of think about that a little bit.
Fair point.
But this is an existential threat to our licenses as manufacturers, that there is no biomass. So we have people who are paying rent and can't create product number one until we have biomass. And there is,
we know we got to get grow going, so we're trying to do that with some of our proposals. So we hear you.
Appreciate that.
We hear you. We've heard the industry on that.
Yeah.
Anyone else on the group?
Dear esteemed General Law Committee members, hello and thank you for allowing me this time to express my perspective in regard to the product packaging license. I am writing and here today to express my support for Bill 5150, which includes language for cannabis product packagers to expand their license into a product manufacturing license. My name is George Kingsley. I'm a lifelong Connecticut resident. I am the social equity applicant for my company, Dutch Packaging. I went to high school in Waterbury, College in New Haven, and most recently I graduated from the Oaksterdam University Accelerator Program, which was sponsored by the state of Connecticut. I am here today to not only advocate for the changes to the product packaging license that have been introduced in this bill, but also to advocate on behalf of the other licensed operators in the newly emerging Connecticut adult use cannabis marketplace. License types were created to facilitate a functioning, sustainable supply chain. If the Connecticut supply chain is going to function efficiently, each license type will be relied upon to play an important role. The changes that have recently been introduced in this bill will not only give product packagers the ability to implement a viable business plan, but also give product packagers the ability to provide critical services to other license types within the supply chain. Without these changes, the likelihood that any product packagers will spend any more time and money required to earn a final license is unlikely, which will certainly create bottlenecks within the cannabis supply chain as the market matures in the near future. These changes are critical to us now, and they will undoubtedly improve the efficiency of the Connecticut cannabis supply chain during the fragile first few years of this new marketplace. The Connecticut cannabis industry has recently experienced a significant shortage in product supply. Due to a variety of challenges within this new industry, a number of provisionally licensed licensees will likely opt out or fail to secure a final license within the next 12 months, including packagers, food and beverage product manufacturers, among others. The consequences of this likely scenario will lead to additional bottlenecks that will delay the deliveries of packaged products desperately needed by retail dispensaries. We know that the proposed amendments related to product packagers will serve greatly to benefit the entire cannabis industry, the supply chain, consumers, and the overall Connecticut economy. Please vote in favor of these changes and allow us the opportunity to play our role in helping to ensure that Connecticut is a model of how to best structure an adult use cannabis marketplace. I would like to also express my support for the language to increase potency limits. If the intent of bettering our market in Connecticut is to keep our patients and customers in state, we need to be able to sell the products that people are buying. We also support alternative options for entry into the market by 149 applicants as outlined in 5150, and by any measures possible to get compliant cultivators to commence operations. Producers are the backbone of a healthy cannabis market. Finally, we believe that the transporter licensee should be able to warehouse inventory. It is in the best interest of safety for cultivators, manufacturers, and packagers to converge at a transporter's facility where fewer deliveries can occur to retail establishments. Grouping orders together is best.
I do want to just kind of keep it moving on. I mean, I appreciate the statement, but we've got your written statement. So if there's any sort of additional color you want to add to the written statement, and we got, you guys appreciate the support that you guys have for all these points. Absolutely. I mean, we heard you on it. So
great. I covered. Thank you.
Same thing. I think I mean, it's helpful to have you all up here together because we can talk about the same issue at the same time with folks who are engaged in it, but don't feel the need to just regurgitate your statement. If there's sort of additional piggybacking you want to do on what's already been said, which has been very helpful, that would be probably more beneficial for the committee. Thank you.
Hold that to the Irish woman just as she shows up. My name is Erin Gorman Kirk, and thank you all for allowing us to speak to you today. I'm the principal of Connecticut-based Canada Government Strategies, and I serve to assist licenses establish their business here. I was the winning RFP writer for the Cannabis Accelerator Network program, which partnered with Oaksterdam, and I wrote every social equity applicant brought to me on a pro bono basis. I'm the only one in the nation that did that. Coming from a 40-year maritime and military background, I've advocated for veterans and humbly appear regarding 5150 and believe there should be some tweaks. Having been involved from the onset in the Connecticut cannabis advocacy space, I'm disheartened by the impact the supply chain issues have had on our patients, particularly our hero veterans. It is not uncommon for me to hear that patients, including my 95-year-old Korean War veteran patient, have to travel out of state to find their medicine on a consistent basis, if at all. Many are forced to go to neighboring states to maintain that medication routine, so we are missing out not just on tax revenues and boost to in-state businesses, but we are failing our veterans, seniors, and patients who depend on their medication. Excuse me. Particularly for our vets, it's important we support a robust supply chain, get seeds in the ground in 2024, and prioritize patients. While I applaud what we've done so far and support your flexibility as we build out, I think there is room for improvement. For example, caregivers or family members who help veterans and those with Alzheimer's and senior citizens get medical benefits from cannabis. This helps manage their symptoms, improve their quality of life, and reduces their reliance on opioids and harmful drugs. I personally have had 3 of my veteran patients commit suicide since January 1st, all of whom were found to have had an excessive amount of opioids in their system. I do believe that the challenges to our caregivers could possibly be changed by giving them a subsidy or a tax credit, allowing them to grow a limited number of cannabis plants at home for personal use, or provide them with a subsidy or a tax credit. Provide caregivers with education and training on the safe and effective use of medical cannabis, including information on different strains, products, methods, and dosages that may suit their patients' needs, and protect caregivers from discrimination, harassment, or retaliation in their employment, housing, or public accommodations based on their status as caregiver. I think this would alleviate a lot of the stress and the financial trouble that comes with being a caregiver. Additionally, our work at the federal level on the 2018 Farm Bill with Senators Tester and McConnell give us a unique perspective on the far-reaching implications of this particular bill on small businesses, particularly hemp. And, well, actually not particularly hemp, both cannabis and hemp. The bill as it stands poses significant challenges to the vibrant community of small businesses. The modification in the allowed hemp products as outlawed in the current draft diverges from federal guidelines that we helped write and inadvertently jeopardize the livelihoods of countless individuals and enterprises. The broad and somewhat punitive restrictions on hemp products, including those with no psychoactive effects, to echo what the gentleman from Ancona said, there are no psychoactive effects on these hemp products for clarification purposes. This has led to a situation where nearly 90% of hemp product inventory in Connecticut faces potential outlawing. This action not only disrupts the supply chain, but undermines growth and sustainability of small businesses, which are the backbone of our community. I am a board member and advisor of the Connecticut Cannabis Small Business Alliance, which has put forth a series of recommended amendments that aim to rectify these issues. The recommendations are designed to create a balanced, fair, and equitable regulatory framework that aligns with federal standards while addressing the state's concerns. By adopting CCSBA's proposed language, the General Assembly can and should ensure the legislation supports the development of a robust, inclusive, and legally compliant cannabis and hemp industry in Connecticut. I urge the General Assembly to consider these proposed amendments seriously. If left unchanged, they will continue to disproportionately affect small businesses and entrepreneurs who contribute significantly to our state's economy and community well-being. It's imperative we work together to develop legislation that fosters a positive environment for all stakeholders. I also wish to support all the testimony provided by those before me, Paul Travelino, Angela Fritz, and Justin Fritz's transportation language, which has been submitted to the record. Thank you so much.
Thank you. Are there any questions? Is there anyone else in the
Thank you.
group? Who's
I don't need to get up and I don't have anything to read, so I'll try to be
Okay.
really quick, guys. I just want to first and foremost completely agree with everything that Paul said. We need inputs. We need biomass. We need distillate, or else there are going to be a lot of companies, social equity companies like ourselves, that are not going to be able to survive, and that defeats the purpose of the entire program. On a completely separate note, it's unfortunate that Representative Retigliano left. I am a pharmacist who's been working in the medical cannabis industry since 2015. The portion of this bill that removes pharmacists from the dispensaries and puts them in telehealth is going to not only lose jobs to about 70 to 80 pharmacists that have left retail pharmacy, not that there's a shortage in retail pharmacists, because let me tell you, there is nothing short for retail pharmacists right now. They don't want to work for CVS or Walgreens or anybody else. That is why these younger kids are not willing to put up with that toxic work environment for less pay than we were getting before, where they take all of your help away and expect you to do more immunizations, do more, patient care, which is great. That's what we want to do, but you don't want to do it in a toxic environment that you're getting paid nothing to do it. So they're unwilling to go there, which is why this has become such a viable, avenue, career path for so many of these. I don't know if you guys looked at the testimony, but I think there was probably 20 or so pharmacists at least, plus a bunch of technicians, plus patients who actually testified to the value of having a pharmacist in the dispensary. I have patients that I've helped through cancer diagnoses, through MS, Alzheimer's, but some of the best that we've had have been the patients that are ones with an allergy to, say, a cannabinoid or a terpene, that it's so simple that could land them in a hospital, that if you don't have a pharmacist on staff handling these products on a daily basis, they're not going to have the information to be able to help that patient find what they need. You're not going to have the patient that comes in and says, oh, hey, you know what? I forgot to tell you, my prescription changed, my dosing changed. What can we do? How can we adjust this dosing in order to get what we need and make sure that these patients are getting the products that they need dosed appropriately? Even just being in the dispensaries, handling these products every day, they may not have had any formal education, but you learn an amazing amount from your patients, number one, but just by being there and through osmosis of handling these products every single day, there's no healthcare people that are available to them the way pharmacists are. And people trust us, and they are used to seeing those faces the same way they would when they pick up an over-the-counter cough medication in a pharmacy. Sorry.
No, thank you. I think that's good perspective for us in regards to, the proposal on allowing for telehealth to understand that there isn't the shortage that, or there may not be the shortage we're hearing about.
Not saying
So-
there's not some sense of a shortage there,
Right.
but I think I've told my daughter I don't want her to be a pharmacist. I don't want her to go to pharmacy school. And I mean that with every ounce of my being. I don't want her to deal with any of those toxic environments that exist out there. It's that bad.
Thank you. Are there any questions? Is anyone else? Are there any questions online, MJ?
No, Mr. Chairman.
Okay, if not, thank you all very much. And then Paul, I did send you an email, but if you and Angie could just send us an electronic copy of this so we can send it out to the whole committee, that would be great. Okay, thank you all very much. Okay, next, Ginny Ray Clay. Please proceed, sorry.
Good afternoon. Good afternoon, Senator Maroney, Senator Ciccarella, honorable members of the General Law Committee. I am Ginny Ray Clay, Executive Director of the Social Equity Council. I'm glad to see you all again, and I wish you a very productive session. I'm here today representing the Social Equity Council and to offer testimony regarding House Bill 5150. First, I'm happy to see that many of the concepts in this bill are included in our 2024 legislative proposal submitted to the committee. Section 4, Section 5, and 9 will tremendously improve opportunities for social equity applicants to better thrive in the adult use cannabis market. The proposed changes do a couple of important things. Provides increased opportunities for 149 cultivators who've experienced unexpected startup barriers to still have an opportunity to cultivate under a microcultivator license. And in doing this, we support using a streamlined verification process that will expedite speed to market. It provides great opportunity for social equity applicants to have increased ownership opportunities in cannabis businesses. Also creates a reasonable deadline for 149 cultivators to finalize their position in the market, and gives greater opportunity for outdoor grow to 149ers, cultivators, to increase job opportunities and reinvestment. Finally, the Social Equity Council heard from and stands with 149 cultivators in opposition of Section 3 of this bill, which allows hemp producers to cultivate cannabis. Thank you for your time today, and I'm happy to answer any questions you have. And I'm sorry that I did not introduce Councilmember Corey Betts. Councilmember Betts is a member of the Social Equity Council here with me today.
He was recognized, at least we knew who he was. So how you doing, Corey? Questions from committee members? Juan.
Thank you. Just ask you a question on your opinion about the conversion from someone that has Section 149 to microcultivator. What's your opinion on that?
Either one of us, or?
Yeah, either.
So we are in favor. The council is in favor. We are in strong favor of allowing the cultivators, the 149 cultivators, to cultivate under a micro license. I think there are things that happened that no one expected. And so giving them an opportunity to still be involved and still be in the market is a great opportunity.
Now, this, if you look at the language of the bill, if you were a Section 149 participant and you were awarded 2 EJVs. In this particular case, in the language, we're not seeing that there. What's your thought on that?
The micro cultivators are not allowed to have 2 EJVs? I'm not sure that that is the case.
Yeah, but just to jump in,
I
we
don't.
are going to clarify that you'll be able to everybody will be able to step down from cultivator and microcultivator. You're correct that it's not entirely clear that you can do that. Even in this draft, we're going to clarify before it goes final that you can do exactly what you two are talking about, which is understanding the market conditions and that people won't be able to get the full cultivation. That we're going to allow the step down to micro. Yeah, Representative Kindler is correct that we need to tweak the language a little bit more to make that clear. We're going to do that.
Yeah, because I didn't see that. I was looking at the language myself and I didn't see that in there. So I wanted to see if they were aware of it. Because right now with Section 149, you automatically get 2 EJVs. When you look at the language of the bill, that's not the case, which is a little bit concerning from other members. So I think it's important you look at that because I think it's critical to their success that there is at least 1 EJV awarded to them. And I think it's critical so that our Section 149ers and those social equity applicants can succeed. So I think this is a critical component and we want to make sure that we include that in the bill.
Thank you for bringing
Thank you.
that to our attention.
Yep.
Thank you, Representative. Other questions? Representative Gonzalez, good to see you. An honorary member today. Other questions from committee members? We can, through the representative, you certainly can. God knows we allow testimony through representatives. There's no reason why we can't have questions through representatives. Other questions? Anybody online? No, we're good.
Online, Mr.
Thank you very much. Oh, I'm sorry, Senator, please.
Thank you for testifying before us. I understand that you're in favor of sections 4, 5, and 9, but 3 you're not in favor of. Could you just elaborate a little bit more? I don't know if Corey or yourself could take that.
So as you know, when legislation was passed, right? The legislation was passed for DIAs, right? I have not a problem with individuals coming in as long as they're staying in the DIAs. And a lot of these individuals trying to convert over, they ain't been nowhere around where I am. I'm an activist. I'm on Barber Street. I'm where the war on drugs have definitely impacted our communities. And if there's no buy-in to coming in to seeing what's going on with those communities, I don't think it's fair for those who have to be in those DIA areas. So that's my concern.
I also understand in my conversations with members of the council is that folks who are hemp farmers had an opportunity to apply to cultivate in cannabis, and they chose not to. The other opposition that the council has is they don't want to pay the fees and they don't want to follow the rules that the 149 cultivators have had to follow and are required to pay.
Thank you for clarifying the concerns with that specific section. And thank you for testifying for us.
Thank you. Other questions from committee members? Yes, please, Representative.
In that same line of questioning, with the hemp farmers, do you foresee where we can come to a middle ground on that at all? Where you see that the Social Equity Council will be amicable in having the exclusivity of having the hemp farmers participate in the program if they do follow the rules that we're stipulating, like you stipulated right now? I just want to get your opinion on that.
So for me, right, and I'm speaking for myself, no. I don't know what the other council members, but for me, no.
Well, again, we've got to consider a lot of different constituencies here, and we're trying to get growing to the marketplace. but I-
Exactly. And I understand also the concern of saturating the market, right, with a lot of the growth. We're still looking at the market and making sure it stabilizes, and we're not there yet.
Yeah.
There's still a lot of the licenses, the cultivators we have issued license to, and they have not opened their doors either. They're not cultivating, right? Because some of them cannot raise the dollars to pay the application fee, need the licensing fee. So we understand the concerns of having
Can I
other
tell you
entrants
my
into
concern
the market.
personally? Can I tell you my concern personally? And again, when legalization of cannabis was presented to us, right? It was under the thought of DIA areas, those areas that were directly impacted by the war on drugs. So when we talk about that, let's talk about the communities that are still hurting from that, right? So that's my biggest concern. Thank you.
Yeah, I'd also like to echo that. RERACA was written for and to help right the wrongs of cannabis in disproportionately impacted communities. And I think we have to give those communities an opportunity to thrive without introducing other members, other industries, to take away from the law that was designed to help heal.
But if you've got a social equity applicant who's approved to grow and can't grow anywhere else, are you saying you'd rather see that person just not be able to do anything and would prevent them from partnering with a existing hemp farm somewhere? You just prefer that person?
I think we try to remedy and we try to look for remedies before. So right now, I think that allowing those cultivators to go to a micro cultivator license is something that is very viable for them.
And they're
so-
free to do that, right?
Right.
Yeah.
And so I think we try that before we start allowing other folks, when we say in the first year that, this didn't happen, then
But I mean, why not allow that social equity applicant to make his or her choice, right? I mean, again, that person's been approved through the process that you said was embedded in sort of the social justice aspects of the law. That person's approved as an owner. Let's let them make the choice that, okay, maybe I want to do micro, but maybe I've got an opportunity now to grow somewhere else and get my product and my business going.
we've not heard that from the 149
All right,
cultivators.
and then in which case nobody will take advantage of it, right? But I understood. I mean, we get that there's sort of competing viewpoints on this, so we'll hear from everybody on it. Other questions or comments? Great, thank you. Thank you for the work that you guys do.
Thank you.
Appreciate it. And it's obviously difficult work, so thank you for the time. MJ?
Up next, we have Chief Richard Velke.
Afternoon.
Good afternoon, Chairman Maroney and Agostino and the committee members. My name is Richard Velke. I am the chief of the Scotticook Tribal Nation a position I was elected to by the members of the Scotticook Tribal Nation in 1987. I am here today to speak in support of House Bill 5150, an act concerning cannabis and hemp regulations. Speaking on behalf of the 300 members of the Scotticook Tribal Nation located in Western Connecticut, and is the chief of the longest recognized indigenous tribe in Connecticut, we believe we certainly should be considered for a cannabis license. Our history with the state is all too similar to tribes across the nation that have been treated violently, unfairly, unjustly, and by state and federal governments. Over the centuries, since our state recognition, the state of Connecticut egregiously grabbed our land, which once consisted of over 2,500 acres along the Housatonic River and beyond, and now has been dwindled down to just 400 acres of mountainous terrain from our indigenous lands. For example, the Connecticut state government was entrusted to pay the tribe for land that was taken over 300 years ago. The state of Connecticut appointed overseers to ensure the tribe would be compensated by the state for our tribal property. The entrust overseer stole the money that he was legally obligated to secure for our tribe. We have never been compensated by the state to this day. Scotticook burial grounds were disrespected and purposely flooded because they stood in the way of a construction project authorized by the state over a century ago. Our tribe will continue to pursue our efforts in removing the ancestors from the Housatonic River to give them a tribal burial. In 2004, the Scotticook Tribal Nation was granted its federal recognition status, only to have it rescinded 22 months later. This was the first time a tribe federal recognition was reversed in an unprecedented decision by the Bureau of Indian Affairs, causing a grave miscarriage of justice to the Scotticook Tribal Nation. The Scotticook Tribal Nation believes, along with the passing of this bill, it will allow our tribe to enter the state's cannabis industry, which would assist many of our tribal members and help correct injustice from the past. I would like to extend my appreciation to Chairman Maroney and DeAgostino for the full General Law Committee for considering this legislation. However, I believe this could be simplified by giving state tribes the same rights as the legislation that was adopted on Bill PA 21-1. A licensed grower visited our reservation and stated their opinion was the Scotticook Tribal Nation reservation was mainly a mountainous terrain. It would not be conducive to grow. Bill PA 21-1 allows tribes to grow off reservation. We ask to be granted the same opportunity. Thank you, and I'd be very happy to answer any questions from the committee.
Thank you for your testimony. Questions from committee members? Anyone online, MJ? Thank you, Chief. Appreciate your testimony.
Thank you.
I'm online.
Oh,
I am
I'm sorry,
online,
Senator Austin.
Mike,
how
I'm
are you?
sorry.
Nope, no problem.
I just wanted to thank the chief for coming up and explaining the long-term impacts that the tribal nations have had, in particular the state recognized tribal nations, which were told that they had lost their recognition by getting a fax on Columbus Day, sort of rubbing salt into an open wound. I appreciate him coming forward and speaking on this issue. And I want to thank you for raising this bill. Thank you. Thank you, Chief.
Thank you, Senator Olson. I
Thank you,
appreciate that.
Senator. Thank you, Chief. Appreciate it.
Thank you.
MJ?
Up next, I have Ed Hawthorne.
Afternoon.
Good afternoon, everyone. So I'm not here on the usual that you've been hearing about today. I promise you that. Good afternoon, Senator Maroney, Representative DiAgostino, and other distinguished members of the General Law Committee. My name is Ed Hawthorne, proud to serve as the president of the Connecticut AFL-CIO, a federation of unions representing 250,000 working men, women, and other union siblings here in the state of Connecticut. I'm here to testify in favor of House Bill 5151, an act concerning solar and licensing exemptions. So Connecticut's electrical apprenticeship training programs provide people with a career, good wages, healthcare, hope for the future. Apprenticeships provide that to us and to people that otherwise may lack that career path. To continue to expand these and ensure the safety of the workforce, and this bill really, to me, is about the safety of the workforce, we're asking that the installation process of solar collectors and photovoltaic panels, including the wiring modules, fastening, all grounding and bonding of that system, should be performed only, I stress only, by individuals with proper licensure or registered apprentices. An exception to this was enacted in 2007 when the scale of solar wasn't what it is now. Green energy is here. It's among us. It's expanding. I know I passed by multiple solar farms and solar panels on my way into the building here today. And just from the conversations I've had with people today, people were wondering, like, why are you in general law today? Because I'm usually downstairs in labor with Representative Acker. And when I told them what the bill was, they were like, well, I had solar installed in my house. Was that person licensed? And I said, maybe, maybe not. So that's what this bill is doing. I mean, in the labor movement, we talk about pay, pension, and healthcare all the time. I say safety is something that should be at the top of the list because pay, pension, and healthcare don't matter if you don't come home alive. It also doesn't matter if your house is, in danger because of faulty wiring. I know if I get solar on my house, so I got to get a bunch of trees cut down to make that happen. That's something my wife doesn't want to do. But to get that installed in the house, I want somebody that's licensed. I want it to be safe because once you take those solar panels out of the box that they're in, they're live. I know I talked to our firefighters about it, and they're saying it's some of the most troublesome things that they see on the roof because it constantly collects energy and stores that energy. We have to make sure that the wiring is properly done and that the fasteners are properly done and everything else. And that's exactly what this bill seeks to do. Requiring the full licensure through the completion of apprenticeship programs will provide the state of Connecticut with a larger, more skilled workforce for electricians, safer working conditions, and we urge you to support this very important green energy safety bill. I'd be happy to answer any questions you might have.
Thank you. Questions from committee members? Great. Thank you. Good. Yes, Representative.
Good afternoon. Thanks for being here. With respect to current solar installation, we don't have that licensure, correct?
No, that's what this would actually
And
propose.
And what are the existing problems that you feel are occurring that this will solve for? Do we have a particular problem with fires or damages being caused by non-licensed contractors installing solar?
It's just the overall safety of it all. If I want something, if I have electrical wiring done in my house, I want somebody licensed and insured to do it. This is requiring the license to install the solar panels, which generate electricity. So
Do you have any instances that you can tell me about where there has been an unsafe situation caused by the current non-licensed situation of installation of solar?
not offhand, but I can circle back on that for you.
Okay, and would the licensure requirement that you're proposing add regulatory delay or cost burden to the installation and the distribution of solar in the state of Connecticut?
Well, with the effective date of October 1st of 2026, there'd be plenty of time for people that are currently doing the installs to seek that license and also apply to the apprenticeship program as well.
And what kind of cost burden would that put on the people who are already currently employed in doing this to seek that licensure and to comply with that regulation?
I don't know the cost burden it would have, but it is a safety burden that I think should be considered here today and should be taken into account as far as the safety of installing solar and solar panels.
So under your proposal, people who are currently already installing solar for which we have no known safety incidents that you can tell me about here today, would have to apprentice themselves under your program in order to continue in the work they're already doing?
They would have to obtain that license, exactly.
And they can only do that through your apprentice program?
Not through our apprentice program, it'd be through the Department of Labor.
Through the.
There actually is a federal
discussing?
program as well. Yes, they'd have to go through DOL.
And I have no further questions. Thank you so much, Mr. Chair.
Thank you, Representative. Other questions? Thank you very much. Appreciate it.
Thank you, guys.
Up next, I have Bill Finch.
Thank you, Representative Rutigliano. Good to see you, man. Good to see you too. Chairman Maroney, D'Agostino, ranking members Ciccarella and the other guy, thanks for this opportunity to speak today about Bill 551. As a former senator, I know Senator Kissel and I worked on many bills together, and I know that there's a great bipartisan view here, and we're united in one major principle, and that's creating good jobs for Connecticut residents, regardless of whether they're Democrats or Republicans or unaffiliated. And I commend this committee for always keeping that in mind. But I was a participant in hampering that effort, and I come here today to make amends. John, I don't remember whether you, Senator, I don't remember whether you and I both voted for this bill, but we came to us about 11:45, sine die, with a bill that was an energy omnibus bill. And in that bill was a line, one line that exempted solar energy from having to be installed by a licensed electrician. So I just want to read to you. So I'm trying to do a mea culpa here and fix my mistake. I was wrong when I voted for that. Had we known that, John, I think we probably, Senator, I'm sorry, we would have probably had a lot of debate about that. Because the state of Connecticut defines electrical work as the installation, erection, maintenance, inspection, testing, alteration, or repair of any wire, cable, conduit, busway, raceway, support, insulator, conductor, appliance apparatus, fixture, or equipment that generates, transforms, transmits, or uses electrical energy for light, heat, power, or other purposes. Notice it doesn't say except from a solar panel. It says everything. And we do that because we have some of the highest standards in the world for our electrical installation. And we're very proud of it. This bill was, this part of the bill was ill-conceived at the time, received no debate. And I think it really shortchanges the career path that Representative Ackert has chosen, which I admire greatly. I'm not an electrician. I always hire electricians when I have electrical work because I don't understand it. It's mystifying to me. And I think I'm not alone in knowing that I need to hire somebody who really knows what they're doing. If we pass this, we will go back to everything electrical requires an electrician's license. And it will also put people who have not been on a career path, put them on a career path. And in response, Representative Osborne, to your question, Senator Osteen, who may be listening and may chime in, came and told us about a case where a dairy farmer, one of her constituents, the electrical work from solar panels were not properly grounded. And it caused their entire herd of dairy cows to stop producing milk because the electricity was actually at a small amount going through the cows and stopping them from milking. It cost that dairy farmer, according to Senator Osteen, about $4 million. So you'll also hear from Dan McInerney, who was a former inspector for me when I was mayor in Bridgeport. And Dan is the head of the IBW local now in the Bridgeport area. He will tell you, if you're here, I'll just mention it because I know he's late down the list, you may not be here. He had a rejection rate of well over 50%, close to 80% of installs that were just done improperly. Now, what you'll find out about this industry is that there are many times when there is a licensed electrician, but they're going between many jobs at the same time, and they can't possibly perform the job at the same level as a licensed electrician. We're going to be creating solar careers, not just day jobs. Remember also that, when we're working on, our members are working on a power plant or a building, the switch box is locked. There's a lock. There's no current. As soon as a solar panel comes out of the box, it's generating electricity. There's no lock on it. So it's probably, in some ways, a little more risky than all the other electrical work that electricians perform. They're producing electricity as soon as they are handled. So really the way to look at this is we're clarifying what was a blanket exemption. It basically said that this worked for solar, didn't have to require a license, except the tie-in at the box to the service. So we're closing this blanket exemption, this loophole, if you will, and we're explaining it. So as Ed Hawthorne mentioned, it's the grounding, the bonding, and that kind of work that is electricity, and Tim could give you a scientific explanation of it later on, that requires a license like Mr. Ackert holds, like our members hold, and we would respectfully request that this is approved. As you know, in the past, there was some disagreements with other trades. This clarifies the jobs on this, the particular parts of this job which are requiring an electrical license and those that aren't. I would say the way to think of it in your mind is it's about half requiring an electrician and half not. Is that a fair, Representative Acker? Is that a fair? I know I'm not supposed to ask you questions, but okay. That concludes my remarks, and I'm certainly happy to answer Representative Acker's questions.
Representative Acker. Senator?
I just wanted to acknowledge you, Bill, and I don't know if I should call you mayor or senator, but
anything but late for supper.
You can always call me John, and this is your second bite at the apple this year.
I think I'd prefer that witnesses call the members up to representatives and senators, and we call the witnesses Mr. Finch. So.
Yeah, I'm
just
sorry
trying
for that.
Yeah.
Mr. Chair, I'm just trying to be collegial, that's all. Thank you so much for taking the time and testifying.
Senator, it's good to see you.
Representative Acker.
Bill, you may be late for dinner tonight. There's a lot of testimony going on. We're going to be late for dinner too. So listen, Bill, I am the one that wants to grow good quality careers in the state of Connecticut. I've been battling that in this building. And just recently, one of my technicians decided to leave and go back to solar. It's called poaching. We could make this change, in this legislation. We don't have the workforce to do it. We have an agenda here in Connecticut to meet some climate goals. And the way to do that, one of the ways to do that is to put as much solar on as we can safely, as you mentioned. I actually went out and jumped on a roof. Last year's a video somewheres of it. As an electrician, I don't want to be climbing roofs. I want the people that are professionally trained, carpenters and racketeers, I call them. They get up there. They don't want to do electrical. They want to go up and put racks on a roof so that roofs don't leak. They want to put that very safe panel installation. I've done it. I know exactly how to do it. And it's essentially like taking your computer and plugging it in the wall. But I would, again, if there's things that we could do to grow this business and grow the careers and get better paid electricians out there, I'm all on board. But until we make structural changes to allow us to grow this trade, I can't stop the installation of solar panels to wait for people to be licensed. You and I agree that I think the safest people to be up there doing it, especially on the grounding and bonding stuff. State of Connecticut has regulations. We have to be properly licensed. We have to pull permits, and they have to be inspected. If any one of those is slipped because somebody doesn't do their job, we have right now the same thing is happening with our building inspectors in the state of Connecticut. We don't have enough of them. We don't have enough because why? Because they come from the licensed trades. And so without having enough licensed people in the trade to go into that business and go in and be the good quality inspectors that we want, then we have things that happen. Cows not producing milk. And that is the struggle that I have with this. And if we could find a way to work together to make that happen, it'd be great. But right now, I can tell you I had an electrician stopped in, one of the largest electricians in my district. He employs about 70 people, installs 7 solar panels a day, trying to help us meet our climate goals. paying good quality people to do the work. And that's just one company. And about 70 people, a third of them are electricians, because the electricians has to do the conduit, the wiring, and the proper connection to plug a solar panel in. It's like plugging a computer in, and it's that safe. I've done it, and I've got video of doing it. So on the big jobs that we talk about, the big solar jobs that we're talking about, the farms, the solar farms, and again, it comes down to the proper people doing the work, the training that's out there, but our inspectors to do the follow-up on those too. So we have things to work on together here. And I want as much solar to be put out there and put out there properly. And I want to grow our trade. So, and have those be the ones that doing the work. If we want to shut down solar installations in Connecticut and slow them down because we don't have the workforce, then pass this legislation.
Well, if that's a question, I could just respond by saying that in your part of the state, it may be different, but in the Bridgeport region, the unemployment rate among the IBW members is now around 50%. So the workforce is not being fully utilized. And our economy is relatively sluggish in that area for hiring electricians. The other thing I would point out is that in Massachusetts and Rhode Island, this exemption doesn't exist, and they have more solar per capita than Connecticut does. So I think it's incorrect to state that there'll be less solar if we clarify this exemption. And I think the other thing to keep in mind too, in terms of proving how this was a mistake in the first place, was that the legislature previous, Senator, you may remember this, we created a PV license, which was a lower skill, lower remuneration level. And then the next year, I believe, or the 2 years after, we basically cut the knees off from the PV license, which there's only about 30 of them in Connecticut. We want to create careers, just like you have with your employees. And I think the way to create careers is to make sure that electricians are handling electricity in all cases. It's really hard to understand how in any way, shape, or form we can have our definition of what's electrical work that I read, but then say if the electricity comes out of a solar panel. And I would say, and Dan McInerney will be here later, ask him about the rejection rate and whether or not all that work you said is being performed by electricians really is or not, because we don't believe it is. And we also don't believe most of these companies that you're going to hear from are using apprentices, which could also keep the price under control and be a good pipeline to careers. I know you want to create careers. I know we all want to create careers. I really do think getting back to our normal definition of electricity and how you have to have a license to handle all those things would help to create more careers.
I appreciate that. And I think that one of the bills I put in, I don't think it's going anywhere, unfortunately. It was going to actually increase our license inspectors in the state of Connecticut, which is woefully low. And
great idea.
And I can guarantee you that the people working in Massachusetts should probably have a licensed inspector on those jobs, just so you know that, because that legislation passed up there, but they want to keep putting solar in. So there ain't a lot of licensed inspectors showing up on those Massachusetts jobs. But thank you again, Bill, as always, for your advocacy for what you believe is what we need to do. And, you know, we agree on a lot of it. It's just how we get there.
And I thank you for coming to our training center recently. It was great to see you there.
That place is fun, is awesome. And I got an opportunity to, with Senator Kushner and others, to go to some of the union training facilities. Top notch. Thank you.
Thanks for coming.
Thank you. Other questions from committee members? Representative Osborne?
Quickly, Bill, good to see you. The
Nice to
irony
see
is
you,
not
Representative.
lost on me that last time we saw each other, we were at the Environmental Summit.
That's right.
Learning all about solar energy. So I think I'm hearing a distinction between the plug in the solar panel that goes on somebody's roof and the major solar installations, the farm installations, and the more complicated electrical types of connections. Would you agree that there's a distinction between those two types of solar installation? And might there be an opportunity for a distinction in our regulatory scheme for those two types?
You know, there's been a lot of discussion about that. I can tell you that our members don't agree with that. They've been zapped, working on a solar, project, just like electricity is electricity. I go back to the definition of electricity. When we passed this large energy omnibus bill, we ignored our definition of electricity. It's sort of like, okay, I voted for it. I'm guilty. I was wrong. I plead some ignorance because here I am trying to change it back. We should not, I don't think, ever exempt anything from that definition. I think it's playing with fire, and I think it could be, you know, we want to keep everyone safe and maintain the highest standards of electrical wiring workmanship.
Do you know offhand how much of the solar installation in this state are these larger, more complex electrical farm type installations versus the stuff that's going on my house?
Yeah, I wouldn't know. I could get that for you, but I
I'd really be interested.
basically how much residential and how much commercial, how much into the grid and how much on your home.
If that's the distinction, yes.
Okay.
Thank you. Thank you, Mr.
Thanks,
Chair.
Representative. Appreciate it. Other questions from committee members?
Mr. Chairman,
Please.
we have Senator Austin online.
Senator?
Thank you very much. And sorry I can't be there in person today. And I'm somebody that loves to be in person, so I really, really very much miss being up there today. So I just wanted to say that a lot of this had to do in the particular case that happened was a stray voltage case, which is something that I never heard about before. I know that Pura has taken out a docket on stray voltage to look at some policies relative to what happened. And I think part of it could have been dealt with. They didn't cut the herd did not completely not produce any milk at all. They did produce milk, but just not at the level that they had been producing. And it took a couple of years to figure out what the problem was. And the problem was that there was stray voltage coming from the solar system that they were paying for in order to decrease the amount of electricity they were using. And they not only had to stop using the solar system, they had to replace the herd because the stray voltage was going through the water troughs where they were drinking from, and the herd did not get over the shocking that they were experiencing relative to that. And so I think that this is something that we should be talking about. Although in my research on stray voltage, and I encourage people to just Google on the committee stray voltage and see what happens, many other states have a requirement for systems to be checked more regularly and for longer than what we do right now. So that's something that I think that we should be looking at. And Tim, Representative Acker, I'll give you a call later and tell you the stray voltage story. Thank you.
Thank you, Senator. MJ? Anyone else online?
No more questions online, Mr. Chairman.
Great. Thank you, Bill.
Thank you.
Next, MJ.
Next up online, I have Jillian Shipchak. I'm adding her right now.
Great, thank you.
Hello,
Good afternoon.
good afternoon. My name is Jill. I'm a lifetime Connecticut resident, and I'm speaking to you as a hemp-based full spectrum consumer. My story with hemp-based products, specifically full spectrum hemp products, started a few years ago when I had a premature baby, and I was suffering from severe postpartum depression. I was navigating a very tough start that my son had with his life. So I started Full Spectrum Products, and I never looked back. As this bill is enforced with THC limit of 1/2 milligram per container, it would rob me of the products that I take that help me with my PTSD. Full Spectrum Products in Connecticut in this ruling will be crippled. Furthermore, this type of bill will eliminate the therapeutic benefit of products that have helped me and so many people like myself, including my friends and family that have dealt with similar issues in life. It's just not unfair. It's sad to think that someone like myself that has found so many benefits with my postpartum depression journey and my continuing PTSD, that I would have to drive to neighboring states to continue my wellness journey to find full spectrum hemp products. I am not a candidate that would go to a dispensary, as those products are way too potent. They would get me high, and I would, my anxiety would just be extremely increased. Considering everything that was talked about today, I am all for reasonable regulations, including but not limited to better child proofing. But just, taking away the full spectrum hemp products and diminishing the accessibility to consumers like myself in the state, I believe would be a huge mistake. As a Connecticut resident, I do not support anyone that has their hand in supporting this bill. And I ask you to strongly consider my testimony and all the people that I know that have been found, have found stability in their life from these products. Like I said, I'm not wanting to the dispensaries to stop their growth. However, I believe there is a way that we can allow two separate consumer bases to shop where it's most comfortable and to find the products that can soothe both sides of the coin. Those that have that use THC to get high, and those that use full spectrum hemp products to find wellness in their life. It's my prayer and my hope that you consider my testimony and allow me to continue using full spectrum hemp products in our state of Connecticut. So I continue to be the best mom to help guide my son in his journey, as he's only 3 years old. Thank you so much for hearing me.
Thank you. Questions from committee members? Anyone online, MJ?
No questions online, Chairman.
Thank you. Thank you for your testimony.
Thank you.
So next, are we on 14?
Yes, she's online.
All right, so we're gonna start enforcing the 3-minute rule, MJ. If you don't mind, just so I can make sure committee members are home before midnight. And again, I would encourage folks, if people are here together on a particular issue, want to come up and testify together, let MJ know. Maybe we can move you up in order if you're willing to come all together and testify on a particular issue. And then we'll relax the 3-minute rule if we've got a group and we can hear a collective concern on a particular bill. That would, I think, benefit everybody.
She's here with my brother. Let me
MJ, can you? Yeah, there you go. Great. Okay, so Anne Marie Rosato, Higher Health. And is she in person or online?
She's online.
Great. Ms. Rosato, can you hear me?
Yes, I can. Can you hear me?
Great. You're on. Thank you.
Right. Awesome. Distinguished members of the committee, thank you for taking the time to hear my testimony today. My name is Anne Marie Louise Rosato. I'm the founder of Higher Health in Meriden. My company provides medical evaluations and certifications for individuals who wish to enter the medical program, but most importantly, I am a patient as well. I'm part of the Impaired Driving Task Force for the state DOT, and I'm also was part of the first wet lab, green lab, which was the first federally funded driving study in the country, where we added alcohol to cannabis to study the effects in driving. We'll also be doing that in April again. Higher Health was established in 2019, and I've personally guided hundreds of patients into the alternative method of plant-based medicine. At that time, the medical program was robust and thriving with over 50,000 patients. Today, we're around about 41,000. My passion for that began by advocating to allow chronic pain to be passed. And thank you to our lawmakers who listened and changed the lives of many for that. Right now, we're struggling a little bit with a shortage, and my business has taken about a 50% decrease. The reason that people aren't renewing is because they don't have accessibility to medication. Right now, what's available is gone from about $28 an eighth to almost a $50 range. So my fear for that, and the reason that I also advocate for this, is because I don't want people to go back to illicit medication or opioids. I became a widow at the age of 46 because of that. So I don't want to see that happen to other people. What's out there right now is we're missing edibles. We only have gummies. We've removed RSO from the menu. We don't see those 2-to-1s. We don't see those minor cannabinoids. So it's pushing people to an illicit market, whether it is black market, whether it is going back to pharmaceuticals, whatever it may be. But the program isn't as robust as we'd like to see it or as safe. Our medical patients are the most loyal and educated clientele. So if we're looking at removing that pharmacist from the dispensary, and it's because of a fiscal issue, I think that needs to be reevaluated because our patients deserve a little bit more. The reason that even though it's financially difficult for me right now, that I keep an office, it's because of my aging and my mentally challenged clientele. They deserve more. This is what's best for them. In the past 2 years with the social equity program, we wanted to make sure that we included everyone. I want to make sure that there is inclusion for my patients, especially my geriatric and my pediatric. They deserve better. We all deserve better. And especially those of us who have been around since 2018, 2019, let's not forget that medical is what brought cannabis to the state of Connecticut. We are the OGs. We are the ones who brought it here. We are not corporate. We are mom and pop. We are brick and mortar. Our CBD stores, our hemp farmers, people like myself who have been sweating it out. We are the ones who got punched in the face, laughed at for this stigma, but we're still here. We're still fighting. We're collaborating. We want your help. We need your help. Look to us for that advice, for that education, because we believe that collaboration is what brings celebration and what brings success. Thank you for your time.
Great. Thank you so much. Appreciate the testimony. Questions? Anyone online, MJ? Great.
No questions online.
Thank you, Ms. Rosado.
You're welcome. Thank you for your time.
Thank you. Patricia Marr.
She's online, Mr. Chairman.
Thank you, MJ.
Hello.
Hi, Patricia, you're on.
Okay, thank you. Good afternoon, and thank you to the committee for the opportunity to speak on House Bill 5150. I'm talking today specifically in relation to Section 8 to the pharmacists and telehealth. My name is Patricia Marr. I've been a pharmacist for 35 years and a proud UConn graduate, and I've practiced in the state of Connecticut my entire career, all in the retail pharmacy setting. The last 7 years, I have been a dispensary pharmacist in the medical marijuana field. I've seen firsthand the benefits of what having a pharmacist on site at the dispensary does for the medical patient, from the initial consultation to the ongoing discussions concerning therapy, dosing, medication options. The patient benefits greatly from the ability to have the pharmacist on site to answer any questions face to face. Patients trust the pharmacist as an integral part of their medical marijuana healthcare team. I see many elderly patients, and they have difficulty completing simple necessary tasks such as renewals or registrations due to the fear or lack of technology. And if we move to telehealth, I'm afraid many patients would discontinue their care by taking away the ability to see the pharmacist in person. I've answered questions, I've listened to concerns, and have just been a shoulder to lean on for comfort or reassurance. Many patients on a daily basis express how grateful they are to have a familiar face to see and how much they trust and value our knowledge and professionalism. Coming into the dispensary is a daily, weekly, or monthly routine that patients look forward to. If we replace that with a face or a voice over a computer or phone line, we are doing a great disservice to our patients and the foundation of what the state of Connecticut's medical marijuana program was built on. I oppose the bill, and I please consider the patient's well-being and the role of the pharmacist that plays in that. And I thank you so much for your time.
Thank you very much for your testimony. Questions from committee members? Online, MJ?
None online.
Yeah, I think in case there's anyone else testifying on that issue, we've been kibitzing as leadership of the committee, and the testimony combined with, frankly, DCP weighing in against a committee bill, which they rarely do, carries a lot of weight with us. So that I can let you know, you don't have to spend too much more time on that testimony. It's likely to come out of the bill that will be voted at a committee, and we'll be keeping the pharmacists in the dispensaries for the medical patients. Next is Catherine Donovan, BDO USA.
I do not see her online, Mr. Chairman.
Okay, thank you, MJ. Sean McGill, the CBD Gurus LLC, and followed by Jacob Honig. So both from the same company, so they're welcome to come up or together or do so online.
We do have separate things written out, so
yeah, same company, the same issue, roughly? Yeah. So go ahead, come on.
Yeah, so I'll go ahead first, I guess. So good afternoon, everybody. My name is Sean McGill. I'm co-owner of the CBG Gurus, a small hemp farm nestled in the rolling hills of northwestern Connecticut. I'm here today not only to represent myself, my business, and all the other hemp farmers across the state, but also as a representative of my customers, ranging from cannabis connoisseurs to cancer patients and everyone in between. As a cannabis farm that practices regenerative agriculture and grows food crops right alongside our hemp, we love our ability to develop direct relationships with our customers while being a positive, community forward-facing business and beacon of education for the cannabis community. I don't want to say that I'm here in opposition of anything because that has such negative connotations. So what I will say is that HB 5150, as written, would effectively put me out of business in the state of Connecticut. I'd love to shine some light on the situation from my perspective as a medicinal plant chemist, farmer, and local business owner. Here at the CBG Gurus, we clearly have a lot of love for CBG, the mother of all cannabinoids, but it is very clear that CBD products are the most in demand in the hemp market. Under the legislation that redefined THC as total THC and set a cap of 0.3%, the possibility of growing CBD flower to sell as raw flower in Connecticut was essentially eliminated. A main point I'd like to discuss is the natural maturation process of CBD hemp plants. As a hemp farm registered with the Department of Agriculture, we are required to get a pre-harvest compliance test on each individual hemp variety. At this point, the hemp must be below 0.3% total THC, and they even allow a little extra wiggle room, calling it a range of error. After receiving a passing result, we are allowed a 30-day window to let the crop mature and harvest. To bring up two examples of CBD flower that we grew last year, for pre-harvest compliance, our frosted grapes tested at 0.2% THC and 4.3% CBD. Our Resurrection Kush tested at 0.24% THC and 5% CBD. After ripening, being harvested, cured, and trimmed, the frosted grapes tested at 0.58% THC and 14.6% CBD. The Resurrection Kush tested at 0.65% THC and 14.9% CBD. We are proposing a ratio of 20:1 total cannabinoids to total THC for all hemp products, particularly extracts, raw flower, and pre-rolls. These are non-intoxicating, full-spectrum hemp products that the community needs. We have been blocked from getting some of our most popular products into our local dispensary. Meanwhile, our customers are continuously asking why our products are not available on a broader scale. So I'm here today asking for your help for the people that this plant benefits in life-changing ways on a daily basis, for the people that keep me farming. Thank you.
Jacob? I'm sorry, Sean.
Nope, you got it right.
Yeah,
That's
okay, sorry,
Jacob.
Sean.
Thank you, members of the General Law Committee. Again, my name is Jacob Honig. I'm co-owner of the CBG Gurus with Sean McGill. Before I address the dangers of proposed Bill 5150, I'd like to reiterate how the current law that's in place, Public Act 2379, hurts our business and puts the hemp industry in a dangerous legal situation. As Sean explained, the hemp flower is testing between like 0.3 and 0.6% total THC after harvest. So under the current law, DCP considers our hemp flower to be a high THC hemp product, and high THC hemp products are defined as marijuana. So not only is our hemp flower and smokable products currently defined as marijuana by the DCP, but we're not even authorized to sell these quote unquote high THC hemp products to the marijuana dispensaries because we're only licensed to sell hemp, not marijuana. And this is according to the DCP. So furthermore, with the current legislation, our 1-to-1 CBG to CBD tincture is less than 1/2 of a milligram of THC away from the 25 milligram per container cap. The current regulations need to change to allow our products to be sold and to give hemp manufacturers a speck of room for error so we can manufacture products without fear of breaking the law. If 5150 passes as written, it will end the hemp industry in Connecticut completely. As the bill currently stands, all of our products contain more than 0.5 milligrams of THC per container and would become illegal. We have no way of taking the THC out of our extract or products because we don't use any chemicals in our extraction process. Therefore, under Section 1 of Bill 5150, we'd be unable to make any compliant hemp products and will be forced to go out of business in Connecticut. Furthermore, the proposed legislation requires all hemp products to be individually packaged as single servings. That's Section 18 of proposed Bill 5150. Almost none of our products can be individually packaged in an economically feasible way other than our pre-rolls, which again are currently illegal. Yet again, in this scenario, the bill passes as it's written, we are forced out of business in Connecticut. So in my written testimony, we have submitted 2 proposals to fix 5150 in Public Act 2379. These proposals will continue to offer last year's protections for consumers from public health concerns, while offering a pathway for CT hemp farmers and manufacturers to succeed. So I urge the members of the committee to draw from our written testimony and consider a 20-to-1 total cannabinoids to total THC ratio as the basis for a realistic and equitable definition of hemp. I hope we can take this opportunity to make a monumentous step towards fair and equitable hemp laws by creating an example in Connecticut for the rest of the country. Thank you.
Look at that, perfect timing. Questions from committee members? Senator Maroney.
Yeah, Jacob, have any states passed laws along the lines of requiring that 20-to-1 ratio that you mentioned?
Colorado had a really long legal battle. The hemp industry there was trying to propose this type of ratio. It never ended up going into action. So we would be really a leader across all the states.
I
This type
also
of legislation.
would like to point out most of the other states still follow the federal legislation, which defines THC as Delta 9 THC. And, you know, that limit is set at 0.3% for Delta 9 THC. And our products do pass, you know, that standard. The flower that I provided examples of upon maturity tests around 0.12% Delta 9 THC. But again, it's just over 0.6% total THC. So that redefinition last year is kind of what caused the illegality there. And a lot of these other states are still going off the Fed law, which refers to THC as Delta 9 THC.
And I think I mean, I guess our issue, right, with the Delta 8, and then other states have looked at, I think, banning some of the Delta 8 products. And I think we've mentioned that, as something new keeps coming up, right? There's Delta 8, then THCA, and the goal is ensuring safety. So, we've seen that, across the country, calls to poison control have increased because a lot of kids are having the gummies with the Delta 8, and,
I'd also say that a lot of those gummies probably are going off of that Fed law and playing the mass loophole. So, if you have a gummy that's 5 grams, you can put a lot of THC in there and still have it be less than 0.3%. And you're not required to put any other cannabinoids in there. So you're consuming just THC. Whereas with some sort of ratio, you'd be required to put these other, non-intoxicating cannabinoids in there. And I can't refer to a specific study, but it has been proven that at a ratio greater than 5-to-1 of non-intoxicating cannabinoids to THC, the really intoxicating effects of THC are largely, I can't say eliminated, but really, negated.
And we're going to be looking at products that, with a 20-to-1 ratio, that's far beyond a 5-to-1. And as Sean said, and I want to emphasize, these products are non-intoxicating. They are really actually hemp. They're really made from hemp. We really grow it under our Department of Ag license here in Connecticut. And if any of you would be curious at all and have never tried a hemp smokable pre-roll or any products, we have some today, if you'd be so brave. But yeah, just to really nail that point in, these products are wanted by people, and they can't access them anywhere right now, and they really are non-intoxicating.
And so the testing you mentioned, is that through DOAG or through DCP, and how does that process work?
Yeah, so as a hemp farm, as I mentioned, we're required to do pre-harvest compliance testing on each individual variety. So like all the different types of the hemp that we grow, each one has to get tested before we're even allowed to harvest it. And that is done by the Department of Agriculture. They come out to our farm, they take the samples, and they love to leave all the leaves on there and all the stems and everything because they want us to pass. And they know with all the extra leaves and everything, we're more likely to pass. We love DOAG. So they come out to the farm, they take their samples and they bring them off to the lab. Right now it's normally like 5 to 10 day turnaround time between when we get the samples taken and the results. And as long as those results are below, they actually define it as Delta 9 THC, but you have to science decarboxylate everything in their testing process. So it's very similar to like what the total THC number would be. So for that pre-harvest compliance testing, we're required to be below 0.3%. And then after that, we're required to get a full panel of testing done through a licensed laboratory before we're allowed to sell any of our final, products in their final form. So that pre-harvest compliance test just basically allows us to harvest the crop.
And there are not any other seeds available on the market that could get us below that 0.3% total THC mark. It doesn't exist. And people have been breeding cannabis for 20 years to get it below 1%. So it's been very difficult, and we're at the edge of what the genome can produce.
Representative Osborne.
Thank you, Mr. Chair. So I'm trying to learn and I'm trying to understand. So I want to make sure the ratio is that having other forms, and correct me if I'm not getting this right. The ratio that you're proposing, when you add different forms of cannabinoids to the product, I said it, to the product that actually reduces the intoxicating effects of the THC that is in the product. Is that correct?
Yeah, absolutely. And I mean, even along, anybody in the marketplace, I've heard being in the marketplace, a lot of people sometimes take too many edibles or whatever, too much THC. Like I've heard the story a million times, grandma ate the whole chocolate bar or whatever, So a lot of the times people say, go take some CBD or, another minor cannabinoid because that's gonna sober you up a little bit, So
next time my dog eats the gummies, that might, no, I mean,
exactly.
So, sorry, so when we're talking about, and I'm forgetting the name of it, is the Delta 8 or the Delta 9, the one that we,
So Delta 9 THC is the one that the plant naturally makes. Delta 8 THC people make by taking CBD and using a bunch of chemicals and turning it into Delta 8 THC.
and that's not what you do. You grow a natural product that occurs this way.
Correct. Naturally, when CBD hemp grows, there is a small concentration of Delta 9 THC that exists. Just like if you look at most marijuana cultivars, there's a small concentration of CBD or CBG that exists in these other cultivars.
Thank you very much. Thank you for helping me understand, and thanks for coming today, guys.
So, look, I mean, I guess a couple of things from my perspective. At a high level, you guys all got into a business. You're growing products with THC. You're making products with THC. And we can sit here and debate till the cows come home, no pun intended, whether that gets you high or not and the level of intoxication, right? You've heard today, and I think the singular concern emanating from this bill is if it's got THC in it, we don't want to get into a situation where we got to have enforcement agents going out there in a convenience store and figuring out, well, this one's got this particular ratio, and no offense to your hat, doing math, asking cops to do math on what's in it and whether it's intoxicating or not. And while your stuff's regulated by DOAG, other products coming into the state are not. So the singular concern being addressed by this bill is to take all of these products and get them into our dispensaries. Now, I heard you, and we heard absolutely what you just said about not being able to sell them. That we need to correct, because that's not, I want to be very clear, that's not the intent. The intent is that all of those products that you make should be sold and be available in dispensaries. And if there's a regulatory issue with that, we're going to correct that. But the lane that we've established for these products with THC is our dispensaries, and that's where they should be sold, and that's what this legislation is meant to do. I appreciate that a grower, a manufacturer who is making these products wants them sold through as many avenues as possible. But this state has been very clear when we passed this law, and people who were in the business before we do it knew it was coming and took a business risk on the products they were making when we telegraphed what we were going to do. And I feel bad about that, but people make business decisions all the time and the regulatory scheme changes. And we legalized cannabis, THC, in a regulatory marketplace. And so the purpose of the bill that we have before us as a committee is to say above a minimum threshold amount. I heard everything you said about you can't avoid that. That was the intent, was to get as much of this product as possible and say, if it's got THC, I don't have to worry about an enforcement agent knowing you go into a convenience store, a liquor store, whatever, it shouldn't be there. They don't have to do math. They don't have to do ratios. They don't have to determine potency. It's sold in one place and one place only. And the advantage that you're going to have is we're going to be able to say, hey, those products that they make are blessed by DOAG, regulated by DOAG, have the imprimatur of state approval, and we can say this should be displayed right front and center in the dispensary as Connecticut grown hemp/CBD, however you guys want to call it, products that are sold. Absolutely, your stuff should be sold in dispensaries, and we're going to make sure we take steps to correct that. But that's the only place it should be sold. That's the purpose of the act. So let me just sort of get your reaction to that.
I mean, I would say just the first point is I understand the legalization of cannabis, like marijuana, But I don't think that in the legalization of marijuana, you meant to make CBD, smokable flower, which is very medicinal and totally non-intoxicating, illegal, which is effectively what happened.
Yeah, look, but this is the point here. You're telling me it's not intoxicating.
Do you want a pre-roll? I'm
It
serious.
clearly, look, but I don't want to even get into the debate. That's the whole point of what we're proposing here, is to be able to say these products have somebody wants to make pure CBD stuff. That's fine.
That's what this is.
Yeah, but if it's got the THC.
No, but that's what this is. It's CBD. You cannot grow a flower, which is what the hemp is. It's a flower that has no THC in it. You cannot do that. You cannot grow that.
Yeah, I appreciate that. That's why we actually have an exception in here for just the flower product. If you saw it, right? We're still carving out that piece on the flower in the bill. The 0.3% on a dry weight basis for cannabis flower or cannabis trim is still segregated out from that 0.5. So we're recognizing that. But at the end of the day, that product that you're making, you understand what we're struggling with is we've got these whole span of products out there that everybody's saying, oh yeah, no, don't worry, this is CBD. And then you look at it and it's got,
they're saying it's hemp and then it has a ton of THC in it.
Exactly. So
I understand that.
Corral an issue that admittedly you are not responsible for, and that you are addressing responsibly in how you're doing it, and you're getting caught up in the wash. And I don't see a way to excise you out, except to say that your products, as I said, should have a special status in the dispensaries and be able to say that's the hemp product that can be sold in Connecticut because it's regulated, because it's overseen by DOAG, as opposed to other hemp products that are out there.
I'd like to say, I think we have a good understanding of your position in regards with selling these products in dispensaries, and we encourage you to look at my public testimony that I submitted, which has some ideas that address your concerns and will help actually implement this in the law. But again, I want to really emphasize that in the bill 5150 as it currently stands, the one serving per container thing is ridiculous, and it doesn't. Again, the hemp flower has more than 0.3% total THC, so it does nothing for us to help make that available in dispensaries.
And in regards to only being available in dispensaries, I think that's like a potentially pretty big availability concern and might also steer consumers either to online markets or back to the black market. I mean, I stated our farms in Northwestern Connecticut, we have one dispensary that's like, within a certain radius. So, and meanwhile, I could type in Google on my phone and find, weed online that can get delivered right to my house. So I think just like from a availability perspective, we don't want intoxicating hemp products to be available anywhere either. We don't want that. We understand that it makes us look bad. We're not trying to sell marijuana as hemp. We're trying to sell hemp, and we're, hopefully trying to come up with the right words that would allow us to grow hemp as it exists and, sell it to customers like that mom who doesn't want to get marijuana. She wants hemp. And a lot of other people too out there, the marijuana's whatever, too intoxicating for them. So they need these hemp products to mix into their, consumption habits. So.
Great, thank you. Other questions from committee members? Just again, a note, I know there's other testimonies that look, Jacob and Sean do a great job of advocating for us. This is a good debate for the committee to hear on this particular issue. So I'd encourage other folks to sort of marshal their comments through them as well. And again, you told me a long time ago, right? If you're winning, shut up. So these guys have done a really good job, I would say, presenting the case. Think about what your testimony is going to be. I don't want to prevent anybody from testifying, but you might undermine the case they just made. So just be careful you go forward, and just good advice from committee members. You guys do a great job, and thank you for the written testimony. I appreciate that. And we'll continue the dialogue. Thank you.
Thank you, Chairman.
Yeah.
Thank you, everybody.
Mike Trahan. It's on Mike earlier. There you go. Mike, do you have anybody with you want to bring up? Great. Terrific. And MJ will relax this, since they're bringing a bunch of people up on solar, we'll relax the 3-minute rule.
Good
See you.
afternoon,
Thank you.
Mr. Chairman, members of the committee. Can I introduce a few folks to you? This is Alex Horgan from Sonova, Kyle Wallace from Posigen to my left. We have two, I believe, Michael, on remotely, Paul Lambero from Trinity Solar and Bronte Payne from Sun Power. My name is Mike Trahan. I'm Executive Director of the Connecticut Solar and Storage Association. Our 40 members are residential and commercial solar installers and developers, doing everything from supplying projects, engineering those and designing those all over the state of Connecticut. This is the 4th or 5th time that I have testified on this bill, most recently last year. Over the last 10 years, yes, this has been going on for about 10 years, a little more than 10 years, and the arguments that are being made in favor of this bill and ones like it are mostly centered around safety issues and workmanship issues. I can tell you just a quick response to some of the comments that were made before. We are licensed. We are insured. Our solar projects are inspected by professionals all over the state of Connecticut. In those 10 years since this issue first started, those arguments haven't changed. They've been dispensed with this committee and one other committee. I can tell you one big thing that has happened since this argument first started. By the end of this year, the number of solar installed projects that have been installed in the state of Connecticut, inspected and improved, will be eclipsing 100,000 systems. We'll have done 100,000 systems have been installed in the state of Connecticut, approved by professionals. And I would hope that we would think that if the system's not broke, it doesn't need any fixing. I don't want to go on much longer. I know that the two folks and the two online will speak in some detail, and I'll cede to Alice first from Sonova.
Thank you very much. Thank you, members of the committee. My name is Alice Horgan. I'm the Government Affairs Manager for Sonova Energy. We're a leading solar energy service. We have about 400,000 customers across the U.S. We partner here in Connecticut with local business and installers, and some of whom who are here to share their testimony today. I'd like to start off by giving a brief overview of the current statutory requirements for installers for residential rooftops systems, and this is all in my file testimony. So a PV installer must have a PV1 license to perform installations, erections, repairs, replacements, alterations, or maintenance of photovoltaic systems, including storage or distribution of heat, power, light, or other purposes to a point immediately inside the structure or an adjacent end use. An E1 master electrician's license for any electrical work as defined by Connecticut statute for any action to an existing panel, junction box, wiring, or circuits on the premise. The installer must have an E2 electrician's license or a PV2 license to be in the employ of the licensed electrical contractor. An employee of a company installed PV system must have a PV1, PV2, E1, or E2 license, or be an apprentice to one of those licenses and working under the direct supervision. And an employee of a licensed contractor may do the hoisting, placing, and attachment of modules without a license currently. So all the installers and dealers that Sonova partners with have up-to-date business licenses, comply with regulations, and have the proper certification to perform the various aspects of installation of a rooftop solar system. Our technicians are fully licensed and certified to address the ongoing operation and maintenance and the monitoring of inverters, solar panels, battery, wiring, and connections. And in this current statutory regime, licenses are required when the work performed is related to the specialty, and there's a historical exemption for the work that does not need specialized knowledge. This exemption for hoisting, placing, and attachment of PV modules has existed over the past decade throughout the establishment of Connecticut's robust solar market. Residential solar has been critical to making progress in the state's aggressive climate and greenhouse gas reduction goals. As far as we know, there have not been any major safety incidents regarding the installations of residential solar. HB 5151 makes changes to that solar exemption license statute by eliminating this exemption for employees of licensed contractors who would otherwise being able and properly supervised for the placement of this anchoring and panel for PV panels. So if this bill were to sign into law, an electrician would be doing non-electrical work. And so this change in exemption creates a restrictive and unnecessary requirement on a key labor segment that's already understaffed. Distributed energy installation jobs represent more than half of the installation and construction related employment in the sector. And according to Associated Builder and Contractors, the construction workforce shortage topped over 500,000 workers in 2023. We shouldn't be adding limits to clean energy transition to the job force. The adoption of additional and unnecessary license requirements would lead to an increase in cost of rooftop solar, which would be borne by homeowners and small businesses that are looking to go green. Solar represents a great opportunity for savings for customers, and Connecticut has some of the highest electricity rates in the nation. And so we shouldn't be penalizing folks seeking to install rooftop solar who are trying to address our climate crisis. Thank you.
And my name is Kyle Wallace with Posigen. I'll just add a couple of points. And the first is just to clarify what exactly a non-licensed worker can do on the job, because they are not doing the conduit, the wiring, the inverter, the AC disconnect switch, the breakers. All of that stuff is being done by the electricians, including the grounding and bonding. What the unlicensed workers can do is they can unpackage the panels, they can move them up to the rooftop, they can measure, put on the mounts for those panels and place them in and anchor those. That's the placement and anchoring that this bill would delete from the exemption. Those are the three words: placement and anchoring. So that is the limited scope that the non-licensed electricians are currently performing. And this has been talked about as a safety concern. And I just want to make it clear that I don't know that that is a valid concern, because in this very bill, it also adds an exemption so that ground mount racking systems wouldn't have to be installed by electrician. The grounding and bonding is the same, whether it's rooftop, ground mount, it is the same. And so treating a larger installation that is more complicated, like a large, 5 megawatt project in a field, differently than the rooftop racking system that is far simpler to install, I think that's a mismatch. You're saying that the rooftop installation is more dangerous from a grounding and bonding perspective, and that's just not true. So that's just one thing I wanted to point out, is the form and function of the racking systems are the same. And so this bill actually is creating an exemption and then removing one from rooftop. The second point I wanted to address was that this bill won't have a negative impact on the existing solar installer workforce in Connecticut, because there's the pathway of becoming apprenticeships. And I just want to say, for Posigen, we employ 8 licensed electricians. That, under current ratio requirements by statute, allows us to have 4 apprentices. Those spots are all filled. We do use apprentices. We want to have more apprentices. One of our unlicensed workers is currently taking courses so that when a spot opens up, they can be our next apprentice. If we wanted to make all of our non-licensed workers apprentices, let's say we had 10 unlicensed workers, to make all of those apprentices under the current ratio requirements, we would have to hire 28 new journeyman electricians just to have the 10 existing installers become apprentices. That's not practical. We don't need 28 more electricians. We have 8. I mean, we're more than quadrupling our number of electricians to just make our installers apprentices. So that's not really a solution. It's not really a pathway, because it's mathematically not possible to do. And if you have every solar company in the state facing that, that's going to be a massive problem. Like Representative Ackert said, there's not the workforce there to make that possible. This really, in my view, is not a job creation bill. This would be a job killing bill for that very reason. And I just also want to be clear that the solar installer is a career path. Like I mentioned, we are unlicensed workers. They are working towards apprenticeships when those spots are available. They can also become foremen. They can move to other operational and management positions within the operations of the company. There are clear pathways for a career, for good paying jobs through the current structure. And as Mike said, there's been over almost 90,000 installations in the state to date, and we'll cross 100,000 this year. There is no real problem here on the safety side. So that just want that for consideration, and I'll pass it to, I don't know if it's Paul or Bronte. But.
Well, yeah, if Bronte is there, and if we cover some new ground, Bronte?
Yeah, hi. I submitted written testimony, but I will keep my comments brief because Kyle and Alice covered it so well. But I'm Bronte Payne. I'm a manager of policy and strategy with SunPower. SunPower is one of the nation's leading providers of residential solar, battery storage, and energy services. We currently serve more than 550,000 residential customers across the U.S., and we employ staff directly in Connecticut and really partner with a robust network of dealers, primarily small independent businesses. I mean, I agree with all the comments made by Kyle and Alice, and really wanted to drive on the point that I think Kyle was making at the end, that the current list of license exempt work really provides a meaningful entry point into the solar industry to work as solar installers, allowing workers to gain valuable training and build the careers that are needed to support the state's clean energy goals. I also want to make a distinction that unlicensed workers are not untrained workers. These installers that are doing things like placing and hoisting and the anchoring and things that would be exempt if this bill was to pass are workers that are trained. They're just not workers that are completing the electrical work component of the installations. So I think removing the placement and anchoring from the list of license exempt work would really severely limit the work that these trained and skills installers are able to do, as Kyle mentioned, hurting the industry overall and potentially removing jobs that provide a meaningful career pathway today. We know that this would exacerbate existing workforce shortages. It would slow down the installation of rooftop solar and harm the state's transition to clean energy. So we really encourage the committee to either oppose the bill or amend the language to remove the proposed deletion of placement and anchoring.
Thanks, Bronte. Our last speaker, Mr. Chairman, Paul Lamoureux from Trinity. Paul, could you start with your credentials? And if there's any issues that we haven't addressed already, can you touch on them?
Good afternoon. I'm Paul Lamoureux. I'm the Field Operations Manager and Electrical License Holder for Trinity here in Connecticut. So they've addressed most of the things that I wanted to. There was a couple questions that came up during this that I did want to address. One was the cost for an apprenticeship. So average schooling right now is $10,000 plus for somebody to register to become an apprentice, to go through the electrical schooling. The question about the panels producing voltage. Honestly, this is no different than somebody can walk into Home Depot, buy a generator right now, start it up, plug an extension cord in, and you're producing voltage. The difference is the modules are designed with safety features. So when they're connected, it's not producing more than 1 volt per module. This is something, and string voltage, you're not getting more than 30 volts within 30 seconds of the system being connected. The other thing that I did want to talk about is really the separation of the work. Really, there's no difference than if you're having a motorized skylight installed on your home. I wouldn't want an electrician cutting a hole through my roof, and I wouldn't want a roofer connecting my electrical system. These are two different trades.
Paul, thank you.
Yeah, well, I think that last point is really what is the whole issue. And I think we'll have questions for the electricians when they come up as well, which is who, from my perspective, who's cutting the holes in the roof?
Those are done by the roofers, by the installers.
Say that again?
Those are done by the installers who are actually trained and certified to. We have the manufacturer of a racking system come out and train these guys, and these are the ones cutting the hole through the roof for the penetrations, not the electricians.
And you're saying that if we eliminate this language, the electricians would be cutting the holes in the roof?
That would be correct.
Okay, I think we'll be interested to hear from the electricians on that, because I don't think we want to. I will say the number one complaint that I hear is you ruined my roof. Not that the system's not working, not that the cows are electrified or whatever. It's that you ruined my roof. So I guess I'm not hearing either side saying how they're going to address that. Frankly, what I need to hear from are the laborers, and you need probably licensed laborers up there, or roofers, to do that work. I don't know what how do you train that person to do that particular work?
So most of our work, so the way our teams work in Connecticut is we have a 5-man crew. So we have 3 installers who are doing the lifting the modules, the racking, the mounting the everything non-tool related connections. So I've talked to the state building officials, state electrical license, and what they've determined is if it requires a tool, it has to be done by an electrician, whether it's a PV electrician or E electrician. If you take a tool out to make a connection, that is electrical work. Plug and play modules is not considered electrical work. It's no different than plugging a lamp into your wall.
And I'm sorry, what's maybe you can answer, what's a racking system?
The rails. So the mounting brackets that mount to the roof, the rail system that the modules mount to.
Gotcha. Okay. All right. I'm sorry. Questions from committee members? Tim, please.
Thank you, Mr. Chairman, and thank you all for your work that you do. What is the workforce ratio? I won't use that term. What is the workforce difference between how many non-licensed roofers, carpenters, racketeers compared to electricians? So it's got to be, you got to employ more non-licensed than you do probably licensed, right?
Correct. Because we need electricians in other departments besides just install, I currently have 65 electricians working under me. I have 10 electrical apprentices. I have 2 PV electricians. I have 11 PV apprentices. Trust me, I'm 100% proponent of the PV license, not as a replacement for installers, but in addition to help with the limited workforce of electricians. I've been pushing this program here for 5 years. Like I said, we've got now 2 PV license, and I've got 11 apprentices who are helping us in a time where it's really getting tough to find qualified electricians.
Thank you. But my question was more to the non-licensed group. So I include the apprentice being part of a licensed group, PV
Yep.
part of license. How many of the non-licensed workers do you employ?
So we have currently 76 installers.
76 installers. That
Correct.
may
Which,
be
if
affected
this
by-
bill were to go through with the current ratios, I'd either have to terminate or hire an additional 100 electricians.
Good luck finding them. Thanks.
And I just for clarity, I would say when we say solar installers, we mean the unlicensed individuals on the rooftop.
Gotcha. Okay. Representative Brown.
Thank you, Mr. Chairman. I don't know who would like to answer this question, but I had a recent experience with one of your companies. I won't say which. And it was a nightmare on my part. And I would wish I was not one of the 90,000 people you mentioned earlier who are signing up for this program, because I had a leak in my roof that I could not identify where it was coming from. And as someone who's not that skilled and talented, took me on the roof to go up there and to find out that it was actually a hole that one of the folks came in to drill to place your bracket, that actually put the hole in my roof that I couldn't identify until it was too late. When I'm talking water damage in my sunroom as a result, because my roof is on a pitch. And so the original cause of the leak wasn't leaking through there. It was flowing down my roof, and as a result, creating damage. I also didn't like the experience of folks who came out to install it. I know you said there was someone licensed at all times to be there, but no one who was working on my roof at the time spoke English. My questions went unanswered. We had to call the rep who actually came out to on their sales call in order to bring someone back to me to answer a question. And so for you to say that there's always someone licensed there, I'm gonna have to doubt that, because no one licensed was there, because I needed someone to speak English. And unfortunately, I only speak one language. So I could not ask questions of the people who were physically doing the work in real time on my roof, that, quite frankly, was because I was hounded almost every day by someone saying, these are all the benefits. And I got my bill last week. It's $450 for electricity on top of my $120 that I pay for this solar. And so I don't see the savings, frankly. And I also don't see the quality of workmanship, because we're hearing about this every day from people who are getting solar installed, that there's something not right once your folks leave. And so we have to ask as a committee, what's the problem? And so we're looking at different avenues. I know you said you've come in front of us over 10 years because we're still looking for that solution. And I think it's real. I think either the industry needs to propose, what should we be looking at in order to make sure that this isn't happening so consistently? And so I would be eager to hear from you all if there are some solutions you think that would address this problem without going to something like this.
Representative, your project was approved by your local building official?
Yes.
So the licensee or the licensee on your project, the electrician on your project, could have been only a Spanish-speaking individual. It's his license that's up if something goes wrong on that project. So he signs off, or he or she signs off on that work, and then that work is eventually approved by the local building official. If there's something wrong with the system, I understand we have consumer complaints. when you do 100,000 projects over 10 years, you're going to get some complaints. I understand. And there is a process in place through DCP and other avenues to seek, to make yourself whole in those situations. I'm happy to talk to you afterwards. I'm happy to talk to any. I field calls from individuals. I field calls from people call me up. They find me on the internet and they say, "Hey, geez, I got a problem with my system and I got it taken care of." And trust me when I say that, when our members, and I can't speak for every company that installs in the state of Connecticut, that's part of the problem. The members of our organization are very astute and understanding of the problems that are faced by some consumers, and they're on it. I'm sorry you had the situation that you did.
Yeah. Sure.
I was also just going to say, I totally understand the roof penetrations are probably one of the #1 complaints of just that they don't always go well. And so I agree that that is a very real issue that needs better training, whatever it may be. But I also want to be clear that I don't know that an electrician doing that work of drilling into the roof and putting the mounts on, I don't know that that's going to make this any better.
No, and I would agree with you on that sentiment. And then one last thing I just want to say, if you wanted to become a regular, an apprentice in the state of Connecticut to be an electrician, there's no cost to you as long as you're a Connecticut resident. And so it's not $10,000. It's actually free.
The schooling. So in order to become a PV apprentice or an electrical apprentice, you have to go through a schooling program. The schooling program is about $10,000 plus.
Yeah, that's
Great. Thank you. Representative Pizzino.
Thank you, Mr. Chair. And I just want to set the record straight that Representative Brown, you are talented, if not at handiwork. So thank you all for being here. I am not going to ask a question about the specific language in the statute. It more directs to the statement of purpose of the statute. And that sort of animates the legislative intent that we have in place with the particular policy. So when we're talking about a project that is under the direction of a properly licensed solar contractor, I just don't really know what under the direction means with respect to a solar installation project. Can one of you shed some light on how exactly directing a solar project would, like, what's the job description of someone who is actually directing a solar installation? What steps do they have to do to see a project through all the way to the end? What does it look like in practice?
Yeah, in my testimony, Representative, I listed a number of the responsibilities of the electrical license holder on the job. But Paul, I'll let you run through the supervision issue that the representative was asking about.
Yeah, so as far as our installers, we have 3 levels. We have junior, senior, lead. Lead is most experience, most training. Like I said, these guys are the one taking lead of the roof work, the installation of the brackets, the rails, the modules. The licensed electrician is taking responsibility from the electrical connection point on the roof down through the inverter, through the disconnects, to the tie-in at the electrical system.
So is it fair to say that the project director is the individual either, or do they have to be directly on site, or do they have to be just available for communication in the event of troubleshooting? Are they ultimately so first of all, that is one part of my question. And then the other part of my question is, are they ultimately the person where the buck stops with respect to a particular project? Are they the person who assumes the ultimate responsibility if something does go wrong? Or as you said, Mike, is it the contractor itself or themselves who, because if something goes wrong, it's their license at stake? Are they the person who assumes the ultimate responsibility?
It's license holder. Paul, did you want to expand a little bit on that?
Yeah, so as far as
your question, the answer is yes.
Yes, as far as the installers, that would fall under the home improvement contractor license. As far as the electrical work, that would fall under me being the license holder for Connecticut.
Thank you. All right. Are there any further questions? Okay. Senator Ciccarello.
Thank you. So you said that you have groups of 5 that go out, one of which has the license, just for clarity for the first question.
Yes, so we have 1 electrician and 1 apprentice.
So the other individuals that you were mentioning, the other 3, what is their job and what is their training?
So They are all trained by our manufacturer, the product we install on site. And they are responsible for unpacking the modules, getting them to the roof, installing the brackets, installing the rails, and connecting the modules to the rails.
And how much training do they receive?
In order to be a lead, they have to be working with us minimum of a year.
And then the other two individuals that are also probably drilling holes and doing other things on the roof, about how much training do they get?
So the lead is actually the one making the penetrations on the roof. He's been here a year. As far as measuring the roof and setting the rails, that's usually done by our junior and senior positions. Juniors could be fresh green, and then they work their way up through training.
Got it. And I know there's multiple different companies, so I'm sure it's probably different. How many crews are subcontractors compared to employees? Is there somebody that could answer that or give me an estimate?
So for Trinity, we currently have 24 in-house crews and we have 7 subcontractors.
Varies by company, but I'll let Kyle
Yeah,
start.
I'll say, I mean, our electrical work is all done in-house, and we use subcontractors when needed if we have a lot of volume in a particular month that we can't get to on our own. But we try to do as much in-house as possible.
And how many crews do you normally have in Connecticut?
We have about 4 currently, I believe.
4 crews. Okay. And is that about the same for you guys?
So we use dealer models. So we actually work with Trinity and other local businesses. And so we use Sonova, we do the back end of that. So we do the operation and management of the services of the solar panels.
Okay. Okay. Thank you very much.
Representative Tagliano.
Thank you, Mr. Chairman. Just a couple quick questions. So DCP is responsible for the licensed workers that go on people's roofs, correct? Yes. Okay. So the number 1 and 2 complaints that I get, my constituents, and my district's close to Representative Brown's constituents, is the holes in the roof, leaky roofs. It's number 1. Number 2 is that the actual savings on the electricity doesn't appear. Who, even though DCP may license the folks that do the work, who is responsible? Is there any regulatory authority on the contracts that you guys generate with consumers?
Yes, DCP is also the enforcement of that.
So enforcement, or do they approve the contract?
Well, they are home improvement contracts that are regulated by DCP.
Okay. So what recourse does a consumer have if you listen, I've heard the pitch, where it's, 40,000 to put up on my roof, and my bill's going to be $25, no more than $90. And then in Representative Brown's case, all of a sudden his bill's $400. Is that just a DCP complaint? What recourse, other than hiring a lawyer and going to court, would a consumer have?
I mean, DCP, if they, like, let's say the system's not producing as much as it should, then that's a production issue, a performance issue, certainly can be corrected and enforced through DCP. Sometimes it's just really looking at the electricity production of the system, the customer's usage, because it's not uncommon for people's electricity usage to change, especially if they get, an EV, if they have, changes to their usage patterns because of who's living at home. There are things like that that also factor in. And so you really do have to look at what the total savings are in terms of that potential change in consumption, what the production is. And so it's a bit of a, when it comes to savings, I think that's one of the challenges, is that it's not always going to be like $25 a month every month. I mean, it depends on the size of your system. Was it intended to offset 100% of your needs, or was it 70%? And in that case, you're still going to have a bill, and that bill's still going to potentially increase as utility rates increase. And so you still are avoiding a larger bill, but it's harder to know what that counterfactual is because you're only seeing the bill in front of you. So without knowing the specifics of the situation, it's hard to say generally what.
Consumers also have the option of approaching PURA, and through PURA, their Office of Education Enforcement, and they're actually have some new policies that they placed on home solar installers that start this calendar year. So they're more involved in the enforcement of contracts and things like that.
Well, I probably could have a few more questions, but it's been a long day. I have more concerns about that side of the business than maybe some of the other stuff, because the complaints are numerous, and we're not talking about a couple $1,000s here. I mean, people are getting quoted for their roof systems, 40,000. They're getting in, signing contracts that are 20 years long. They're remortgaging their house. Whether or not they're experiencing any savings, I have no idea. I'm not even really sure how long the solar panels last. I know they have a lifetime, right? Isn't it 15, 20 years?
25-year warranty typically.
Warranty, but do they diminish over time the amount of capability they have?
Yeah, at the end of the life, it's typically around 80% of what it started.
Okay.
So
So, I mean, that's where my questions lie, but I know that doesn't apply to the bill we're talking to today. But while we had you here, I thought we'd ask them. Thank you.
And just on that, I believe there is a bill in energy and technology that is looking to address some of these consumer protection concerns.
Thank you. Are there any further questions? MJ, are there any questions online?
None online, Mr. Chairman.
Okay, all right. Thank you very much for testifying. Next, I believe, is Kevin O'Connor. Is he online, MJ?
No, he's in person and he's going to have some people with him.
Okay, great. Thank you. Just make sure you push the button and identify yourself.
Is that good? Yep, perfect. My name is Stephen Nardiello, and I have Sheila Fenton here with me, and we're both representatives of small business hemp retailers. I prepared a brief statement I will read to you now. So we oppose Bill HB 5150, and let me tell you why. In life, there is good and bad in everything. There are good politicians who does what's right to protect the free market for fellow Americans, no matter what. And there are bad ones who do the opposite and monopolize them for big business. There are good hemp retailers who have been compliant since their first day in business 5 years ago with third-party testing organic products, serving Connecticut's residents in a consultative, hands-on approach like your CBD store who we represent. And there are bad ones who sell synthetic THC and marijuana illegally behind the counter and other illicit drugs. This only hurts the good guys, and it only hurts us because the other guys don't care about what law you pass. We, on the other hand, do. And I oppose this bill because it's blanketing us all together unjustly. These restrictions are an attack on the free market, and it will destroy our businesses. Not only that, but also it hurts thousands of your constituents who will not be able to get these full spectrum non-psychoactive products anymore. And they rely on it desperately. And they can't get it at adult use cannabis market because they're exclusive to your CBD store. A little bit of THC has a lot of power for the human body without affecting the brain in any way. I heard a debate earlier with D'Agostino about what's psychoactive and what's not. Well, you know, we've been doing this for almost 10 years. We have Dr. Tony Ferrara, and we know what's psychoactive and what's not. And CBD is not psychoactive, even with the natural trace amount of THC that's in there. But it is incredible for the endocannabinoid system. There's TED Talks on it that I do strongly encourage you all to look at before you pass this bill. 5 milligrams per container is enough. We could make that work and be able to help people on a regular basis with month supplies of CBD. We do not get people high. We're not interested. We do not want to compete with the marijuana dispensaries. We want to help people, and we're passionate about it. And we would just hope that you could hear us out today about that. And do not pass this bill, please. Would you like to say anything, Sheila? And this is Sheila Fenton.
Good afternoon. I know we seem to be beating a lot of horses to death today, but I'm here to represent my customers. I will get emotional. My customers are amazing. I have helped more people in 4.5 years of working for your CBD store than I could ever imagine. And now this law is going to take away products that are helping my customers without being on opioids, without being on marijuana. They don't want to be high. They don't want to damage their guts, their hearts. They don't want to mask symptoms. Cancer, PTSD, autoimmune disease, anxiety. I've seen it all. I have played therapist for 4.5 years and listened to these poor people who have found relief from full spectrum products. They are not getting high. They don't want to get high. When this law passed in October, our business went down and that stunk. But the customers that I had that came back after they went to a dispensary and said, oh, excuse me, hell no. Older customers that can't handle THC. This minimal amount that does not cause a psychoactive reaction for them is beneficial. If it's higher, much higher, and making them higher, it's not going to be beneficial. I've had customers who have gotten products at dispensaries who have fallen because the amount of THC is just too much, whereas they were managing their symptoms well with the federal amount allowable by the US Farm Bill in 2018, less than 0.3%. I am passionate about this because I have seen it. I have witnessed it. There was also discussion today about this has only been for 2 years that marijuana has been legalized. Folks, we've been selling CBD products, full spectrum CBD products for 6 years. We got 3 times as much time under our belts, and it's been successful, and it hasn't been a problem. So please reconsider. Thank you.
Thank you. Are there any questions?
Oh, right. We gotta get your question.
Yeah.
Sorry.
We're like, we're out.
Mic drop and then.
Please.
Yeah, and I'll ask some after. Senator Chicarella, and then I do have a few questions.
Just briefly. So when we were talking about the seltzer drinks that have the 5 milligrams of THC, the individual that was testifying said that would change someone's, state of mind, if you will. But the 0.5, which will be fine if it's under 0.5 for CBD products, won't change somebody or alter somebody's, physical ability. As you said, people are falling. So if you're still able to have hemp products or CBD products that are under 0.5, what's the problem with that?
So under 0.5 is nothing. We're talking about 1 milligram per serving. So the seltzer products with 5 milligram, we don't carry.
Right.
That's a different ball game.
And to add to that, we're talking more about month supplies, 3-month supplies. It's not about the individual serving. That seltzer that we did a little bit of our due diligence, they sell a seltzer that's technically 5 servings, but the whole container has 5 mgs and consumers are drinking the whole thing. What we're dealing with is in tinctures and month supplies or 100 count of gummies that are not psychoactive, even if you ate 50 of them. And that's when you add all those milligrams together, it will breach the 5 milligram threshold, but it's not because we're dealing with, high concentrate THC products.
Thank you for clarifying that.
You're welcome.
Now, how many states does your CBD store operate in?
So we're in over 30 states.
Okay. Are there other states that, I know there are states that have banned Delta 8, which and then I understand Virginia passed a law where they do have a ratio, but it's a 25-to-1 ratio. So are you operating in Virginia? And can you give us, if so, I know you probably owned a local franchise, so you may not
Correct.
be able to speak to that. but
Sure.
I was just wondering.
We do have some stores in Virginia, and I know what they did in Virginia was hard, was like passion really hard, just completely eliminated the possibility of full spectrum. But we do, some other states that we do operate in that works well is like a 10-to-1 ratio, or like there was 2 gentlemen here who were the farmers that recommended like a 20-to-1. Anything like that is a lot more feasible for us to be able to create a high quality product without the psychoactive properties and be efficient.
And how does the licensing work for your store now? Like, do you have a license with the state, or can you go through that?
So we're a franchise and we're a wellness center. It's not easy to open up these franchises. There's a lot of hours and hours and hours of of study, research, and education. As far as a license, we have our like normal licensing practices that you would to open any business. We're registered with the Department of Revenue. You know, we're paying all taxes, of course. But Connecticut doesn't have, like, let's just say, a specific hemp license that we would be able to, you know, which I think would be a really good idea to help tell the difference between like a wellness center like ourselves or a smoke shop down the street.
And, you know, in your testimony, you alluded to good actors and bad actors,
Right.
right? And unfortunately, sometimes, right, the bad actors ruin it for everyone. But I mean, I guess this is probably not something to answer now, but how can you propose regulations that can help us separate out the good actors from the bad actors? And that's, unfortunately, I think that's what's spoiling it now is the bad actors. So.
No, I understand that. I will say that, you know, working with SunMed, get SunMed your CBD store would be a good way for you to, you know, we've done self-regulation from the very beginning. I mean, we deal with the FDA. We make sure things are compliant or third-party tested. We spend $70,000 a month on just third-party lab reports with USDA agriculture or farmland. So when it comes to how to still take care of the good people versus like the good actors versus the bad, I think you should take a look at the franchise as a whole and maybe make certain exceptions for a franchise business model that will meet all your requirements that you present.
And I think we'd have to look more towards the testing requirements than necessarily a franchise, right? Or business organization, but so suggestions on testing and what you're doing would be appreciated. So.
Yeah, so we do third-party testing, seed to soil, soil to oil. We're going to test the plant for heavy metals, microbial. We're going to break down the cannabinoids parts per million because the FDA went to like 100 locations and they didn't have what they said they did or all. So that's important. We test for pesticides I couldn't spell or pronounce. But the big one is heavy metals. You got to know where you're growing your hemp because if it gets in the soil, it gets into the nutrients, it gets into the plant, and it's going to get you sick. And if you take a look at our testing policy and procedure, replicate that. Let us help you. Don't put us all out of business and bankrupt us. Put us to work. We would happily volunteer our time, effort, and energy to help do this the right way for the people doing the right thing.
And that was when I first started with the company 4.5 years ago, it was kind of the Wild West with CBD products where I'm, you know, it's always TJ Maxx and Marshalls and
Right.
everybody. And that's one of the things that we strongly tell our customers, and not even just our customers, but anybody that comes into the store just asking questions. If it doesn't have a third-party lab test, walk away.
Right.
Back, I know there were several studies done back when the stores first opened that, and I know I looked at a bunch of different ones, and it was anywhere between 30 something and 70 something % of a lot of products that were tested didn't have the amount of CBD in them that was touted on the labels. That's why that third-party test is important. And that third-party test also proves the amount of THC that's in the products. So and we have samples of lab reports right in our stores that we show customers. Scan this QR code, you will find how much of each cannabinoid is in here. And we educate our customers so that they are smart consumers.
Right.
And I think a lot of consumers are also not given the credit that they deserve. We have a lot of people that are skeptical when they walk in the door, you know, and a lot of people who, it was earlier discussed, I don't want any gummies because I had a gummy once before and that was a bad experience.
Right.
Not our gummies, totally different ball game. So it's important that we recognize that people are going to make, first off, their own choices, but majority of people are going to make educated and well thought out choices. When we carry broad spectrum products with no THC in them
At all.
And yes, those products sell well, but there's also a lot of customers that use those full spectrum products because that little bit of THC, even not psychoactive, is far more beneficial for them for their relaxation, for sleep, for pain, whatever it may be. And taking that off the table for them and then having to go to a dispensary where dispensaries are going to have much higher amounts of THC, and they're not going to get the benefits from those products.
Right.
I have questions about testing, but I know someone else is coming later and I'll ask them of Becky in the interest of time. So, but
Okay.
thank you guys very much for are there actually, MJ, are there any questions online?
No questions online.
Okay, thank you very much.
Hey, thank you so much, guys.
Okay, next. Benjamin Pomerantz.
Mr. Chairman, he is asked to not testify, so we can skip ahead.
Thank you. Kevin Callahan.
All right, good afternoon, Chair Maroney, distinguished members of the committee. My name is Kevin Callahan. I'm here today with StubHub, the world's leading ticket resale marketplace, testifying in support of Senate Bill 15. That's the all-in pricing legislation to require businesses to disclose the full cost of different goods and services upfront. I'm really only going to focus on the live ticketing portion of it. I do have written testimony, which you can look at as well. But really, when we look at Senate Bill 15, our own experience around all-in pricing is really formed our perspective on this issue. So back in 2014, we voluntarily began displaying all-in pricing to buyers in the hope that the approach would, one, appeal to consumers, really would drive business and help create a competitive advantage to differentiate StubHub and maybe even eventually draw the industry in to follow suit. Unfortunately, that really didn't happen. So what we saw was that our use of all-in pricing actually confused StubHub's buyers who assumed that the prices displayed did not include fees and would ultimately be more expensive than a lot of other competitors in the space. We saw business actually shift away from StubHub in a pretty unsustainable manner. And so for competitive reasons, we really had no choice but to revert back to the former form of pricing. So this experience has really driven our perspective that laws are needed in this space to implement all-in pricing equitably across the industry, to achieve transparency and eliminate consumer confusion. So really want to thank you for the opportunity to speak here today in support and really appreciate the leadership of the governor, the attorney general, and certainly the General Assembly as you're looking at all-in pricing. We want to be a partner and a resource to you as you continue to address this issue, and look forward to just helping out however we can. Thank you.
Representative Akron.
Thank you. And thank you for your testimony. It was interesting. So you came out and said, we're going to show you everybody what, here's what the ticket costs here. And they went over to Ticket Joe's, and Ticket Joe didn't put that on, right?
Right.
And so, oh, we're going to buy it here. But they also then got the additional fees added to those tickets, not knowing that there was going to be added. So when they get their bill, but they've already bought the ticket.
Yes, in some cases, or as you are looking at different prices or comparing across different platforms, our price would be higher because it was inclusive of the fees. And then comparing that, so obviously I'd go the cheaper route, but as you get through a checkout process, certainly the fees would be incorporated.
Rather than being shown up front,
right?
It's added on afterwards, and then you're still at the same price range.
Right.
Thank you. Thank you for your testimony. Thank you, Mr. Chair.
No, Representative Retigliano.
Hi, just a quick question. I really do appreciate you being in favor of this. It's a huge problem in the industry that we've been, you start the process of checking out, and by the time you're done, the tickets are, almost 20% higher than when you started. But I have one question just out of curiosity. So say you're reselling an NFL ticket, right? And now they have an authorized reseller now. It's not illegal anymore. But the team actually puts a fee on. They charge a fee. How would StubHub or any ticket network handle something like that, where it's the originator of the ticket that's charging the fee? It's not your fee, it's their fee.
Yeah, I'd have to double check on that, but I think is the way it's intended to work would be that those fees would be included. If you are purchasing on our platform, that all those fees would be upfront, or you'd see the price, and then as you are going through and checking out, there'd be an itemized listing of what those fees are, so that you're aware of, you know, where they came from.
All right, I'll leave it at one, and I appreciate you supporting it because I think that's a good consumer protection. I think it's a good consumer policy, so I appreciate it. Thank you.
Thank you.
Thank you. Are there any further questions? MJ, are there any questions online or?
No questions online.
Okay, great.
Thank you,
Thank
sir.
you very much for your testimony. Next, Kyle Wallace.
He went earlier.
You went,
So,
okay.
Yes, Mr. Chairman.
Carl Torello.
Yes, and he's going to be joined by Ben Zacks.
Okay. All right. Thank you very much. Please,
Thank you.
Please proceed.
Senator Maroney, Senator Ciccarella, Representative Ritigliano, and members of the General Law Committee. My name is Carl Torella, and I am co-founder of Butter Cannabis, a retail equity joint venture. Butter currently has locations in West Hartford, Danbury, soon to be Tolland, and 3 new locations in 2024. We appreciate the opportunity and to offer comments on HB 5150. First, we would like to offer support for the direction the committee has taken to address concerns with the shortage of cultivators under the existing Section 149 framework. As others, our operations have been challenged with a supply shortage, which is driving up prices and making it difficult to compete with surrounding states. The cannabis consumer is very sophisticated and loyal to certain strains and brands, and shortage can and does result in loss of customers looking for something specific to their needs. Given this, we agree that it is important to offer alternative paths towards those Section 149 cultivators who have been unable to get up and running under the provisional licenses. However, we urge the committee to consider A, moving up the date for the moratorium for granting provisional Section 149 cultivator licenses in Section 9 from December 2025 to December 2024, and B, to specifically require that a Section 149 applicant must have a final license prior to opening a separate equity joint venture. We understand there needs to be some time to assess conversion applications, but we believe significant time has passed for existing provisional license to determine whether they can make it work or need to pursue an alternative path. Time is of the essence as the market is already challenged due to delay. Further, it is imperative that we close off unintended loopholes. The intent of the 149 license was to build cultivation in the state, but we now see that Section 149 licenses are opening other verticals such as dispensaries without having operating cultivation facilities, and in some cases without even starting construction. Butter also would like to speak to an issue that's not in the bill, which is respectfully request the committee to consider. As an equity joint venture, we believe our social equity applicants are disadvantaged by being held to a 7-year moratorium on ownership transfers. 7 years is a long time in any industry, and we fear that this time frame can disincentivize certain social equity applicants who may prefer to be party to a change of ownership earlier in the process. We believe that this holding period should mirror the 3-year holding period required for the social equity lottery winners, and we ask that the committee consider adding this language into the legislation. And then also in my written testimony, I just wanted to state that I do agree with the DCP and their RP or in the pharmacist stance. So I'm not going to go into that, but we do agree with their testimony on that. So thank you for your time today, and I'll pass it over to Ben.
Hi, thank you. My name is Ben Zacks. I'm the Chief Operating Officer of Fine Fettle. Fine Fettle, we believe we are Connecticut's cannabis company. We had 3 medical dispensaries that are now hybrid. We have opened equity joint ventures. We've completed our social equity plan. We immediately, upon 5 days, as we attested to, paid $3 million for our cultivation facility. And we have worked and mentored and partnered with social equity operators across the state. And we do also agree with the direction of this bill, but believe that there are some key structural issues for the success of the market, creation of jobs and entrepreneurs, especially social equity entrepreneurs. And Connecticut's market is probably 30 to 35% less of what we expected. And the outputs and outcomes of new businesses have not come in part because of market conditions, in part because of the economy. And that's had a huge impact on jobs, revenue, and success. And so we agree with, by and large, what Carl said, and appreciate his letting me chime in with him. But two really key points that I want to hit on is the goal of the Section 149 was to build cultivation, and then later equity joint ventures were added. Folks are simply not building their grows. Some are even paying the $3 million, opening dispensaries, don't have space, don't have a location, doing nothing to push forward, and our market is strapped for supply, and they're exacerbating the issue, which is having huge issues on the market, and also sending people to Massachusetts and other states to purchase product at a much lower price and much more available. Additionally, we actually really like the opportunity for those who haven't been able to pay the $3 million to have different access into the market by partnering with hemp and or by paying a reduced fee and getting a micro cultivation. However, those should not be stepping stones to take advantage of what we believe is a gift. And so if folks do that option, we agree that they shouldn't get equity joint ventures. But also, if you're going to have a micro cultivation, you shouldn't be able to pay less, have a lower cost of entry to build, and then just be able to expand as the micro cultivators do. So we believe that if you do keep this approach to allow folks to step down to a micro, that their canopy limit is capped. We've had incredible success operationally, this industry. I'm really proud of all of our co-operators that we haven't had issues with traffic. We haven't had issues with legal product getting into hands. There haven't been more driving issues. We've created hundreds and hundreds of jobs across the state and tons of tax revenue and put that back into the town and then been good corporate citizens using our social equity plans, partnering with nonprofits and bolstering social equity entrepreneurs who have pushed into the market. And so we put in written language to change some of these pieces, and we have other pieces in our written testimony. But Carl and I, our teams and our companies and our groups, we are operators. We're doing this every single day, understanding the market and working across boundaries to ensure a success for safety, access, and patient care in the state using this really unbelievable plant. So thank you.
Thank you. Are there any questions?
Online, Mr. Chairman, we have Rep. Ali Brennan.
Okay, Rep. Ali Brennan.
Thank you, Mr. Chairman. And thank you, Carl. You spoke of your experience with medical patients and your concerns with the use of telehealth. I was just curious if you could elaborate more there, like why you still oppose this despite the fact that you have a hybrid facility yourself.
Sure. So I've been in cannabis for 7 years, and I chose cannabis to affect people and to really be on the ground to see what cannabis can do from the power of the plant. I used to operate 3 medical facilities. My second week on the job, I heard a cancer patient tell me, or a cancer patient told me that they had hope for the first time in 18 years, right? So those types of things happen day in and day out, and seeing how patients open up and interact to pharmacists from on-site experiences, from breaking down to something about their family, to understanding their kids, to really alleviating, to really being part of their journey, it is just going to be lost when that goes to telehealth. I mean, there's no such thing as a personal connection, and that is over Zoom or anything like that. So we are happy that the DCP took the stance of removing or stating that they would hope that the pharmacists keep on site. And even though that we do have a hybrid license coming on, and it's going to cost us more operational money, we really do think that the medical market needs it, and the preservation of the medical market is key to our business.
So I'll just chime in as well. So Fine Federal, we operated the 3 of the first 7 hybrid licenses. We employ 14 pharmacists across our stores. And one of the realities of adult use coming in is we have incredibly trustworthy team who focuses on inventory. And part of the touch with patients has been lost. And part of that is operational. And part of that is by need and demand and how many folks we can staff. I'm not sure what the right operation is, but the flexibility to ensure that there's access to the pharmacist is really, really important. And so while we're not necessarily exactly aligned here, we want to ensure that pharmacists are running our hybrid facilities, that they are always available to patients. And however we can make them most available, most actively and most on time is key. It can take time for our pharmacists to be available to the patients because of the change in operational flow. And so, while I'm not exactly sure how it would look, the most important thing is that Connecticut's program and Connecticut's operators get the best access to medical practitioners, because not only do our medical patients use the pharmacists, so do our adult use customers. 92% by the studies of people coming into our facilities are purchasing with a health and wellness benefit. And that's in our adult use customers as well. That's not just the medical patients, where 100% are. And so having optionality for the access to be quickly into a pharmacist, we think is really, really, really important, and is for the good of everyone who actually comes into our facilities. We have 3 hybrids now. We're opening a 4th in Bristol, and we want to ensure that that access is there to give unbelievable customer service, because at the end of the day, we're a customer service business, whether it's for patients or the general public above 21.
Thank you. I think it's important to highlight, what we heard earlier, as well as your testimony regarding that. And just one more question, Mr. Chair. Carl, I know you mentioned briefly in your opening statement that you talked about aligning the change of ownership holding period for EJVs with that of social equity lottery people. I just wanted to see if we could expand more on that. Just curious to hear more about that.
Sure. So there are 2 really key determining points on this, and one is at a macro level, right? 7 years is an eternity in any industry. I mean, and then in cannabis, it's even longer than eternity. So I've been in this business 8 years now in cannabis. I've seen multi-billion-dollar companies, hundreds of $1 million a company, and then your local mom and pop shops who are doing great, and then something happens in the market in year 2, year 3, where they're out of business. They weren't prepared, right? So I think it's doing a disservice to our social equity owners to really have that time frame in that respect, right? We want to shorten the time frame to make it in line with the social equity lotteries, right? You're doing a disservice to our social equity owners. And then secondarily, because of this unintended loophole, right, of the Section 149, we're seeing a huge saturation of retail, right? And a huge saturation of retail ultimately devalues the license holders of our facilities, right? The more competitors that are in the market, like any business, will devalue, but we're seeing that rapidly happen faster because of this unintended loophole with the Section 149 license.
Right. And if we're trying to build a program that can create generational wealth for social equity owners, generational wealth is not being created by a business that's taxed at 28% on gross margin, not on gross margin, right? Because we can't deduct anything at the federal level. And so if the non-social equity owner of the licenses or a business says, I'm going to sell, but oh, my social equity partner, you're left behind. And so you can't have the exit for a longer period. Who are you ultimately helping, especially as we've seen over time valuations move down in the industry, and that's been on the public stocks, that's been in private ownership. And 3 years we think is a reasonable time, because it allows for the social equity partner and the business to really get up and running, to understand, to get its feet, to see the market get someplace. But 7 years is really long. None of us know exactly where any industry is going to be in 7 years. I mean, in 3 years of this, with just 1 year of us being open, we're constantly adjusting and changing this bill. But we have seen what happens to the outcomes and valuations of these businesses over time. And for the opportunity to create wealth for these entrepreneurs, change and opportunity is key. And so that's why we think changing from the 7 to 3 to actually be at the same exact time as the grow licenses, the 149, which is 3. So it actually creates consistency between the 2 types. And especially since most of the equity joint ventures are retail, and it takes an incredibly long time for the grow to actually get up and running, people might be able to sell off their grow before even being operational. I mean, we're 18 months in, there's 1 outdoor grower open. Now, we're under construction. I have no idea about anyone else. But if you're going to hold that for another 5.5 years for folks, just on these EJVs, it's an incredibly long time, and it's detrimental to only the social equity owner and entrepreneur.
Thank you. I appreciate those comments. Appreciate you both testifying, and thank you, Mr. Chair. I yield back.
Thank you, Representative Brown.
Thank you, Mr. Chairman. I need help understanding the benefit to the social equity applicant from 7 years to 3 years, how does that benefit them specifically? Because in one instance, you have stability. 7 years, you have to work with me regardless. If you changed your mind, you don't like our partnership, you have to work with me for 7 years. Tell me the benefit to the social equity applicant by moving it to 3 years. You said maybe they decide that it's up to them to move over, and so they have that option?
So they can't. So conceivably, the non-social equity partner can sell their piece, and then the social equity partner ends up with a new partner, right? So if it's a 50-50 partnership and someone comes to me and says, Ben, I want to buy you. And we say, all right, great. I'll take the exit. But now the social equity partner can't. And now they're put in with a new partner who they didn't know. Our social equity partners, we've known for a minimum of 25 years. I mean, it's been in the newspaper. One was my babysitter, right? Growing up, like he's seen good and bad, right? A lot of bad. Elementary school, Ben. But but the truth, so like they're with me. And if the business though is still going and we don't get that option, the stability is actually still there from years 3 to 7. It just gives the optionality for before. It doesn't say, oh, you have to sell at 3. It gives the opportunity because we have no idea where this is going to be in 7 years. What if there's federal legalization that changes things and Coca-Cola wants to come in and do something differently, or the pharmaceutical companies and they're still stuck? Or what if opportunities change? And so it gives the flexibility for chance and choice for the social equity partners, just like anyone else, right? Versus holding them to a special credential that may be better in 7 years, as you note, but may be worse. And so it gives the level of optionality.
And I think I agree with that in terms of giving them that option. How often would you imagine a social equity applicant terminating their partnership if we said 3 years was the rule? After 3 years, they terminate. Where are they going to go? How many options, how many available opportunities for them are there going to be? Who's going to be left without a social equity applicant that they can go to?
So they're still on the cap table, right? Because the structure of ownership per the licensing phase is that they own on EJVs 50% and on Section 149s, which is 3 years, at least 65%. And so their space in the business via an operating agreement is still held, right? So it's not like saying, oh, you're out, because right, that's corporate law. And so you know, it's not like your partner and it's somebody's job and, oh, you have to keep this job and then you're gone. It's really on the ownership cap table side where, you know, everyone gets to make their level of decision based on their own ownership. And so that's why we think the change is there. And look, maybe someone says, you know what, I don't want to sell. I love being a part of this. I want to be in it. So if we sell and they find the right agreement with their new partner, they can choose to do either or versus be stuck with somebody, or, you know, maybe they stay in and there's an opportunity for distribution and they keep a job and it works. And, you know, because it's about choice ultimately and optionality versus forced to stay in, because I don't believe there is a force out from the cap table.
Got it. Thank you.
Yeah.
Yeah, thank you very much, Representative Brown. I've been struggling with this one as well. I think for me, it makes sense to align the length, right? If they're both at 3 years, and that to me is the stronger argument. Like, because, you know, with efficient markets, if you know a price is going to go down in 7 years, then it goes down what you're going to pay now, right?
And
So that's why I didn't know if it necessarily would increase the value to them, but I think that aligning the length and increasing options, I guess, too, in case your choice is to leave.
Right. And also from the 149s, right? So because we have a 149 with our partners and we'll then have equity joint ventures with them. And that's vertical, right? And so the vertical benefit is strong from a tax perspective because you can deduct all of your costs of goods sold from a grow. And so there's economic alignment by being vertical, right? And it only comes from the grow. But in that case, if someone wants to come in and buy the full vertical, the social equity applicant could sell their piece in the grow 149, but they actually couldn't sell the piece in the equity joint ventures that are attached to that grow. And there is language within this bill to fix that. Personally, our partners have been honestly the poster child of that law going wrong because of how we structured it, and they had to give up ownership of entities that they had been licensed on. And so we hope that that gets fixed. But in this case, right, like there's literally an alignment of the same ownership in the same business that they could sell one piece and not the other. And so we think the timelines being together is good. What we don't think is that it should be too quick, because then you create sort of the California issue, which was there were folks who were poster children and said, yep, I qualify and then I'm out. But this creates some longevity being a part of it, and then optionality with alignment on times.
And just to add to that, we're purely retail. Ben's going to be vertical, right? So from a retail cannabis standpoint, almost every single market will play out that the valuations will go down over time, right? So giving that option and that choice for that shorter time frame for the social equity owner will allow them the opportunity to choose whether they want to capitalize on that higher valuation at that point in time. And that's all our social equity owners are asking, is for really that choice and that optionality. And the intent is to give them control of the business, but this really does the opposite, right? So making sure that it's not just us that get to choose when we want to exit, but do it as a family, right? Our goal is to create this partnership, right? And decide with them, alongside them, that this is either right for them or wrong for them, and be there with them every step of the way.
Thank you. Rep.
I just want to follow up on that 7 years, which I understand where you're coming from. It makes some sense. The reason that provision was put in there was actually protect the social equity applicant from being bought out, right?
Sure.
So what you're telling me, if I understand correctly, is if you decide to sell, they still need to stay within that venture.
Correct. As of now, right? There's no restriction on timelines of sale, and but there is for the social equity partner, but not for the non-social equity entity. And just looking at Connecticut's cannabis space,
right,
of the 18 medical operators and of the 4 original producers, only 3 are not the original license winners. So of the 22 original businesses, 19 have changed hands, including 2 of Fine Federal's. We bought them from other license winners. One of ours, we won an application in Willimantic, and then the folks in Torrington, and then the guys in New Haven. But everyone else has changed hands because of timelines of market. And so it's sort of part of the realities of our upcoming industry, or up and coming industry, that we don't know where things go and how things happen. And, look, sometimes the opportunity to get the bag is too good. And so people, we want people to be able to do that.
Thank you for that.
Yeah.
Representative Acker.
The more you guys talk, the more questions come to mind. So it's good. So being a business owner myself, I can understand some structure on this. So you have a partner, right? And the 2 of you are partners. Can the social equity partner buy out the investor side after 3 years and be the sole owner?
Conceivably, they can do it right now.
Sure,
Right.
conceivably they could do it right now. Yeah.
Yeah, because we have we can sell whenever, right? As the non-social equity owner, the social equity owner has to hold for that period of time. So conceivably, if they had the capital at a right valuation to buy us out, we agreed to it, that sale could happen, and they could be 100% owner of the business.
Now flip that.
Yep, that cannot happen until
After 3 years, can you
7 with the social equity joint ventures.
with your change?
Yes, 3.
With your change, after 3 years, can you become the sole owner?
Again, it would be the same type of deal. We would have to come to a fair market value of the business. They would have to agree to the sale. It's not a forced sale. They would have to agree to the sale. And then obviously, like any other business owner, they have the chance to create that generational wealth for them if that's what they choose to do so, right? So that's kind of how it would be.
So a social equity partner doesn't have to be a partner after that point.
They do not have to be a partner, but it would have to be a sale that was agreed upon like any other business.
Right. As of now, they have to be a social equity partner no matter what with any other partner or by themselves. Some social equity partners don't have ours are equity joint ventures. So they're based from other businesses. And so there generally are partnerships, but yeah, they have to for 7 years, no matter what, stay in it as of right now.
As of now.
As of now.
Thank you. Thank you both.
You're welcome.
Can I follow up?
Representative Candela.
Just a clarification. You mentioned something that caught my attention was, if we, let's say this stays at the 7 years, you decide to sell, you still have to get the approval of the joint equity partner, correct?
No,
You can just sell?
we could sell
without their
our, we could
consent
sell,
because it's 50-50.
we could
isn't
sell
it?
our piece. So we could sell our equity in the
So
business.
the cultivation you can sell,
in-
but not the joint venture.
So as of now, we could sell any of it. We could sell the piece of the equity in our ownership in the grow. We could sell our ownership in the EJVs. We could sell our ownership in our medical dispensaries. The social equity partners cannot. So we could sell to them. We could sell to, insert business
So just
here,
for
but they can't.
clarification, isn't the EJV 50-50 owned?
Correct.
So wouldn't you need the equity applicants?
No, because they could buy
Or-
our shares in the business. So let's just assume there's 100 shares. We own 50 and our social
they'll
equity
buy the
partners own
shares, okay,
50.
gotcha.
Someone could buy our 50, but not
you
their
you don't
50.
need the joint ventures
No.
approval on that.
No.
Okay, thank you.
But being a good partner, we did, we
Ju-
would
just-
offer
just to-
them
Just to
first.
clarify, I mean, just to reset everybody for a second here, though, because this is the subject of a long debate for years and years. And there was a lot of thought given to how long the social equity partners had to retain their ownership interest. And there were other concerns. I appreciate the sort of, cursory concern of, okay, well, it's fungible, they should be able to do what they want with it. But there were a lot of anonymity concerns about, okay, if we let them sell within a year, they're going to get bought out and then we're going to lose the entire social equity population. So I appreciate what you guys are saying, but I think, no offense, I think we need to hear from Social Equity Council and social equity partners directly, not a couple
No,
of rich white guys.
And honestly, we
yeah.
agree. Look, we
Yeah.
agree.
But again, I just want to reset everybody on this discussion here because I appreciate the sort of,
And
the
all-
reaction to it is, and
All of our social equity owners have signed off on this and they were put written testimony.
yeah,
in it too, just so they can
I'm sure
see.
they have.
Ours as well.
I'm sure they have because believe me, we thought about that, and the reason that was in there was because we knew there would be dollar signs thrown in front of social equity applicants to give us your name, we'll pay you a lot of money in a year, and you'll be out. So there was a lot of thought given to why we were preventing the sale of those licenses on the social equity side when we passed this bill. And I for one, am not willing to unwind that 2 years into a program.
So just out of curiosity, why was the 149 a disconnect with those social equity applicants?
Especially since the 149s are
Again-
open.
Again, there's a lot of compromise that had to be done to get this bill passed. And
Okay.
when you start pulling on one thread, you unwind the entire structure that got this together. Okay?
Mhm.
So I appreciate that you guys let's get this market going. I mean, we all want to get this market going, but we can't do that by changing the foundation that it was built on literally 2 years into a program. Other questions from committee members? Yeah.
Point of clarification,
yeah.
if I could. Just thank you, Mr. Chair. Just so I understand, and I get the historical context behind how we got this bill passed, but am I to understand that any person who originally signed up as a social equity applicant had the social equity partner? It's 7 years. If you decided to buy them out, you could be the sole owner of this industry, because that's what we're going to see. I just want to make that very, very clear. That's what's going to happen. The moment we allow people not of color to take over this industry, that's where we're going to run into this problem, because that's what we tried to solve a problem. And we're now creating another one, which is the equity that we thought we were going to get is somehow about to be eroded, not after 7 years, but potentially 3 years. And if the market is going to turn in 4 years after this 3-year deadline, that benefits you all. Your valuation to your applicant devalues, not. So it would be in your best interest if the market goes in the way you think it is to allow that person to stay for 7 years, right? Because their valuation could go down, was what you guys said. It was to make the best benefit to the applicant. It may be better for them to sell in 3 because the market's going to be good in 3, but maybe not in 7.
Maybe.
Potentially.
Maybe. And so
100%. So what I don't want to see, and this is what we all thought was going to happen with this industry, was that everyone's going to partner up with the closest person they can find, partner with them, and then eventually in a year, 2 years, here's a check. And to a partner, someone who's struggling, who's been through what they've been through, when you write them a check like that, they're going to say yes. And that's the problem. I've had a concern with it 7 years from the very beginning. I felt like my concerns were alleviated, but I think it's gotten worse a little bit because this is not going to be equitable in 7 years. I can promise you that. If we lose half of our ownership, which we will in 7 or 3, it's not going to be equitable anymore.
So I guess the question is, right, no one has to take the option, right? And so the question is, if somebody thinks that 3 years is the better option for them or 7 years is the better option for them, their operating agreement should give them the opportunity to make that choice, right? And our question is where do they get the opportunity for choice versus forced held ownership? And I don't know the right answer exactly, but generally the argument of choice versus being stuck is sort of what I think folks want to understand, because if you know where you stand in 3 years and you might not know where the industry is in 4 years, right? Sometimes, one in the hand is better than two in the bush, or one in the hand might be better than 0.2 4 years later, but you don't actually know either way. And so it's the question of choice versus enforced action on timelines when others are not held to those timelines. And I don't know the right answer. Yeah. But I think that's a real concern and not the goals of, I think that's a real concern. And this industry, and Carl and I saying this, right? But this industry should be diverse. And this industry has a long history of problems around Black and brown communities and the goals and communities that have been impacted more by the war on drugs. That's why we're placing businesses in disproportionate impact areas. That's why we have social equity plans. That's why we partner with social equity partners, and we can look at it at the full framework. And look, I don't envy you for trying to build something that you don't know what it's going to be in 3 or 7 years. But the goals should be opportunity. The goals should be opportunity, and every other business owner gets that choice.
And just to go on the record, Butter is co-founded by Derek Gibbs. He couldn't be here today because he just had a child 4 days ago, or a week ago now, whatever it may be. So he has a new daughter. He is a person of color. We found this together, and we're looking out for the community and want to do it the right way. We're all for social equity and making sure that's done the right way. We're here to, like Ben said, fight for them, to give them the choice and ultimately allow them that optionality. And they're all in agreement with that.
Okay. All right. Having no further questions, thank you very much.
Thanks.
Thank you all. Have a good one.
Thank you.
All right. Next, Bruce Morris. Former Representative Morris.
Good evening. Should have known this. I got to press the button first, right? Good evening, Co-Chairs Maroney, D'Agostino, members of the committee. It is my privilege and my honor to be before you today after so many years. As many of you know, my name is Bruce Morris. I'm the Director of Government Affairs for Ticket Network. And I'm here today to discuss Senate Bill 0015, which we support with some important clarification about just one issue. Ticket Network is a technology company and ticket resale marketplace based in Connecticut, serving consumers engaged in buying and selling of tickets to events in the state of Connecticut and across the country and globe. We've submitted a written testimony, so I won't go through a lot of this, and I'll get to the meat of what we'd like to discuss. Although I would say that Connecticut is the most forward-thinking in terms of ticket legislation. As I go around the entire country and you take a look at the bill that this committee passed in 2017, dealing with ticket transferability, And then bolstering that last year with all-in pricing, you've set the proper floor to make certain that consumers are really protected. You've sustained a marketplace where true competition can continue to exist. This year, the bill that's come forward, though, however, in a right spirit of trying to make certain that we've got language that allows all-in pricing and transparency. And Ticket Network, we believe fully in transparency that at all levels, whether it's primary or secondary, that is in the best interest of consumers. But in so doing, the language as currently proposed specifically talks about, and let me just find my piece real quickly. As currently proposed, SB 15 would impact practices common as venue publishing a range of face value prices before tickets go on sale. Would be effectively impossible due to the dynamic nature of ticket pricing on both the primary and secondary platforms. And it's actually that language where this time around saying as first advertised. It is understood with federal legislation and everything else is going forward that what you really want to do, and it's done in normally is intent, but this could possibly be misconstrued the wrong way, that you want to make certain that from the time a consumer enters the procurement process, that first time they see a price, whatever is listed, and that's what your current statute says, that price is all in. It reflects every charge that you would ever have, except for the fees associated with how the ticket might actually get transferred. With that, I won't continue to go on, but that's the real meat of what we'd like you to just take a look at, because current statute would, as you already have it, protects that. If you go beyond it and do an advertisements, you're going to have problems with your venues and everywhere else. This was a problem in Canada, in fact, where prices were listed in advance because they've got all-in pricing. All right, and because of dynamic pricing and things changing, it's really at the point when you get to the website, you had some consumers were complaining, gee, I can't actually buy the ticket for what was advertised. You need to stay with the procurement process. Any questions, Mr. Chairman or committee?
No, thank you very much. And did you send us some suggested
Yes,
language? Is that in your submitted testimony?
Yes, we actually did in the last paragraph. We submitted it, but I'm glad I contact you afterwards and give some more detail in that submitted language. I could have elaborated on other suggestions that are really good for transparency. In fact, if anything, I would remind you of legislation last year that was submitted on SB 392 and look at our testimony. A lot of the testimony was given then. There are a number of things currently going on in the country that go beyond junk fees, that deal with data privacy, delivery of tickets, anti-bots, that we would gladly work with this committee to help put together a comprehensive piece that will actually continue to let Connecticut be the model it is. I can tell you, I'm very proud every time I talk. I was just in Maryland last week, and then even in Maryland, they were talking about the Connecticut's law about all-in pricing. Connecticut and New York ahead of the curve, no matter where I go. So you're doing a phenomenal job, and we appreciate it.
Thank you. Are there any questions? Representative Retigliano.
Thank you, Mr. Chairman. Good to see you, Representative.
Good to see you, Representative.
Real quick, because I've listened to every word you said, but I have to admit that I didn't get a chance to read the testimony. You're saying our intent was to have fee disclosure. You're saying that there's an algorithm or whatever, the dynamic ticket price is a fancy way to say that they go up and down depending on demand.
Oh, yes. So that certainly happens.
Right.
Ticketmaster, many based on the demand, the price of tickets go up.
But does our bill, as currently written, just focus on the fees, not so much the fluctuation of the price?
What I'm saying, the challenge here is that dynamic pricing is going to happen. And it's the when and the how that the bill comes in. If you're saying the when is anytime a ticket is advertised, you must have all-in pricing. If you do that effectively, in January, someone's put something in a newspaper, you're going to go to Taylor Swift's concert, the all-in, and they gave you the all-in price is $52. Of course, they went for a lot more than that. All right. The person that comes to actually go buy the ticket, they had that advertisement, but they go to buy the ticket 4 or 5 months later. The price on that online price ticket has changed, but this person is saying, I'm procured it based on this advertisement that I bought at this point in time.
Would the fees be the same? I understand what you're saying, and I guess this is my question. If that $50 ticket had $10 with fees and you advertise it, okay, when it gets to $75 or $100, are the fees still $10? I think the intent of the bill is just for you to disclose the fee, and I don't know if it interrupts with the dynamic pricing. So if it does, I guess that's the base of my question.
I was just a little unclear the last part of what you
Okay.
said.
If the ticket's $50 in January and $100 in June, is the fee still the same? I think what we're trying to do is let the consumers know what the fee is before they even get involved in the process. Because a lot of times in the bill that we did, the bill that you say is the model for everywhere else is, a lot of times you put the bill in your cart and by the time you got done, all of a sudden you're 20-30% higher than when you started. So I guess what the governor is trying to do and what we would support, I'm speaking for myself and others, is that the disclosure of the fee, but not really so much your pricing model on the ticket.
Oh, so I guess we're saying the same thing in a different way. Okay. All right. So what I'm saying is, if you do it, as long as you're saying it's at the time you're going to that website, because you've got to disclose all the fees, no matter what. Per your current statute, you have, and we support that. It doesn't matter to me whether that ticket sold for $50 4 months ago. If it sells for $100 now, you're still going to have to disclose the full fee. And what works well, because it allows real competition between the primary and secondary market. Because what people don't talk about often, we talk about the extreme cases of the Taylor Swift, but in reality, 40% of tickets are sold for less than face value on the secondary market. So we prefer always being in a market where, yes, where as soon as you go open up that page, the prices that you see tickets listed, and that's your current law. That's what you did last year. The price you currently see, that's the full price, and it cannot change anytime during the procurement process.
Meaning while you're online ready to buy.
That's right. And here's why that's important to dynamic pricing. Because for dynamic pricing is what happens when you went to go buy the ticket at 8 o'clock, but at 8:05, someone else got in online and that price of that ticket was different. Right. Because it went up based on the demand. So if you're the consumer, all I want to know is, I open up the Ticket Network, Ticketmaster, whoever it is, take a look at it, I see the seat maps. Before I make a commitment, I'm able to see, yep, these tickets over here, $70, these are $80. I can go look on SeatGeeks. These tickets here are 80, these are 90. And I know that's a full price. That price cannot change as long as I'm online with them. And now I can do real comparison shopping. That works that allows real competition, allows the proper disclosure and transparency for consumers.
Okay. I think I understand what you're saying. We're probably on the same page.
Yeah, we are. Okay. In fact, sometimes I have actually argued that knowing the detail behind how that final price was derived is not as important as just knowing that the total price you told me up front is the total price I pay in the end. Because it's the upfront price. Think of when you go to buy a car or something, all you want to, you're looking at price tags. Yeah. And if you know that this Cadillac was $10,000 and that one's $11,000, you're going to make an educated.
Yeah, well, that's before they got you with the warranty and everything else. So what specific language in this bill interrupts that process?
The language when we say that first it's line 41. I believe it's line 41. Yeah, no person doing business in the state shall advertise, display, or offer any price. When you just leave it that broad, it's not giving you the when. And what I'm saying, the when needs to be the language based on your current statute that says, which is similar to New York's. It shall be displayed in the ticket listing. Shall be displayed in the ticket listing prior to the ticket being selected for purchase.
I appreciate your thoughtful answers. It's really lovely to see you, sir, and thank you.
Thank you.
And so, you know how the building works. This came down from on high. So have you spoken to the governor's office about these changes to the bill that you want us to make to the governor's bill?
No, I haven't done that yet, but that is fully our intention.
Yeah, I think I'd prefer that you have that discussion.
Oh, no,
with his
definitely.
staff.
Quite frankly, I intend to have that discussion, and we'll slide in a few of the other things that really, seriously, Connecticut is the best. And we'd be glad to kind of share with the governor's office all the other legislation that is happening around the country, and some of it that looks like it's pretty imminent, close to happening, so that we can continue to stay on the cutting edge.
Yeah. And federally as well. I think you've got some bills out there.
Federally as well.
Okay.
But certainly I would definitely have this because
Yeah, if you wouldn't mind.
Yeah, this would be
having this
problematic.
discussion with the governor.
The governor would
staff.
find, and I'm sure before this actually would get passed, that you would have these smaller venues and all coming out to say, this is a problem, this doesn't work. It won't work for our box offices. It's just that slight change, and the possibility could be misconstrued. Otherwise, both you as chairman would have to spend a lot of time on the floor when you bring the bill out, making certain that legislative intent was such that people understand that it's when you actually go to the purchasing
Dave and I are pretty
process.
good at that in the house. Great, thank you. We'd appreciate you doing that. Let us know how those conversations go, and we'll look forward to probably a ticket year next year, I would imagine. So thanks.
Will
Appreciate it.
do. Thank you all.
Duncan Markovich.
Good afternoon, esteemed members of the General Law Committee. My name is Duncan Markovich, founder and owner of Better Ways LLC, a small cannabis therapeutics business rooted in the heart of Brantford and Connecticut's shoreline since 2019. For our commitment to education, safety, product efficacy, and affordability, and our overall love and defense of the cannabis plant, Better Ways has been awarded first place for Connecticut's Best on the Shoreline hemp and CBD store for the last 4 years after that category's creation. I personally have well over 15 years of experience with this plant and community. I'm here today testifying against the current version of HB 5150 as a Connecticut native, small cannabis business owner, Shoreline Chamber of Commerce member, Connecticut Canna Warrior, Connecticut Cannabis Small Business Alliance member, and an overall concerned citizen for the cannabis industry unfolding here. I'd like to remind the committee that just a few short years ago, our governor ran his campaign platform to empower the Connecticut farmer with the advent of this emerging hemp industry. It doesn't make much sense to have the very government then license us to create our sector in this cannabis space, to then legislatively shutter it, and for all intents and purposes, hand it over to people who didn't create it. Where's the free market capitalism? Why should my trusted business, knowledge, passion, patient experience, and non-intoxicating federally legally compliant products now only be limited to a dispensary? With that option, what's your promise that all existing hemp and CBD businesses and our products get equitably onboarded to dispensary shelves, when that seems to be a limited option that you're offering right now? That question was relatively rhetorical. This is a really bad look and rather presumptuous that leaves many continuing to feel under-supported by our state, including our patients. I stand strongly behind my colleague's suggestion of a 20-to-1 THC to CBD ratio for all spectrum naturally derived hemp products, supporting the entourage effect. I strongly stand behind issuing more micro-cultivation and dispensary licenses. Existing safe hemp and CBD operators like myself should get inspected and also provided some pathway of licensing so that the state and the public can identify us as trusted sourcing, unlike bad actors and their locations. I also support existing hemp cultivation locations to be offered to social equity licensees so that we can rapidly reverse the supply chain issues that our state is currently facing. I have a lot of recommendations. Many I've emailed to all of you, but we simply don't have the time to go over them today. Much of the solution for these obstacles lies in my theme for today's testimony, which circles back to the underpinnings of community, which is the very cornerstone and focal point of any effective legislator's pursuit. Just this morning, alongside Senator Cohen, we were at the Shoreline Breakfast, where small businesses are considered to be the very fabric of community. I urge all of you to reconsider the proponents within this bill that will shutter Connecticut's hemp industry. Please truly think long and hard for how your legacies will be remembered with your decisions during this short session. I know what the real legacy will tell because the rest of our state and our country is watching earnestly. Please do the right thing and support your local statespeople. We've built one side of this industry. As you've all identified today, there are many, many components. We have every right to stay here.
Thank you. Hold on, let's see if there's any questions for you.
Yes.
Questions from committee members? Anybody online, MJ?
None online, Mr. Chairman.
All right, thank you. Thank you. Continue to send us the stuff that you send as well. We appreciate the emails. MJ?
Next up, we're gonna have Rebecca Ghosh.
Good afternoon, guys. Esteemed members of General Law, thank you for affording me the opportunity to speak with you today. I'm representing my testimony as well as the other members of the Connecticut Hemp Industry Association at this time. So they allowed me to move from 79 to this position, so I'm very grateful. So I would like to first extend my gratitude for continuing to keep hemp in the discussion as far as cultivation of cannabis in the state. It's something that we're all passionate about, and we continue to trying to carve out a space for the hemp farmers to participate in the legal use market. You have my written testimony, so I just want to briefly reiterate something that we've talked about, which is it really has to be at the micro cultivation level to really take advantage of the opportunities that the hemp farmers offer. So we are small scale farmers. There's a select few large scale cultivators, but the pairing of the hemp farmer with the adult use space is really at the micro cultivator level. And it's imperative that you understand that the licensing fee should reflect the canopy space offered by the microcultivation license. It's my opinion, it's my honest opinion that it's still too high and is not offering true social equity at that price point. It'll be very challenging to create a robust, profitable business with that point of entry. And the way the way I read the bill, and I might be misreading it, is that there's no path for license ownership for the hemp farmer in the way it's structured. It's more of a rental agreement, if you will, for layman's terms. And I'm only speaking to that at this meeting because I've heard discussion in the halls today, wondering why the hemp farmers wouldn't be responsible for the licensing fee. And so to address that, I'd just like to say that in the operating agreement, there may be ownership terms for a small percentage of the licensing fee, but I believe it's my understanding that the social equity licenses wouldn't afford for us to become majority owners in any way, shape, or form. So I would like to see some language in an ideal world where there was a path to a cultivation license for hemp farmers. I don't see that happening in this short session. But I do appreciate the opportunity for the social equity applicants and the hemp farmership to create a partnership. And feel free to email or address any questions that you might have with that. Now,
Do you have a suggestion on the fee structure that you would?
I really liked what we talked about last year, which is that $12 a square foot, and that $12 a square foot stems from the price point for the cultivator license at $3 million. So and somebody suggested earlier in their testimony that perhaps the hemp farmer and social equity applicants have a cap. It's not an expandable license. If that's the case, then it's really critical that you use that model of $12 a square foot or something equitable and proportional to the amount of cannabis that would be able to be cultivated at the facility. Just makes sense. It's not to me.
Sorry, I cut you off there. You were gonna go on, you had something else you were gonna say.
Well, I just wanted to, I just can't not sit here before you today and talk about the product side of things. You've heard a lot of testimony on it today, so I don't want to necessarily talk about, you have my written testimony and feel free to refer to it. But what I do want to do is sit before you as a farmer, a mother of 2 children, a small business owner in the state of Connecticut, who's also 8 years sober and does not use any intoxicating products. CBD got me sober and maintained my sobriety. And it's very personal to me that people who do not want to go to a dispensary, I would never go to a dispensary. I've visited hemp farms in Colorado. I've been to Vermont. I go to Massachusetts all the time. I would never step foot in a dispensary. To be clear, to your point, I would not risk having intoxicating products in my space. I create CBD products with that in mind always. I make my tinctures. Last year was the first year I made tinctures because they have ethanol in them, and I'm not going to go have alcohol in my shop. So I want you to understand that partnering with dispensaries, I understand I've never heard it so clear as I've heard it today, that that is the path for us to stay in business as far as this leadership is concerned. I respect that. I respect in turn that you offer us a pathway that's comfortable for the regulatory framework of the state of Connecticut to stay in business, make my products with integrity, and continue to support my community as a local community herbalist. I grow plant medicine that's non-intoxicating, and it's very personal. And I want to be able to share this with my community. I have helped in the town of Killingworth 6 local residents quit heroin and opioids. 6 mid-aged residents of my town who obviously for every reason under the face of the sun want to stay anonymous with my CBD. And when I help them, they need a lot of CBD. I have to serve them 2,000 milligrams, and they take that bottle like you wouldn't take normally. So I just need you to understand, and I think you do, and I know I've formed relationships with many of you on this committee, and I know you understand where I'm coming from. And I know I have to believe in my heart that you don't want to force me out of business. So I urge us in this short session to be creative, be collaborative, and have a dynamic conversation about how I can continue to exist. Because I'm going to say it here for the record, as I've said to everybody, I am going to continue to work with my community with plant medicine, whether these laws are passed or not. So you will make me an illegal operator in the state of Connecticut. So
Just going back to the first part of your testimony on the acre, you've given us this before, but the numbers, how many hemp farmers, how much the total acreage available?
I'd like to get you an accurate number
Yeah.
from the Department of Ag, please. So the number of acreage that's available is very different than the number of people with greenhouse infrastructure in place to accommodate that. So if you would trust me enough to get back to you
Yeah,
with
that'd be
something
great.
that's accurate, I
Thank
would
you.
do that.
Yeah. That'd be very helpful.
Yeah. And then I think Senator Maroney, you had some questions about our hemp testing and licensing,
Yeah.
perhaps?
I was going to ask some questions about the testing and going back to the licensing. I think we are flexible in the pricing. It's just, I think that the $12 per square foot number, that assumes that everyone went to the 250,000, right, to get
Right.
3 million. And I think it's an average of more 50,000 than it is the 250, although they do have that option. So that being said, we're flexible in the number. I don't know if 12 is the right number.
Understood.
You know, like, so, but I do have questions on the testing requirements.
Mm-hmm.
And so how are your products tested now? What are the requirements you go through in order to bring something to the market?
So just to be clear, so our hemp is tested through the Department of Agriculture. The plants that we grow and that are deemed federally legal at the 0.3% THC on a dry weight basis are tested by the Department of Agriculture. They come to our sites, as my colleagues at CBG Gurus explained. They come to our sites, they collect the plant material when it's wet. they put it in a bag and they combine it all together. So they'll take multiple samples from my from my plot, and ensure that the entire harvest averages at a federally legal level. From there, I'm allowed to harvest it. If I'm above the threshold of the 0.3%, I have to destroy my crop. So we aren't allowed to harvest anything that's not compliant with the federal USDA hemp laws that we operate under in the state. And then from that point, once I harvest the hemp, it's the onus is on me to and my integrity to move forward down the path to the consumer. So from there, we dry the plants, and typically after post drying, you remove the trim leaves. And so you're left with the actual cannabis that's consumed in smoking form. And that's where you'll see the percent of both CBD and THC maybe go up a little bit, because you're removing some of the material that doesn't have as much of either cannabinoid. So our smokable products, I test again before I sell either flower or joints. So that way the COA that I give my customers is what they're consuming. That wasn't always the case, and it's not a requirement. I choose to do that, and I think most of the colleagues I know choose to do that too, because it only benefits us. CBD is not at a high percentage in these plants without really good genetics. So we want to be able to show our customers that it's not 12% CBD. We want to show them that it's 18% CBD. So I think most people in the industry will do that testing there. And then from there, we make products. So I blend that flower in with other herbs and make herbal teas. That's my primary product line. So I don't do any additional testing because I'm still using just the flower. However, I have sent my flower to an extractor, my colleague Mike Goodenough, and he has provided me with distillate. Now, keep in mind, my business is so small that was now 18 months ago. 1 liter of distillate has lasted me this long. So I've had that liter of distillate tested. I know the math. I have a former degree. I'm a scientist by training. Before this farming adventure, I was a molecular biologist. So in my workspace, I then dilute that distillate that's been tested into products. And for the products that I sell that are medicinal, that are potent, I then send that out for an independent third-party testing. So theoretically, I have had my plants tested by Department of Agriculture. I have performed a post-drying test at my own expense through a third-party lab. I have then tested through a third-party independent labs, as CBD Store was suggesting, my distillate, my primary starting material. And then I have a 4th test that goes on my products that are delivered to the customer. And that, I will say, is how our industry operates. Those are the good actors. So we've paid for three testings across the products. Now, people who make edibles, I don't. People who make edibles definitely have another test on the edibles directly, because to sell them, we all use QR codes as well. So you want the customers to be able to take the QR code and go straight to that independent test.
Is there a certification process? You mentioned third-party testing for those third-party laboratories that are doing the testing.
We use we have been fortunate enough to have affordable access to out-of-state labs. So I think that has changed perhaps under last year's law. I would strongly urge you not to restrict any testing. People want to test, and I can test for in the $50 to $100 range. I can test a lot. If you force us to go to in-state testing only, those tests are going to be cost prohibitive. People won't do them. You should give us as much flexibility as possible on the testing end, because then I can send out 15 samples to get tested versus just 1. And I urge you not to restrict anybody who wants to test to be able to test out of state. I really do.
Is there some means, though, of validating the testing, right? Like of knowing the
These
quality?
are certified labs. These are certified.
That was my
These
question.
are
Yeah, what are they
industry
certified?
standard certified labs, absolutely.
Yeah.
And they offer a menu, so you can test for mold, you can test for heavy metals. There's a menu of testing, so you can do a full panel test, or you can do a quick and dirty $35 how much THC is in this test. It tells you all the cannabinoids. Do you know? Yeah.
Now, your products, do you typically sell them on your farm or are you selling?
I only sell through my retail outlet. I can't afford, what I think what's also being missed here is we're small businesses. There's no way I could afford the expense of selling at the wholesale price point to a dispensary. That's not in my, that doesn't work for me price wise. Without, it just doesn't work. And not to mention, I know I just was kind of passionate before, but truly, my customers, myself, my business are my core ethos, my actual values that keep me doing this at a loss every year is because of my community and my access with my community and my interactions with my community. I have an 82-year-old woman. She's one of my best customers. She comes to me because she doesn't want to go to a dispensary because the first time she went, she received product that had her call the ambulance because she was scared of how high she got. And I need to stay there for my community, and I will.
My understanding is there's approximately 24 hemp farmers,
Totally.
give or take in the state.
That's
How
accurate.
many of them are selling to dispensaries? How many just sell like you do on their own retail store?
So to my knowledge, the only people, I think Sweet Heel, Mike Goodenough, my colleague who you'll hear from later, I believe he used to be in dispensaries and wasn't able to, and I'm not, let him tell his story. And the CBG gurus evidently tried. I don't know anybody selling hemp products in dispensaries myself. My number would say 0.
So the majority of you sell from a retail store on your own.
Yeah, or at farmers markets, in particular, or maybe your local health food store, Edge of the Woods in New Haven, if you know them. Yeah. And also, and I don't want to villainize and negate completely all the head shops and smoke shops that do sell good products too. Some of our stuff is in there, but I think myself, I'll only speak for myself. My whole mission is my own access as a community herbalist to my customers.
Okay, great. Thank you. Does anyone else have questions? Okay, Senator Chicarelli.
Do you know the reason why Connecticut's so expensive to test the product where out of state is less expensive?
We don't have a competitive marketplace. There's really only 1 or 2 labs. I think there's only 1 left, but I urge you not to use that as as fact. That might be fiction, but there's no competitive landscape, and there's probably not enough throughput. So the wait times are extraordinary, is what I understand from my colleagues, and so there's not rapid turnaround, and the price point. I've never even explored a Connecticut lab. I used to use a lab in Rhode Island for my first 2 years. And now I've formed a great partnership with one in Kentucky, and I wait maybe 5 days. I can call them and ask them for it to be quicker without an added fee. Sometimes 10 days at the most, but I literally can get my compliance test done for $50, say.
Where
And
Connecticut would be much more.
in the 200s last time I looked, $1,500. I wouldn't test, honestly. I'm not joking.
1,500 and you could get it 50 in Kentucky. Interesting. Okay. Thank you.
What about
Thank you for informing that.
But I paid. So my cannabinoid test is 35. He's talking about the 5-panel test, which is the mold and more advanced testing. That's 250 in Kentucky. In Connecticut, it's 1,500.
Wow.
But when I tell you, it's the turnaround time really matters.
Thank
Yeah,
you.
I wouldn't choose to test at 1,500.
Thank you very much. That's
As much.
interesting.
Is that it?
Great, thank you. Are there any further questions? Okay, thank you so much, Becky.
Thank you.
Okay, Mr. Clerk, who's next?
Next up, we have Kenneth Bastian with a couple others.
All right. We also have Ellen Brown. She's on. Ellen, would you like to begin?
Good afternoon. Thank you all so much for your time. I really, truly appreciate it. My name is Ellen Brown. I am a United States Air Force veteran. I'm a compliance trainer, and I'm a hemp farmer in the state of Massachusetts. I'm here today to voice concerns about different aspects of Bill 5150. Please appreciate that this is an abridged version of my testimony in order to not repeat and to be mindful of the committee's time. Line 814 to 816 states that only a micro business would be allowed to sell cannabis seedlings. I was hoping the commission could hold space, or I apologize, the committee could hold space for the conversation of whether or not it would be better to allow for multiple licensing types to sell clones. This would allow for a variety of cultivars that have different genotypes, phenotypes, different cannabinoid profiles, terpene profiles, so that way there's diversity in the market for the consumers, be it adult use or medical. And something I really wanted to talk about today are lines 4 through 19 and lines 1,607 to 1,608 pertaining to hemp products, serving sizes, and servings per container. Respectfully, I don't see these regulatory hemp changes creating betterment for public health, safety, and welfare, but I do see it creating detriment to the Connecticut hemp industry. The aforementioned lines need to be addressed to be more amenable to those whose livelihoods will be affected and those that rely on those CBD products. I'm grateful for the committee's time, and I'll be sending over more notes about the bill with my written testimony. I'd like to echo support for those that have spoken before, including Erin Kirk, Anne Marie, Duncan, Luis Vega, and upcoming Michael Goodenough and Ken. Thank you all so much for your time. I truly appreciate it.
Sorry, just before we move on, can you give me the seed concern again one more time on those lines? Just reiterate what you were asking for.
Absolutely. Thank you very much. So the exact lines are line 814 to 816, and this states that only micro businesses would be allowed to sell cannabis seedlings. So I was wondering if the committee could hold space to have the conversation, if it would be beneficial to allow for multiple licensing types to sell cannabis seedlings, so that way there would be more cultivars available for consumers, be it adult use or medical, making sure there's a varietals in different genotypes, phenotypes, cannabinoids, and terpenes.
I got you. Okay, thank you.
Thank you.
And Ellen, you provide education in multiple states as mandatory by the state. That's from Massachusetts, and what state?
In the state of Vermont. So I thank you very much, Mr. Goodenough. I'm a compliance teacher, and so part of my job is to read regulations. And I'm also a United States Air Force veteran, and I'm here as a veteran and as a farmer in support of Sweet Heel and the other farmers, and making sure that they're able to have legislative reform that's going to be beneficial for their livelihood and for those that rely on their products, the products that they create with integrity and customers in mind.
Thanks, Ellen. I guess I'll jump in, Ken, next. My name is Mike Goodenough. I'm a Marine Corps combat veteran. I'm also a hemp farmer. I'm 5th generation in this state, in the state of Connecticut. We transplanted into this state, and we were supposed to be able to sustain. My family has been bleeding over the soil and the land of this state for 5 generations, and I prayed that I could give it to a 6th, and that's not going to happen. It's because I followed after begging. I've been testifying for 9 years with you people, 9 years, and I begged you to help our farmers have a crop with the USDA so that we could survive and have something different to go to market with. And you granted that in 2018. In 2018, 0.3% THC was the number that we went towards. That was the number that held federally. There are federal guidelines which have money put behind those guidelines to come up with numbers and not guess and pie in the sky and wonder what 0.5 milligrams is compared to 1 milligram, compared to 5 milligrams. There's federal funding to give you guidelines so that you don't diminish and hurt the federally protected farmer that is growing a federally legal product, which you have now made illegal. And you are forcing us to sell in an illegal, federally illegal market in order to avoid selling illegal narcotics in your retail stores, which are licensed and insured. How does this make sense? The products that are being sold in your stores are not hemp derived. Stop putting them into our industry. They do not come from my people. They do not come from my farmers. I manufacture over 110 products, 110 different brands around the country. I have 40 here in the state of Connecticut. Not one of them manufacture a product that is illegal and in any of those stores. Yet you say it's my hemp that is causing this problem. Those are illegal narcotics that are being brought in by drug industries that are covering themselves up with my term hemp. And you are now punishing my farmers. You are now punishing what is federally legal and turning it into something illegal because you don't know how to control it. You have the greatest education system. Connecticut's EDU is stronger than any other EDU in the entire country. We have UMass, we have UConn, we have Eastern, we have numerous universities who have been digging into this since day one. Dr. Berkowitz has been running with this since 2015. And for you to turn around and be sourcing or looking for education from anyone other than our own EDU on what does a milligram do or doesn't do is ludicrous. I do not understand what we're doing. And I do not understand how we're going to backpedal now and hurt those farmers and those small businesses. Do you know 50% of our CBD shops have closed down since you made your new laws, which you still can't police the ranks of? You have people here testifying that they're still able to buy drugs in their local stores, but you're going to come at us deeper to 0.5 milligrams per vessel. That's ludicrous based off of what science? If you want to know what 5 milligrams does, then go talk to the people who are doing the driving studies in your own state. And they're analyzing people consuming THC and then what that inebriation actually does. Start taking responsibility because you're killing us. Literally, I have vets who are checking themselves into mental institutions because what's happening in this room is impacting them greater than the combat that they served in to protect the flag that sits behind you. I have people who are losing their farms after generations. I have store owners and entrepreneurs who are already enabled and trying to rise up and have been and have put money and time into their local community who are shutting their doors because of the audacity that comes from these new laws. It's ridiculous. And I beg you, make a change. All I see here is separation. I don't want this person to have an opportunity over there. I don't want this person to do this. I don't want somebody else to have something more. Well, let me tell you what I want. I want us all to thrive and succeed. I want us to be unified. We created the Connecticut Cannabis Small Business Alliance, which takes everyone from a basic user to a store owner, to the people who are making the tires for the security trucks, to our farmers, to every single individual within the industry. And we are offering you a bill that has recommendations on how to rectify this mess that we have in front of us, this mess which is ruining lives. Please
Does your
understand.
companion have anything he wants to add? Thank you.
Yes, I would like to present the bill we wrote.
You can give it to MJ.
Yeah, the clerk.
Clerk. Thank you. You want to give a summary of what's in it?
Yes, so let me just introduce myself. My name is Kenneth Bastian. I'm the owner of CT Hemp Shop, and I'm the owner of AI Web Tools LLC, and I am the managing director for Connecticut Cannabis Small Business Alliance. I've been extremely affected by your last legislation, okay? 95% of my products have become illegal, and none of them are psychoactive. None of them. Okay? I recognize you. Yeah. You were at my shop. Anyways, I sit here before you today and I say, please listen. Okay? All of our small businesses are being completely decimated, not included in this industry at all. All right? You guys say it's equitable. How is it equitable? How is it equitable? We're shutting down CBD shops with non-psychoactive products only to let big MSOs sell them, Mr. DeAgostino. You have an answer for that?
So
So-
we're happy to take your testimony, guys. Is there, if do you have any further testimony you'd like to add? We've got some more people behind you.
We'd
So
like the labs to not cost so much in the state. We can't support anything small batch. That $1,500, divide that across a farmer who wants to make 100 tinctures. That 100 tinctures would be $15 just to be on the store floor, just in lab costs. We would like to make sure that all the CBD that's going into these dispensaries isn't coming from Oregon and the large MSOs who are bringing in those products today. Every bit of CBD in those spaces have not come from a single hemp farmer within this state. Not only do we want that, but we'd like for the distribution. The simple fix to this whole problem is distribution. If there was somebody who handled distribution and verified what they're selling to these stores like they do for every other regulated product that we have, then there would be no problem. The distributors would be the ones to hold accountable. Instead, we're making new rules. And I trust me, I know you guys are trying your best in certain areas, but we're stuck in this vortex of complexity and things we don't understand. We would like the EDUs to become more involved. We would seriously like you to turn to our local EDUs and the professors who are teaching this to the next generation, because they're what's important. These are the CEOs and the people who are going to drive the companies of our future. And right now, they're just as confused as you are. And that's insane. We'd also like for you to look at what I grow as a crop. It doesn't need to be destroyed in a year. Basic agriculture tells you to store a certain percentage of your harvest for 3 years in case there's a drought or a blight. We would like for you to take into consideration the integration of small businesses and models that help a small business owner not have to incur the fees that are equal to the large size enterprise. They're never going to survive having to pay the same prices for their point of sale systems, for the delivery fees, and everything else associated. We'd like you to put on your economics hat and actually take a look at what's happening with the small businesses around us and enable them to be successful within the cannabis business, not just lock everything into the THC realm of the dispensaries, which right now are controlled by a large group of people who are large size enterprise. Everybody uses the term MSO. It's the wrong term. A large size enterprise has to act a certain way. It is their business. It is different than mid-size and it is different than small, but make an envelope equal to the small and to the mid-size business so we can succeed too. We cannot reach their level. And we're also asking that you follow the federal guidelines that are actually put out there for you. The reality is those guidelines are things that answer questions and have money and components that go behind them. I'm also asking you to look at your extraction. You're asking us to not produce anything with chemicals. You want it considered to be a synthetic. But then you're telling me to remove the THC from my hemp. Do you understand that you're saying use a chemical to do that? The only way to get rid of THC out of my hemp is with chemicals. You have to think about what you're putting in front of us. It doesn't make any sense. You've built an industry and now you're tearing it asunder. And Representative D'Agostino, you said that you only had one marketplace. You don't. The hemp marketplace was here first at 0.3%. And that was there very specifically before the cannabis business was. And now there's a cannabis business. And oh, by the way, we gave away gifting and grow at home. That's a third market. You have 3 markets that we need to address. And by locking THC into one of them, doesn't change anything.
well said. Other questions? Representative Osborne.
Thank you for your comments. I'm actually very touched by your impassioned plea to us here today, and I have a very specific question. With respect to an organic product and us saying we don't want chemicals, we don't want chemistry used on this, I know you've been here all day, so I know you've heard the other testimony. Does the cannabinoid, and I'm going to get it wrong.
You're all right, go for it.
The ratio that you've heard prior people testify about,
Yeah.
having that CBD ratio to THC, does that remove the issue of not having to use chemistry to have the THC
100%.
not be intoxicating?
100%.
So if we were to adopt a
Cannabinoid, I say cannabinoid because I say cannabis, not cannabis.
Okay.
And so say it any way you feel comfortable.
So adopting that kind of cannabinoid ratio would, in your opinion, solve that intoxicating problem of the THC because it will be coupled with these other cannabinoids.
So intoxication is 5 milligrams is what your current driving studies are showing. 5 milligrams is what gets someone to a point where they shouldn't be behind a car. And we don't want anybody driving behind
Right.
us. My biggest concern are people who consume things, then get behind the wheel. Granted, don't want children to have it and everything else. But first and foremost, the reality is that 20-to-1 ratio gives you a ratio where it matches the need to be able to put a 3,000 or 2,000 milligram tincture out there to help those patients. And no, it won't be psychotropic. But put your hats on for a minute. The digestive tract in the upper portion of the body digests almost immediately, as opposed to an edible, which goes to the stomach. Each one of our membranes absorb differently. Something that's applied to the skin is not going to get you high. This organ doesn't impact or absorb in the same way. Just think about it the way you normally would take anything else, whether it's a pill, whether it's smoking. Smoking's instantaneous. It has a shorter lifespan. Every one of our organs are a different method of delivery. And the reality is I get the drinks. I truly get the drinks. It's your upper digestive tract and it's instantaneous. And I wouldn't want anybody consuming rapidly in that mannerism, especially if they're also consuming other things, unless their intent was for that. And so we have to remember which organ and why we want to control that level of that organ. You could put 1,000 milligrams on your skin and it's not going to affect you. And that might be a little bit of an exaggeration. But the point is, each organ is radically different. And I get the drinks. I truly do. That's the cleanest organ for most people. Whereas the rest of us pollute the rest of the organs that are there, whether it's smoking, whether we have bad gut health, whether it's all of the other layers there have different impact. So I'm sorry, I didn't.
No, thank you for your help in educating me. I appreciate your testimony today.
And we're here to help. We're here to give you guys as CCSBA ears to every layer of the vertical that's there. Every small business that exists. If you want to talk science, we'll talk science. I'll bring in professors and assistant deans from 7 different universities because I work with all of them. They all send students to my farm to learn from. I've yet to see one person come to my farm, although I've extended the invitation radically to every individual at every testimony. And I'll do it again here today. If you want to have discussions around any of these variables, come have those discussions.
I don't know how many times I have to say it. This is not a debate over what level of THC here and who's got what and who's making it. This is much simpler. Okay, you make products with THC in it.
Yes.
I don't care about the level. You make products with THC in it.
Mhm.
Yes. After we did your market, we went through a whole process where we created a new regulatory marketplace for THC products. And right now, we have multiple marketplaces open for these products. And philosophically, what this legislature decided, now maybe they're going to change their mind, I don't know, is that there should be one path for those products, regardless of level. I hear what you're saying. Oh, don't worry about it. I can drink a drink with this much and I won't be intoxicated. But if I drink a drink with this much, I will be intoxicated and I can put this on. We're simple people up here for the most part. All right. And for the most part, what resonates with us is we spend a lot of time and effort creating a marketplace for THC products. And you want your own marketplace for it. The package stores want their own marketplace for it. Somebody else wants a marketplace for it. I understand. I understand from your perspective, it's completely different products. I get that. I'm trying to explain to you what's driving this bill.
Yes, sir.
And
I get that.
and we have said,
But I don't want.
I want to reiterate.
I don't
want to
mean correct you,
reiterate.
But we don't want. We have already taken and built our businesses and built our farms around something that you've already made legal.
Yep, and this
supported us to do.
This would alter that. I recognize that.
So you're going to destroy every small business and every farm. Then just tell us. Tell us you're shutting down hemp because I spent $80,000 last year rebranding to your new labels and your new labs. I bled as deep as I could bleed to try and match your new laws, and now you're going to give me new ones.
We made pretty
Can we
clear
just ask
last
you to
year.
read our definition we wrote that literally addresses the problem you're trying to close the loophole for?
We will. We're looking.
Thank you.
But I want to be very clear that we are not looking to prevent these products from being made or sold in Connecticut. And to the extent that we need to refine and readdress our law. We thought we did this last year, but to the extent we didn't, we will make it absolutely clear that these products can be sold and can be made. They just need to be sold and made in
By your
accordance
people.
with the regulated structure. That is different than the one you're operating with now. I get that. I totally get that. And it's not fair at all.
So my house loan was called in because I might be getting my money from cannabis. From cannabis.
I'm sorry, sir, but listen to me. The regulatory structure of the state of Connecticut is our responsibility.
Yes, sir.
Not your mortgage. I'm sorry you got into a field knowing full well, by the way, that the state was going to regulate a competing marketplace for it and now have to react to that. And we're going to do everything we can to make sure your products can be sold.
My products are federally legal.
But our responsibility is not your mortgage. Our responsibility is to the entire state of Connecticut and a regulated marketplace for cannabis.
Correct.
And to sit here and say, forget it, don't worry, we should allow an entirely separate marketplace to exist with 20-to-1 ratios and a separate testing scheme and products that still get you intoxicated, right? I mean, I can smoke a number of joints or edibles that you guys make and get the same level of intoxication.
Illegal products that
depending
don't
on
match
value.
these standards can get you high,
But
but that's not our products.
And
We're getting thrown into a bucket.
and we're happy to have your products sold in our stores, right?
In your dispensaries, which are not federally legal, which takes my business and my farm and it puts it into now not being federally legal.
Look, you've made your case. If this legislature wants to have a separate marketplace, frankly unregulated, or less regulated for your products, that's what they'll do.
It exists, sir, federally in every single state
I can go on
already.
Amazon and order things. And
Yeah,
are you going to stop that?
The out-of-state stuff, we know we have an enforcement issue with. That's a separate issue.
So you're going to let Amazon sell
No,
things
no,
to my
we're-
neighbor,
we're-
but
we
not
don't-
small business.
The idea here is that all of this stuff, it'll make it a lot easier to just regulate and ban because we can look at it and say,
You can't ban Amazon from selling it or sending it.
well,
You can't do anything.
we're
So
Our
you're
state
literally
can't
doing
impose laws on
something
somebody in
against
another state,
only
sir.
your people.
yeah, we're
You don't
Just
care.
us.
we can
Say it.
regulate.
You don't care.
We can regulate THC in the state, and that's what we're going to do. That's what we have done.
And
But
I'll-
look, I get it. You guys have made your case. You've made you're going to get a chance to testify too. Are you guys? Hey, the way this works is you sit down and you testify. Are you guys all set? Do we have any further questions for members? I'm going to ask you. Any questions? Thank you, gentlemen.
Thank you.
Mr. Clerk. Up next, I have TJ Elgin. No. After that, I have Allison Sicard.
Of the General Law Committee for being present today to listen to my testimony pertaining to an act concerning cannabis and hemp regulations. I'm a mother of 2 grown children, daughter and granddaughter of registered nurses, great-granddaughter of an Algonquin medicine healer, and a lifelong educator. Hence, I begin my testimony by reflecting on our nation's history with cannabis and hemp, so we all understand the roots of our relationship with it. Current legislation can either repeat or prevent the mistakes of our past. 17th century American hemp farmers were incentivized by the US government to cultivate hemp for rope, clothing, and sales for ships. 19th century cannabis was a common ingredient in medicines. Early 1900s, following the Mexican Revolution, immigrants bringing their familiar recreational herb with them were scapegoated for inciting marijuana-induced violence. Subsequently, by 1939, 29 states had regulations that outlawed marijuana. Then we had the Marijuana Tax Act of 1937. But then in World War II, the United States Department of Agriculture launched a Hemp for Victory campaign where 375,000 acres of hemp were grown in America. Then we had the Schaefer Commission, which I'm sure you're all familiar with. It was bipartisan, concluded that personal use should be decriminalized. President Nixon ignored these findings, declared a war on drugs, and created the DEA in '73. More regulations in spite of reports from the New York Academy of Medicine, as well as both the Kennedy and Johnson administrations, absolving cannabis from propagandic misconceptions of inducing violence or being a gateway drug. Ask yourselves who the casualties are of this war on drugs. I am. Our farmers are, our small business owners in this state. According to the ACLU, by 2010, over half of all arrests were for pot, with minorities 3 times more likely to be targeted. Personally, I have been arrested and incarcerated for possessing a plant which was first cultivated over 12,000 years ago in China. A self-regulatory infrastructure for cannabis already exists within the legacy community of growers, caregivers, small business owners, veterans, and folks who appreciate and nurture the essence of this herb. History has shown that government regulations lead to criminalizations. I implore you to adopt a narrative of reclassification in lieu of regulation. Cannabis is truthfully an adaptogenic herb that engages and supports our internal endocannabinoid system that all invertebrates possess. Oleander, castor beans, giant hogweed, hemlock, bleeding hearts. Some of you have plants more toxic than cannabis growing in your backyards. Consider cannabis like tomatoes, but far less toxic than these nightshade cultivars. I just want to grow my own using native-free sunshine and share my harvest of healing with folks. You're trying to regulate an herbal supplement essentially. I am astounded at the level of what I can only describe as acts of reefer madness, which permeates our policies and saturates our time, better well spent tackling the real plagues of society, such as human trafficking, hunger, and homelessness. My heart sunk despondently when on the opening day of the new session, I was attempting a discussion in the lobby with Representative Rutigliano, when he tapped me on my chest, stating that he would never vote in support of anything pro-THC. That was a hard no to hear and a hard pill to swallow. It was such blatant unreceptiveness to public sentiment or public opinion. History does repeat itself, and your decisions decide your legacies and families' futures. Are you a staunch supporter of spreading the propaganda of reefer madness, or are you engaged with the people to create innovative policy that reflects the people's interest? Please listen to the farmers, small business owners, caregivers, patients, veterans. We are the people. Thank you for your time.
Questions or comments from committee members?
I'll be happy to comment. I don't remember touching anybody.
I do.
I don't. So I completely
I guess it's
disavow.
your word against
And I thought
mine.
you were the psilocybin.
I am. I am advocating for all plant-based
Right.
medicine.
So I think I was against psilocybin that day.
But you said THC, so you
Maybe I
got
made
your
a
words mixed up perhaps, and
Maybe.
I understand that
So
we all make
just to be
mistakes.
clear for everybody, and I know we don't want to extend the conversation. I supported grow your own. We are against the commercialization of cannabis. If you want to grow it and smoke it, we thought, God bless you, have a good time. It was the commercialization that we had issues with.
Can I use sunshine to grow it without a license?
Yeah, as far as when this was proposed, as far as we were concerned, me personally, and some of my colleagues, we were totally okay with whatever you wanted to do in your own house. Why you yell? You want him to yell at you? So you have a great day.
I
urge
will
you-
have a great
But
day.
let's all be clear on what's
Thank
going on
you.
here. It's the commercialization.
You're much more
of the
polite to
product.
me now than you were then.
Well, I have that.
We can be
habit.
clear on federal law as well, which I'm not going to sit here and reiterate the data that's been shown
Other
and displayed
questions
to you.
from committee
I
members?
know that D'Agostino has stated today he prefers not to do math, but there needs to be some.
Thank you, ma'am, for your
some of that
testimony. We
being done
appreciate it.
and some data.
Thank you very much.
I appreciate you too.
Thank you.
Up next online, we have Nick Costanza.
Nick, can you hear us?
Yes,
You're on.
great. Good evening to the honorable members of the General Law Committee. Thank you for the opportunity to provide testimony here today in regards to HB 150, in addition to the corresponding written testimony I've submitted as well. My name is Nick Costanza, and I'm General Counsel for the Can and Bottle Company, which created the first ever microdose THC beverage product and brand, Can Social Tonics. Can products were created in 2019 based on our co-founder's passion for giving adults a social alternative to alcohol through safe, low potency, great tasting THC beverage products made with natural ingredients. Our products are currently available to consumers in over 40 states throughout the US where permitted, and are available in 1 milligram, 2 milligram, and 5 milligram THC formats. Because low potency THC beverages like Can are an alternative to alcohol, we've always believed that these products can and should be regulated in a similar fashion as well. Specifically, we believe low potency THC hemp beverages are appropriately regulated and sold through state regulated hemp channels, whereas high potency THC products are appropriately regulated and sold through cannabis dispensary channels where both high potency and low potency THC products can be sold. It's been exciting to see so many states adopt this sensible approach and permit the sale of low THC hemp beverages both inside and outside of cannabis dispensary channels, including especially Connecticut with the sale of manufacturer hemp products up to 5 milligram THC per beverage that are regulated by the Department of Consumer Protection. However, we're deeply concerned that the proposed 0.5 milligram THC per container limit in HB 5150 will result in the elimination of the low THC hemp beverage market for Connecticut, its businesses, and consumers. We believe Connecticut's existing hemp laws already contain key provision that sufficiently protects against certain concerns raised by policymakers, including packaging and labeling requirements like warning statements, FDA-related statements, for example, cannabinoid potency testing requirements, and also a ban on synthetic cannabinoids. There's also at least 4 additional safeguards that we respectfully encourage the committee to implement into HB 5150 that are already used in other states where these products have proven to be safely regulated, sold, and consumed inside and outside of the cannabis dispensary channel. The first of which is restricting the sale of hemp products with more than 0.5 milligrams of THC to persons that are 21 and over and requiring age verification prior to purchase. The second is limiting sale of hemp beverages with more than 0.5 milligrams of THC by entities with liquor permits and entities that apply for, pay for, and obtain a registration from the DCP to be a hemp retailer or hemp wholesaler. Third is to add testing requirements for hemp products that are akin to those already in place in Connecticut for cannabis products for quality and safety purposes, such as testing for heavy metals, microbials, mycotoxins, pesticides, and solvents. And finally, to implement an excise tax on the sale of hemp products that is equal to the excise tax applicable to cannabis products. So in conclusion, CAN respectfully urges the committee to revise HB 5150 to contain a 5 milligram THC container cap for manufacturer hemp products that is currently already in place, and to consider incorporating at least the 4 additional safeguards I've discussed today in HB 5150 to ensure that Connecticut's hemp laws are sufficiently rigorous to enable these products to continue being safely regulated, sold, and distributed in the state. I thank you for your time, and I'd also informed the committee that I've submitted written testimony as well, further laying out these points in support, along with supportive exhibits.
Thank you. Questions from committee members? Anybody online, MJ?
Questions online, Mr. Chairman.
Thank you.
Up next, we're gonna have Katie Covett with Jennifer Fell.
Good evening. My name is Katie Covett. I live in West Hartford, and I'm here to speak in general support of HB 5150. I'm one of 4 co-founders of Soulstar Connecticut. We are one of the teams. Approved for the Section 149 Social Equity Cultivator License, and we're the only female, 100% female-owned and led company. We aren't backed by a large company because we ourselves are experienced cannabis operators. HB 5150 provides a real opportunity to improve upon a social equity program that, while well-intentioned, contains a number of built-in barriers that disadvantage the very people who should benefit from the program in the first place. Last year, we stood before many of you here to share our story and push for changes that would help teams like us to get our businesses off the ground. And we've made great progress since then. Our team recently paid the state of Connecticut the required $3 million fee to accept our social equity license, which is $3 million that doesn't go towards any of our actual startup costs. The fact that this $3 million barrier was placed on income limited groups like ours, while the 4 non-social equity cultivators paid a reduced fee of $1.5 million, will remain one of the true injustices of the social equity program, but it's a challenge that our team has accepted. Right now with HB 5150, you've created an opportunity for many of the groups here today to work together to address some of the challenges facing the social equity teams. So let's dive in. Right now, our team's biggest struggle is finding available and appropriately zoned property within the DIA. And so we strongly support the language under Section 9, which permits outdoor cultivation operations within a DIA community. This provision would open up agricultural lands for cultivation within DIA communities. It would encourage more environmentally sustainable operations, require less startup capital, and create more diverse products. We also strongly support the provision under Section 2 to redefine the disproportionately impacted areas to include any tribal reservations. Let's make it easier, not harder, for social equity groups to succeed and build partnerships with tribal communities. And our team also strongly supports the provision under Section 3, which allows social equity licensees to partner with hemp farmers. We see this as a win-win for the industry. Social equity groups will have the opportunity to leverage existing agricultural land and the hemp farmers' years of experience, which, when you think about it, is very similar to how other social equity teams have partnered with established operators to launch and fund their businesses. But we don't think it's right that the hemp farmers and social equity applicants should be punished for forming those partnerships. And what I mean by punished is that we do not support the provision requiring hemp farmers to give up their hemp licenses. Instead, let them keep their hemp licenses and take a smaller stake in the social equity license, which is already really required by the ownership and control rules. And second, we do not support the provision requiring social equity groups to give up their opportunity to form equity joint ventures. Why would you eliminate the opportunity for social equity groups to create additional social equity group ventures and make it more difficult for the social equity cultivators to build a profitable business? Our team also strongly opposes Section 17, which prohibits discounting and promotions on cannabis products. Cannabis retailers do need the tools to manage their inventory and keep customers engaged. And even though it might not seem like it, we do think that this issue is also a social equity issue. In markets that have those kinds of restrictions on discounting, what happens is that the more established, better financed groups will take more risks to win over customers with discounts. And if they get caught, they know that any fines or penalties are worth the rewards for customers knowing that they have the best deals. They can afford to take those risks. In contrast, new groups to the market, especially social equity groups, will not be able to afford those kinds of risks. And finally, in reference to the language in section 11 on telehealth and pharmacists, we strongly urge the committee to listen closely to the patients and the pharmacists who the foundation of this cannabis market was built on whether the pharmacist should be required on site. We thank you for this opportunity, and we hope that you will recommend the provisions of 5150 that create a more diverse and equitable cannabis industry.
Thank you. I'm sorry, I was just taking, give me the section you posed on the hemp piece again.
Sure, that's section 3, which allows social equity licensees to partner with hemp farmers.
There's a part of it you were opposed to.
Oh, so sure. So we oppose the section that we don't want the hemp farmers to be punished. So they should be able to keep their hemp licenses if we're able to partner together to create a grow. And then we also do not support requiring the social equity groups to give up their EJVs.
All right, got it. Thank you. Questions from committee members? Senator,
Representative Akron.
Representative Akron, thank you.
Yeah, Mr. Chair, and thank you for your testimony. So section 9 that you touched base on regarding, so you're struggling with space, you said, or location.
Correct.
Do you think that in these areas, you're going to be able to, with section 9, that you'll be able to find those spaces also?
Absolutely. So what I believe section 9 does is permits outdoor cultivation in a DIA municipality. So instead of being in the blue area on the map, which is largely you know, it's hard to find a space. Sometimes it's neighborhoods where people live. You can't put a grow operation there. But in those communities, if you expand the map, they do have some land, specifically agricultural land. We would still be in a DIA community, be able to create jobs, impact that community. It's just not in the specific census tract that was created to create or to enable someone to become a social equity applicant. So it's just expanding, like Hartford's a DIA. Only certain areas of that DIA we could locate our facility in.
Oh.
What we're asking for is that if there's anywhere in Hartford where we could locate, we would have a much easier time finding our home.
Okay, that's what I was trying to get down to. So you've looked at areas that you can, you know, that in these areas that you can expand to that. So this actually does expand the area
Yes.
and opportunities. So
Correct.
that's what I was interested in
Yep,
getting that
it
answer.
would,
So
within the same community. Mhm.
great. Thank you. Thank you both. Thank you, Mr. Chair.
Thank you, Representative. Senator?
Thank you very much for testifying. You didn't touch base on allowing the 149s to convert to the micro cultivators. And
Yep.
How do you feel about that? I think you actually brought that idea to us
Yeah,
originally.
I-
So
you know, I-
was a little
That is
surprised to
true.
not hear you testify. on
Yep.
that.
I also like that idea. I think that's a great pathway. I think how the bill is currently written, you would also have to lose your EJVs. And for us, the EJVs are really key to making sure that we can be profitable. We can kind of diversify our business. We would love to be a micro cultivator with our EJVs. And I think for some other groups who are really struggling with that $3 million, because it was a struggle, we got there, but them paying 1.5, I think that would be helpful for some groups. We also support that. We want to bring more people into this industry who want to be in it. And I think the barriers right now are pretty high. If we can reduce that, we're all for it. We don't feel intimidated by that.
And then I think one of our other intents it isn't in the language now, but that we do plan on adding is to allow conversion to a micro cultivator and to negotiate with the hemp farm as a micro. So is that something that you would support?
That is also something we do support.
Okay,
Yep,
thank you.
yep.
And thanks for your comments. I think if we keep the license fee at the $3 million for the 149 cultivator to negotiate with the hemp farms, it does seem fair that they keep at least one, if not both EJVs. So
Okay.
Thank
Yeah,
you.
we would really appreciate that.
Thank you. Other questions or comments? Marcus?
Thank you, Mr. Chairman. Do you have any opinion on going from 7 years to 3 years?
I really appreciated what your comments there. And what I think should be asked is, what do the social equity individuals want? They should be the ones deciding. It should be the Social Equity Council with them coming to you with what makes sense to them. I'm not the social equity individual on my team, so I don't feel that I can speak to it. I really think it's their call. Some of them may make a different decision, but I agreed with what you said. It's really up to them. And I do also feel like 7 years from now, it could be completely wiped out and they're off the map. And that's not the kind of industry we want to be a part of. I don't think it's the kind of industry you wanted to build. So I am skeptical of provisions like that.
Thank you.
Mhm.
Other questions? Anyone online, MJ?
One online, Mr. Chairman.
Thank you. Thank you. Appreciate your testimony.
Next is Jennifer Fell.
To the chairs, vice chairs, and the ranking members, as well as the rest of the members of the General Law Committee. We are grateful for your thoughtful leadership and consideration in crafting this legislation, and we appreciate the opportunity to provide testimony regarding HB 5150. I speak today on behalf of the Connecticut Cannabis Chamber of Commerce. The Chamber is a membership organization representing a diverse cross-section of leaders in the industries, from cultivation to delivery to dispensaries, manufacturers, transport, and other non-leaf touching services. The Chamber was established in 2022 to promote sensible policy, responsible growth, and effective development of Connecticut's cannabis industry. Connecticut's adult use market began with a license lottery cultivator application process in 2022. Recreational sales started in January 2023 with 7 dispensaries, and now there are over 30. with the potential of that to more than double. And we've seen the sales in the adult market steadily increase to about 15 million a month, with December holidays bringing an outlier of 17 million. Access to capital, though, remains one of the most significant hurdles for the majority of cultivators. Aside from the 4 existing medical cultivators, only 1 new cultivator and 2 new micro cultivators have entered the market thus far. Availability of flower and biomass is a critical concern for dispensaries and manufacturers at this point, as you're well aware of. That being said, many cultivators are actively under construction. So for example, if you're coming in 91, you can see INSA building where the chowder pot used to be. We know with 1 or 2 additional, I'm sorry if that was a sad moment. We know with 1 or 2 additional cultivators coming online in 2024, as is expected, this will immediately bring significant relief to the flower shortage that we're seeing. It's important for us to acknowledge that the changes that we are proposing in the legislation will not bring that immediate relief as they are looking forward. We do maintain continual contact with our membership throughout the year, learning from, sharing their insight and experience. And to establish and refine our legislative initiatives, our leadership circle members regularly convene to discuss and vote on the specific provisions. So there have been a number of our membership here. They may have some unique perspectives, as you've heard throughout the night, but what we represent is the majority vote of chamber membership in the leadership circle. With that being said, I'd like to share our specific positions around HB 5150. In the current bill, we support many of the sections as written, including the definition of high THC hemp products, prohibition of the sale of multiple servings of hemp products, although we do know that there could be some consideration for beverages to be broken out of that. The clarification to allow 2 EJVs per each Section 149 cultivator, enhanced access to pharmacists via telehealth, and methodology to apply for the relocation of dispensary and hybrid facilities. Additionally, the chamber provided some recommendations for amendments to the bill. Section 149 cultivators partnering with hemp farmers or converting to micro cultivators are controversial within the chamber membership. Provisions for the hemp partnerships are defined in the bill, which prevent the EJVs and require the full $3 million investment for licensure and establish a level of fairness and palatability within our membership. They feel comfortable with saying, yes, you can be outside of the DIA on these existing hemp farms with the trade-off of losing EJVs and maintaining that $3 million. And although we have concerns about the negative impact of the change that it would cause on social equity, in terms of the new provisions for microcultivation, the chamber would like to see these new operations be located within the DIA with a limit of 10,000 square feet and without the opportunity to scale up. So right now, as it exists, they could come in as a microcultivator and continue to grow and then eventually apply for full cultivation at 250,000, which is probably what everybody would have done if that was their first opportunity.
So I'm sorry, is the objection to that, we didn't get a chance to do it, so nobody else should?
No, that's not the objection. I think.
What is the objection then?
I
mean, if grow is
valid.
grow is a concern, and this.
Yeah, I
leads to more growth.
think the objection is they're stepping down. They're paying 1 million. They're not paying 3 million, and they're able to enter the market there without paying the 3 million to become a full cultivator. And the chamber also recommends that hemp partnerships and the microcultivator conversions are capped in first come, first served basis as well. So putting some sort of limitation on how many people can move into those roles. We also support the bill's provision for a sunset date on Section 149 cultivators to receive their provisional licenses. We recommend an earlier adoption date than the December 31st, 2025. Another priority for the chamber that was not included in the bill, and you've heard several people talk about it today, is to reduce the EJV social equity applicant ownership from 7 years to 3 years. And I know there's been some speculation, we've had some conversation around that, but it was a vast majority that supported that within voting. And then in final response to HB 5150, the chamber strongly opposes the prohibition of cannabis establishments from engaging in advertising or marketing that includes discounted prices or other promotional offerings, which market experts believe would be detrimental to the industry as a whole. So we acknowledge there's limitations in a short session. We look forward to further discussions in the next session on operational concerns that include branding reform, packaging reform, potency limits, which also may remain high priorities for the chamber's members. But thank you very much for your time, and would love to answer any questions that you may have.
Are there any? Committee members in person or online? Great, very comprehensive. Thank you. Appreciate it.
Next up online, I have Ivelisse Correa. She's coming in.
Great, thank you. What's her name, MJ? Ivelisse?
Ivelisse.
Ivelisse, you there?
Oh, there we go.
Can you hear me, Ivelisse?
Yeah, I think she's in now, Mr. Chairman.
Can y'all hear me?
Yep, perfect. There you go. There you are. You're on.
Oh,
Nope,
hold on.
you just lost.
Okay.
No, I can hear you. Oh, there you go. Okay, perfect.
All right. Thank you. You guys can hear me okay?
You're good. Go ahead.
Okay. Wow, this is really, I'm sorry. Let me just move this over here. I'd like to begin by thanking the committee for allowing me to speak today. I'm a little frustrated. This is a couple years in a row now that I've come forward to the committee to warn you guys about problems that you're going to have. I have this testimony written, but instead I'm going to tell you a story about someone I go to church with, right? Elderly man, cancer patient. He doesn't like smoking cannabis, but everyone in church knows that I do it because I, smell louder than the sermon. So this man has bone cancer and he cannot access CBD. He's been having the hardest time with it. So, I've had to sit there and source it for him just to give it to him. What is being done to the hemp industry is unforgivable. What is being done by why does it keep switching? I need to change my background after this. I'm sorry,
You're
guys.
good. You're coming through okay.
Okay.
Yeah.
So what's being done by lobbyists to the existing cannabis industry is just going to push it further underground. Right now, there's a shortage while the legacy market is thriving. I think the additional attention and publicity that has been provided by William Tong to the legacy market and the pesticides and the mold and the fact that we have the highest mold and mildew limits in the country in our medical cannabis program is horrifying. So raising the profile on that and just letting everyone know that this is what the regulated market brings you has really done a lot for the legacy market. There's also, the horrific fact that we started out with Vince Candelora talking about locking Black and brown men up. You don't need to sit there and state a race. Black and brown people have traditionally been sent to prison more, prosecuted more, despite the fact that we usually sell cannabis at lower rates, just according to the studies. It's frustrating. It's disenfranchising. This is going to continue to be a disenfranchisement rather than looking to create a marketplace of former legacy vendors who have now been bought out by Connecticut to an equitable market. I don't think that there's any dispensaries that are 100% Black or Brown owned. Everyone has to partner up with a mainstream operator. This is basically Curaleaf in blackface. This is their plant in blackface. This is an insult. And to talk about workforce training would not, you don't need it. That's why the ATF exists. If Black and Brown people needed workforce training in the cannabis industry, the ATF, all these other agencies, they just wouldn't get our tax dollars. It's clear that Black and Brown people know how to run businesses. Oop, I'm sorry. And they're still being kept out of it. You have people still sitting in Connecticut prisons, and I'm able to go buy weed on an iPad with some mold on it down over at Weston Street, down the street from the prison. This isn't right. This isn't fair. This bill, I mean, besides being able to grow out in the sunlight, there's not much about this bill that anyone should be a fan of. There's like, to sit there and say that the state of Connecticut is not responsible for a man's mortgage is disgusting. Should we not be helping a farmer out? We already don't do enough for farmers in this country as it is. So to sit there and say, hey, I understand what you're doing is federally legal, but I don't care. Go do something else. I mean, is that serving constituents? This isn't. This is serving lobbyists. This is serving donors. This is serving everyone else except the people it was meant to serve. There's still no equity here. There's still people sitting in Connecticut prisons for cannabis. And I don't know what else to say other than the fact that I'm not sure if anyone's listening to us or if this is just a formality. If this testimony is just, hey, we're going to do what we want anyways, because it seems that's what's happened every other year. You have people, I mean, first of all, me witnessing a whole argument between a senator and a constituent, that's crazy. That is absolutely bananas. And y'all need to be ashamed of yourselves. Y'all need to be ashamed of yourselves because no one's listening to cannabis consumers. Y'all talking about all these regulations and everything.
We've gotten the message that you're sort of over your time. Is there
Yeah, I'm just saying that a cop's not going to be able to sit there and peg me for a DUI after 7 minutes. And the reason is my pupils stop dilating after that. So, I mean, I don't know what y'all talk about enforcement or anything else, but please speak to actual consumers. And I thank you very much for my time and allow me to go over.
Thank you. Good luck. Good luck in church this week.
Yeah, I'll need it.
Thank you.
Because they watch my testimonies. Thank you.
Thank you.
Yep.
MJ.
Up next on my list, I have Joe Grabowski.
Welcome. Thank you.
Thank you. Thanks for bearing with us, members of the law committee. It's been quite a night here. I have my two partners here, also from Serene Craft Beer. We're based in Bridgeport, Connecticut, and I had a whole thing prepared, but I've heard everything that some people have said before us. I've heard kind of where you guys are coming from with regulating THC, and I don't want to waste any more time on what we were talking about. You have my testimony, it's online. I think we offer a unique position. We've been selling these products in Connecticut for about a year now. We are a licensed beer wholesaler. We know about regulations. We know how to keep these things safe and age gated and all that kind of stuff. I echo the sentiment of trying to get regulations out there. I think we are in a unique position. We've seen this. We operate in 5 different states. We see all how these, specifically THC beverages are being sold, not just in Connecticut, but in other states. There's other states that are embracing a bifurcated market, as you said, Representative D'Agostino, to great success. And I'd love to, show that another time. There's some other states like Minnesota that have really embraced this, and they did a rollout of the adult use market simultaneously with hemp-based market. They have a 10 milligram cap. Anything under 10 milligrams can be sold by anyone who registers with the state. It's monitored by cannabis. And that's, I think there's been some kind of back and forth on should liquor stores have it. These people have it. We've picked as being a beer wholesaler, a liquor store we thought was easy for, the legislature. It's already there. There's a system in place. I have to register every beer that comes into this state. We have to send in lab tests, the ABV. All of those things are in place. We would embrace that and allow, that's, I think, kind of where our heads were at when we were talking about how do we properly regulate this. The alcohol channel seemed like a proper place. There are other models in other states, and I think just to see all the other impassioned speakers that have been here tonight, there are ways that this could be done, still monitored, regulated, and kept safe. And also some of those products that I think have been at issue are not what we're selling. We're not, as far as I know, and I know that we don't sell to anybody that doesn't have a liquor license, period. No one, we're not selling to a gas station. We're not selling to, anybody that doesn't age gate. We sell to dispensaries. And what we've seen is that a lot of these products are unregulated and they're way above the milligram cap that you guys put in last time around, which we think was a fair milligram cap. And I don't want to get into the science and all that kind of stuff. What we think is there is a model that works in other states. We've seen it. And part of it is taxing it. And when you tax it, these products we're talking about, these seltzers, they're not going to go to a dispensary. The reason is, first of all, there are no beverage manufacturers currently in Connecticut. Nobody in the adult use segment makes a beverage. There's a reason for that. It doesn't sell in a dispensary. In Massachusetts, it's 1% of sales. Okay, so that's kind of what we're talking about. People go to dispensaries for higher dose products. The products that we are selling, they have up to 5 milligrams. The number one selling product in a dispensary is a pre-rolled joint. Pre-rolled joint has 150 to 200 milligrams of THC. You would need to drink 30 of the seltzers that we sell at the 5 milligrams in order to equal the same amount of THC in that joint. It's almost 4 gallons of liquid. So we're just talking about a totally different product here. And I understand trying to get that into a dispensary channel, but what I'm telling you is that it doesn't sell in a dispensary channel, and there's reasons for that. And if you take it out of there, and you could keep it and tax it and regulate it, that money could be used to enforce the gas stations, the bodegas, the places that they're going to still sell. When you guys go to a 0.5 milligram cap, they're still going to sell those products. They're not going to stop selling those products. And we need to enforce, those bad actors are giving us a bad name, quite frankly. And we're trying to do the right thing here. And we came into this before there was any cap. And then you put in a 5 milligram cap. I've had drug control at our warehouse. I've been working hand in hand with them. I actually was, in essence, training them on how to look at the labels, show them the certificate of analysis, scan the cans. They've been looking at us as kind of advocates, and I think we bring a unique perspective to, the legislature, the General Law Committee. We have seen this work in other states, and again, we've seen a lot of passionate speakers here today. I think there is a different avenue that can be explored where not only can they be kept safe, in certain stores, however we want to do that, but they don't have to be relegated to a dispensary. And if you relegate it to a dispensary, they will be gone and there'll be zero revenue from that. You're not going to get that revenue from a dispensary. Matt, you have anything?
Joe covered most of what I wanted to say too. But again, I'll thank you guys for being with us. And it's very clear you're razor focused on getting everything into dispensary channel that has THC, and it's beautiful in its simplicity, but there's so many people you hear speak today because it just doesn't work. And you can say you're putting it in there and allowing them to have a market, but the dispensary channel doesn't want these items. I'll give you an example with the 5 milligram beverages. These things are, again, to Joe's point, 1 gram blunt, you can have 150 to 200 milligrams. You can buy that for $15 in an adult use dispensary. It weighs 1 gram. You can fill your pockets with, you can fill in one of these seats, you can fit about $20,000 worth of product that is an adult use dispensary. In one seat here, you need about a tractor trailer to fill about $20,000 worth of hemp-based THC beverages. And so when you have to move these products to dispensaries, You've got them carrying satchels. They can only carry so much in the satchel. They got to move everything to a vault at the end of the night. They don't want to deal with volume of these beverages. And you've heard dispensaries talk today and adult use dispensaries talk today. None of them have issues with the 5 milligram cap that we've spoken to. And you didn't hear it today either. And I think there's more testimony coming later about the same fact. So I think we're trying to get to is a common sense, what we think is a common sense solution. It does mean that we do have to bifurcate somehow on some level of THC allowed. But again, we're not talking about products that get people extremely high. At 5 milligrams, we can debate whether someone's going to feel that or not. But again, the most common product we're talking about adult use are 150 to 200 milligrams. And that's 50 to 60% of the sales of those stores. This is less than 1% of their sales. They don't really want it. It doesn't move there. That's why you don't have a beverage manufacturer. You will not have any beverages in your stores at all. So all these people that are saying the consumers that want consumer choice, it doesn't exist if we move it to the adult use dispensary. So I know it makes sense elegantly and simply, but without totally reinventing and throwing out the baby with the bathwater, alcohol channels do have all these points that you're talking about in terms of lab testing, label registration requirements, 21 plus. There is a real avenue to moving it. And I don't want to get into a whole debate on about the package stores and what they're grabbing or who does it, but it doesn't necessarily even have to be alcohol channels. But I think it, in terms of without having to reinvent the entire wheel to satisfy a whole lot of constituents, there is a whole channel that exists already that's kind of makes it much simpler than trying to redraw the whole thing up from scratch and allow a second market in that sense. There already is an avenue, as Joe said. We've had ECP, we've had liquor control. Never stopped by our warehouse before. We've been in business, what?
8 years.
8 years. They've been here several times since we started selling these hemp beverages. So they are all over this. There is an avenue for enforcement here. So, and we can supplement that with additional tax revenue. Joe mentioned the Minnesota model. They're pulling in over $1 million a month in tax revenue currently just from hemp-based beverages. They have a 10 milligram cap. You guys have already sensibly set, I think, 5 milligrams. We're not advocating for that to increase, but we've seen what happens. They don't have the same kind of complaints from hemp farmers. They're generating a ton of tax revenue to help enforcement, to get the bad actors, the 100 milligram gummies you see in the gas stations, all that other stuff taken care of. You can't do it without enforcement. So it's one thing to regulate. It's another thing to actually act on it. And so I think there's maybe a path that makes everyone kind of happy. I don't think anyone's advocating against it really at the end of the day.
So, I mean, okay, there's a couple issues, right? I mean, the first one is just the policy choice that we have to make.
Yeah.
Is that, do we want these products, no matter how you describe it,
Yep.
it is an intoxicant. And I can drink, maybe I'm not going to drink a case,
Right.
but somebody downs 12 of those 5 milligram seltzers, they're hot.
Sure.
Yeah. Okay. So there's a policy choice that we have to make. Put that aside.
Yeah.
Let's say we go down your path. Why not then in restaurants? They have that the architecture exists there for beer and wine to be sold in restaurants. Supermarkets, beer is sold there, same architecture, same thought. So you understand the policy implications of what you're saying aren't just as simple as seltzer, beer, no problem, just follow that dual market.
Yeah.
There's a lot of policy implications to what you're suggesting.
Totally.
There is, to use your words, an elegant simplicity of what you're suggesting. Should we go down that path? I'm saying there's policy implications to what you're saying.
Yep.
That
No doubt.
we all have to wrestle with. That's kind of the overarching point there. I'm sure from your perspective as a wholesaler, right? I mean, you'd want it sold in supermarkets, in restaurants, in packaged. Why you'd want as many channels that follow the beer scaffolding.
Selfishly, yeah, of
Sure,
course.
right?
I think
Of
I think we're trying to present something in the spirit of compromise. And so for us, where you guys want to draw the line is up to you. But I know it's 1% in dispensary channel, and it offers a
and then once we do that and we say, okay, package stores only, then next year it's, well, why not in the supermarkets? And then next year, and again, this is, I mean, everybody here has got to figure that out from a policy standpoint.
Yeah, totally.
Or
That's why I wanted to suggest
or is it the policy choice that we made, which was THC as an intoxicant has one avenue. Again, I'm not the arbiter on this. I'm the voice of what we did and what we're trying to fit it into. And if the committee's pleasure and the legislature's pleasure is, and society's pleasure is to change that, it will. I go back to something I've been saying a lot, which is we're 2 years into this marketplace. We may not be here right now on this, but 10 years from now, everyone might say, yeah, THC seltzers, that's what we want. And we want them in, we want it on tap in our restaurants like Bud Light. But I don't think that's where we are as a legislature, but that's what we're wrestling with. But I appreciate the the structural option you're presenting. Questions from committee members? Tim?
Thank you, Mr. Chair. Thank you for your testimony. Do we know what amount of sales have been approximately in the state of Connecticut with this product?
Yeah, we probably have a pretty good indication. We're one of the only wholesalers, I believe, selling it. So we probably, I believe we've sold about, I'd have to run a report, but we haven't quite been a year, but if I'm annualizing it, it's about 30 to 40,000 cases, but it's growing every month. And that's about, retail wise, it's about $90 to $100 a case.
And you said, and it's taxed.
It's currently not. We're advocating for you to use, and again, looking at Minnesota as a model, who's actually embraced it. A lot of the hang up is from retailers is mostly the confusion about, is it legal? Is it not? The laws are changing. We decided to, we decided your interpretation was it was legal at the time. So we got into it, but a lot of retailers are kind of waiting, seeing where you guys go with it, which is maybe a wiser decision, maybe not. But for us, as I mentioned in Minnesota, the market where they've bifurcated the market, they have adult use at the same time. They launched a low milligram beverage option for hemp farmers. They're pulling in over $1 million a month in revenue. It's about, they're only 7 months in. I believe last month's data was the last we got in January. It was about 1.2 million in revenue, and that's 10% of retail, which matches the adult use segment. So that's just from the hemp beverage side, not from the adult use side. So there is a real market from consumers for this that doesn't exist when you put it through the dispensary channel, and it does allow, that is a lot of enforcement dollars to try to get rid of a lot of the products you guys are talking about. Is it THC 8 or is it Delta 9? Is it Delta 8? Is it THCA? We're specifically talking about Delta 9, which is the naturally occurring, and then is it intoxicating? Is it not? Should it be in this market? Should it not? You already have the cap in place. This is a lower resistance avenue. That's why you hear a lot of the impassioned testimony of like, if you put this in, I also say as a side note, this is a one-to-one replacement for alcohol. So in a lot of ways. And I think if you look at studies from 3-4 years ago, when this adult use market was just coming into existence, you don't see a lot of that data because it was only, 2% of the alcohol market. What we've seen is very recently, a lot of federal studies showing the exact opposite, especially among younger consumers. So I would say from 21 to 35, there's a lot of studies that suggest that this is essentially, they're making the decision whether they want to have one or the other. And this is specific to beverages also. This is this is what we've done. We've had one lane for intoxicating products for 100 years almost. And we've opened up a second. It's natural that it's going to compete with it. And so as a wholesaler, I can tell you our beer sales are struggling. And we do have, I don't want to get into the economics of it and not going out of business, but there's a lot of, there's people at stake here and jobs. And so that's why we're impassionately fighting for it. And it's not something we can correct because the younger generation is actively choosing cannabis and they specifically want these beverages, and they're not buying them again from dispensaries. They want to get them elsewhere, whether they're buying them online, grocery store, package store. You guys can ultimately make all these decisions. I'm just trying to give a guide of what else has been done so you guys can see how maybe you can legislate without upsetting constituents in other areas and still have a safe beverage. Again, 5 milligrams versus 9. They have 900 milligram cartridges, vape cartridges in these stores. These are the most popular products they sell, 150 to 200 milligrams. You've already set a 5 milligram cap. So whether or not it gets someone high or not, depending on their tolerance, is largely irrelevant. And can they drink a bunch and get high? They can. But again, there's also benefit of alcohol channel is we already entrust them to guide intoxicating products. It's existed for 100 years. So there's no necessary need to deviate from that. And whether or not on-premise consumption, there's a lot to get into there for sure. But I think it's easier than the lift of all these hemp farmers, all these other interested parties that are potentially losing a lot of completely non-intoxicating products due to the regulation. So that's what I'm hoping to get across.
I appreciate that. I think of when I'm going to get a refreshment, I wouldn't typically go to a dispensary. I've never been to a dispensary. I have stopped by a local package store to get a refreshment, and I have turned in a manner to the near beers, the non-alcoholic beers, just for health reasons, and half the calories and literally almost no alcohol. So, but truly appreciate you being here and sticking it out with us. Thank you.
Thank you. And thank you for sticking around. And also thank you for putting in perspective, understanding what a joint would be compared to the the drinks based upon 5 milligrams. That really did help me kind of understand it. Just a quick question. Did you guys provide written testimony?
Yeah.
We did.
And does that have Minnesota's kind of breakdown of how they're implementing it or regulating it?
I didn't include like the whole guidance, but I can get you exactly what they have. I mean, and to Retigliano's point, they have a whole thing about what you can do in a restaurant. Like you can't serve alcohol and THC to the same person. There's a lot more than just where it can be sold and the milligram limit. They've really dialed in an actual legislation to make sure everything is safe and properly taxed, to be honest. Like these products are taxed at sales tax right now, but they're not taxed at adult use tax. And that's exactly what Minnesota did. It's 10% for adult use. It's 10% for hemp products.
Retail sales. We also would suggest that through the alcohol industry, it may be even easier to collect through wholesale. I mean, if you're taxing retail 10% or wholesale at 15% or whatever the markup is, there's already an avenue for that. So,
And is it only for the CBD seltzers, or does it also take into consideration the other CBD products that are in that kind of same milligram?
It specifically for THC, as you guys kind of have alluded to, is like
CBD products have THC
Right.
in them naturally, but really what they're saying, we don't care how much CBD or how much THC is in it, other than there's a cap, and it can't be more than 10 milligrams THC. Ratios, everything else, like how is it going to get you intoxicated, whatever.
But it's
Draw a
not
line.
just for the seltzers.
no, it does include other products,
Got
but specifically speaking, like that is where the sales are.
Got it. Okay.
Total Wine has it. There's Binny's. There's all kinds of there are stores that have dove headfirst into this, and there's a pretty good market, and they're taking in a lot of tax money.
Got it. Thank you very much. Thank you for sticking around too.
Thank you guys for hearing us out.
Yeah, thank you very much. And I think that right, the shelf space argument is something, and I think you putting it that way, right, with comparing the size of a joint versus the size of a seltzer, right? I mean, obviously you
one,
need to
you need 40.
maximize your square footage and what you're
So-
selling. So that makes sense. The one thing though, I just want to point, and you're not the only person I've heard mention Minnesota. I need to read the actual laws myself, but looking at an article about the Minnesota laws, well, yes, there is somewhat of a bifurcated market now. It says that as of March 2025, Delta 8 THC will then only go into the regulated cannabis market. So I don't know. I need to just read the laws myself.
Said Delta 8?
Yes.
Yeah, we're just talking about Delta. Yeah, Delta
Okay.
8 can be outlawed, but that's not what we're.
That's
Right.
okay.
DCP actually put out another bill to basically
get-
to
right,
ban
and
Delta
everybody-
8. That's not what we're talking about.
Yeah, we're with you.
Okay.
Delta 8.
Yeah.
Great. Thank you for that.
Sorry, other questions?
Oh, Dave, it's okay. I just have a couple because it's been a long day. How do you reconcile the fact that the individual servings are supposed to be individually wrapped or marked, like a candy bar type thing? So your total container is 5 servings, correct?
Correct. That was to comply with the law that was written last
I know,
year.
but how do you reconcile the individual servings? Because an individual serving isn't 5, correct?
Are you talking about what cans we're selling in the market?
Yeah.
Well,
they're labeled as 5 milligrams to
right.
help people understand that if the legislators decided the serving size should be 1
Right.
milligram. They're trying
So-
to say it's 5 times that. Yeah.
And we all agree that this is THC, right?
Yeah, of course.
So under Connecticut law, if you're in the THC, commercial THC space, it's supposed to be produced in Connecticut. Is any of this product produced in Connecticut?
Well, there's a key distinction. It's all derived from hemp, and hemp is federally
No,
legal.
I get that it's derived from hemp, but it contains THC, which in Connecticut is in a regulated marketplace and is supposed to be produced here in the state.
If it's under 5 milligrams, it does not fall under that part of HB 6699 from last year.
Okay. And if you're one of the few distributors in the state, how does it get into the gas stations and all the places where it's not supposed to be? Every convenience store, you name it.
Our
it's sitting in there.
beverages specifically don't get into those channels. I mean,
Where are they buying it from?
I'm assuming online, but I also don't know I mean, we're not in there. We don't sell them. They don't buy beer. They don't buy our hemp drinks. We're not in that space. And I totally hear what you're saying about that being a frustrating avenue. I believe online, but I don't know.
Right. So you guys are recommending that it just be sold in package stores at this point?
We're not recommending any. We recommended that because it seemed to be there's a complication for you guys, right? How do you regulate this?
Right.
And as Matt was saying, the simplicity of putting in the adult use, that's the easiest. I get it. What we're saying is that that brings a whole different set of complications. We're trying to kind of talk to you about how there was another market that did this and there's other states following the same. And it will, you know, it kind of is a win-win for everybody in a sense of a lot of these people that were here talking, you know, very passionately about how it's affecting their business. There is a path for that. And we were saying liquor channel because it's like, well, what do you do when you go to a liquor store? You're buying beer, wine, spirits. They're checking your ID. They're making sure you're over 21. You know, the products are all registered to the state. You can't sell whiskey in the state unless you register it with DCP. We're saying do the same thing with these products. And that's kind of why the liquor channel is a natural fit for that.
So I get what you're saying. It's curious to me because that I feel like you're sort of advocating liquor stores, grocery stores, wherever like a beer is sold, right? But yet you're currently selling it to restaurants, right? With no prohibition on that getting mixed with alcohol or anything. I mean, they could do it. So you're saying put us in a controlled space, but yet you're currently selling it to anybody with a liquor license.
I would say 90 to 95% of our sales are to liquor stores. You know, the one or two restaurants or few restaurants we've ever sold it to, they've put on their menu, you know, drink 2 or 2 max. They're, you know, we are self-regulating, and it's kind of why we're also coming to you guys. Like we want more regulation. If it shouldn't be in a restaurant, then let's talk about it.
It shouldn't be. See, you can't under our Connecticut law currently. Correct me if I'm wrong. You can't have alcohol and THC basically in the same spot.
Right. You can't.
But you're putting it on a shelf in a package store and on a shelf in a restaurant that makes drinks. Currently, we're doing that right now.
I think there's a difference between hemp-based THC as legally provided anyway, and currently.
I get what you're saying, but it's still THC.
Right, but you're saying can't, but what does that mean? I mean, if it's legal.
Well,
then
you can't. Yeah. You listen. You can't have a bar. You can't have a dispensary that serves alcohol, basically. So you can't have THC and alcohol in the same spot, in the same place, basically. So, but even though you're saying that my THC has been derived from a legal product across state lines, not Connecticut derived, I'm still okay selling it to places that sell alcohol, which all the other dispensary and the cannabis people can't do. Is all I'm saying.
That's a very fair point, and it's almost a silly distinction, but it really depends on where you're coming from, what you're trying to achieve. And I think if the goal is to create some sort of common sense legislation that helps support hemp farmers locally and helps support consumer choice and helps also, quite frankly, not eliminate you're essentially eliminating the products if you're saying the only channel is dispensary. And so we're trying to say, look, this is federally legal and does not need seed to sale regulation, but it does need regulation. And so that's what we're kind of saying. I think there's maybe a path where you can do both. And yes, currently under Connecticut law, you can't sell marijuana in beverage stores. You can't sell hemp-based THC. Is it a little silly that that's the differentiator because of where they draw the federal line on dry weight?
So I don't know if it's a silly distinction, because if I was a dispensary and I paid $3 million to get into this space, I would be upset if somebody didn't have to pay anything to sell essentially the same chemical compound. I know lesser amounts. I get the whole argument.
Yeah.
And everywhere. This is the problem we had last year with the Deltas and all this other problem, all this other stuff that was permeating into the convenience stores and the gas stations, right?
Right.
We're saying, hey, this is harmful to kids. This is their avenue to get their hands on it. Why don't we just make it so that the dispensaries, the ones that are licensed, regulated, and paid a ton of money to get in this space, let them handle it. And so I guess that's where we ended up. I guess that was more of a statement than a question. I do appreciate you guys coming up here, and thank you very much. Thank you, Mr.
Thank you. Other questions or comments? Yeah, please, Senator.
Yeah, and I did pull up and look at the Minnesota, so thank you. The Department of Health has a nice fact sheet out on what they allow and what they don't and their requirements, so.
Yeah, and just to respond, you know, the dispensaries, you said that they might be angry. They're really not that angry because they don't end up selling this product anyway. It's totally different. So they're, you know, they haven't really complained about that because they're on the, you know, the higher milligram.
To us anyway, and you're going to hear from another dispensary owner today, but yeah.
Yeah, no, I'm just saying that's what we see.
Anecdote. Right.
Sure.
We have brands that play in both spaces, and they are basically fully pulling out of the marijuana cannabis side of it and going straight to the hemp because the sales don't justify it.
All right. questions or comments? Thank you, gentlemen. Appreciate it.
Thank you.
Thanks.
MJ?
Up next online, we have Norman Flood.
Norman? Is he in the room, MJ? Can you hear us?
Hello?
Yep, there you go.
Okay. I don't know if you can see me or not, but that's okay.
Can't see, but we can hear you, so go ahead.
Okay. My name's Norm Flood. I'm owner of Sweet Eva Farms, a small hemp farm in Seymour. As one of your state's last remaining hemp producers, I urge the committee to consider incorporating craft cannabis into House Bill 5150. This inclusion would create opportunities for existing farmers like myself, legacy growers, and other small businesses to participate in adult use cannabis. Sweet Eva Farms represents the potential of countless small-scale farmers across Connecticut. We possess the infrastructure, expertise, loyal customer base, and we contribute significantly to the state's cannabis industry. However, with current regulations and restrictions, hemp farming has hindered its growth over the last year or so. Hemp farmers are operational and ready to transition to adult use cannabis with minimal setup. This reduces the regulatory burden, expedites the market entry. I also advocate for the inclusion of all legacy growers who faced legal challenges in the past. Their experience and knowledge is valuable, can't be left out. As hemp farmers, we have built trust with customers. We established safe handling practices. Adult use cannabis represents a natural development of our business. I propose sales primarily through stores or public events. This keeps us with community engagement, supports local economics. Craft growers prioritize quality over diversity over mass production. We grow unique strains and we all grow unique different ways. Many craft growers like myself use organic farming methods, promoting sustainable growing areas. I suggest craft cannabis grow size areas of say 100 to 2,000 square feet. This way here it would keep it under a craft canopy in a smaller size. Including craft cannabis into 5150 will create jobs, generate tax revenue, and support local businesses. It provides consumers with unique, high-quality products that fosters a competitive market without hurting our competition, which would be corporate. Craft cannabis provides an avenue for equity and social justice and other legacy growers, drug war veterans, small farmers like myself to enter the market equitably. By including craft cannabis into House Bill 5150, we would create a diverse, sustainable, locally focused adult use market in Connecticut. By leveraging the existing infrastructure, promoting quality over quantity, and adapting sensible regulations, we can empower small businesses, create jobs, and contribute to our state's economy.
All set? Great, thank you. Let me see if there's any questions for you. Any questions for Norman from the committee? Online, okay. Thank you very much for your testimony. Appreciate it.
You're welcome.
MJ?
Up next, we have Dan McInerney.
Sorry to disappoint you, but this is not 5150. Chairpersons Maroney and D'Agostino, ranking members Rutigliano and Ciccarella. I'm here to testify in favor of bill number 5151, an act concerning solar licensing exemptions. You'll get my written testimony later on this evening. So I'm just kind of winging it now because it's been a long day. Basically what we've done this go around, we were here last year trying to get rid of the exemption. This year, we're trying to clarify it to what is actually the electrical work and what can be the work of other individuals. So I know from some of the testimony today, there's a awful lot of going back and forth on how much money it's going to cost people, but your surrounding states are strictly electricians doing solar work from soup to nuts. And it doesn't seem to be a problem there. We're not asking for that. We're just asking that the work that's got to be done, that's electrical, be done by licensed electricians. And with that, I'll take any questions that you want to ask. Let me just make one more point. When, I spent, I'm the business manager for the International Brotherhood of Electrical Workers, Local 488. Prior to that, I was 2 decades as the electrical inspector in the city of Bridgeport. I have seen a lot of solar installations. When I was an inspector, it probably had an 80% fail rate on the first inspection. And very seldom do you actually see an electrician on the job. So we're here to make sure that we can get this passed to keep it to where electricians are doing the electrical work. It's going to save houses from burning down. It's going to save sites from burning down, because if they're not properly wired and properly grounded, which is electrical work,
Well, I mean,
it is.
I appreciate that, but for the, Representative Osborne's question, give us one example of where something burnt down to the ground in this state because of.
Well, the problem you get with that is it's very hard to get that information, because it's basically, if it's a house fire,
Well,
it's
that's
just
what
gonna,
fire
it's gonna
inspectors
say,
do.
it's gonna say electrical. It's not gonna say it was solar panel.
I think I think we'd hear about it if that
Okay.
example existed.
You
I think
also heard, I
the
think,
issue that I think I wanted to hone in on
Sure.
is I'm struggling with what is placement and anchoring based on what we heard. And I don't understand why electricians should be in charge of the roofing work. The actual,
well, what do you consider to be roofing work?
what do you consider to be placement and anchoring?
We're placing the panels and anchoring them to the supports.
To the supports that
Yes.
are already on the roof
Well, they have to be installed.
by,
They can be installed. They can be installed by anybody.
okay. That's what I'm looking to clarify. Because you've heard a lot of concern about the damage to roofs and.
Correct.
And it seems
But-
like this is anecdotal.
So just to make a point though, electricians do, and Representative Ackert could probably confirm this for me. Electricians make penetration in roofs all the time. Because if you have an eave on your house that hangs too far over when you're putting the service up, you have to drill a hole through it to put up a masked electrical service.
No offense to electricians, but I know I'd be more comfortable with a laborer or a carpenter. Probably doing
Well,
that.
that's fine, because that's what we're trying to distinguish
yeah.
here, is what is the electrical work
Yeah.
and what the work that others can do.
I guess somewhat of my concern, I think what you're clarifying is that what I don't want to have, 'cause we asked you guys for compromise, is, the laborers and carpenters coming back a year from now saying, they're telling us that the electricians have to do the work that we're doing.
No, that's not what we're doing. We already, from organized labor,
Yeah.
the carpenters and the laborers have no problem with this.
Yeah, no, and that's what they said.
No, I know.
I'm
But
worried
here-
about in practice.
But here's
when it
the
comes
thing,
down to
you know,
placement and anchoring.
what we look at though also more is large scale solar, which is, that's where you're gonna have a lot of distinguishing between whose work is what. So right now you have it in that exemption, anybody can set the panels. The minute that panel sees light, it's creating electricity.
Yeah, no, I get that part. It really is it's that fixture piece that is concerning me, that placement and anchoring seems so broad to me that I worry there's going to be a dispute between in terms of who's doing
Okay.
that fixing, like you said, fixing the structure that the panel goes on onto the roof, who's going to be doing that work. And I
Okay.
guess I foresee conflicts down the road of an electrician saying, I'm the one who's got to install those support structures on the roof, and a laborer or carpenter saying, no, I should be doing that. That's more within my wheelhouse. You see what I'm saying? Placement and
And,
anchoring.
and that's how it would be on a large scale job
Sure.
anyway.
Sure. I mean, again, I worry
Well,
about future.
Let me
conflicts
ask you
like
this, if we make modification to that language, would that be something you'd entertain to make it more
Yeah,
clear?
no, absolutely. I mean, look, you guys seem to have agreement on it. I worry about, I'm not concerned about the exemption generally. I
Yeah.
like the idea of having the qualified craftspeople, doing the work. I'm just concerned about the infighting about the particular work, and frankly, making sure, I mean, Tim, you can tell me if what he says is right in terms of, again, I don't practice here, but the electrician's doing what really should be, that kind of actual structural work. And then understanding that electricians absolutely should be the ones doing the connecting, getting the panels themselves down and connected. That I don't think there's any dispute on. Just placement and anchoring is so broad. That's what I was worried about, just the potential for conflict here.
Okay.
Tim, I don't know if you.
Yeah, no, so not, the electricians I know have no desire to sit there and drill 50 anchors into somebody's roof and put in racking. And I can tell you, and I respect IBEW as one of the best trained organizations for electricians that we have. But for our training, we do a service mast, which is not, it's the extension of a roof. If it leaks down the pipe that's not in your house, but yeah, I jumped up with some solar folks last year because of this bill and jumped right up there. And I can tell you, it is not it's dangerous to be on a roof. Let me quote that. So we're in full gear with harness. I'm not sure if they had harnesses on when they were doing yours, but we have full harnesses, roped off. You can't fall off the roof type of thing. And you grab a panel that weighs, 15 pounds. And you lay it down, you uncap it and you plug it in. And until that actually is plugged in, does it actually have any danger to an individual? So I get where we're trying to go with this. I'm more concerned, as that is vague in this language here, but I'm listen, I would always mention, I would always direct as much work as I can to electricians.
Right.
We don't want to do this work. We'll love wiring something up, making it live, making the power go back to the utility company, whatever it may be, and have you save money on your electric bill. But we're not roofers. We're not climbing up there. It's a metal rack system that you sit on. You lay on the roof. You put in rubber boots that hold it in place, and you screw into the building, and it's got a caulking. And that's let the people that are trained by the corporations that get in there train, and hopefully they're training them correctly. That's the key there. And then let the electricians wire them up.
I mean, it doesn't sound like you're disagreeing with what he just said in terms of which pieces, who's doing what piece.
Correct. But we're also limiting this installation basically to residential housing, and it's not. If you're talking the larger scale commercial rooftop, it's a flat roof. Nobody's going to make those penetrations except for the roofer, because 9 times out of 10, the roof has a warranty on it. And if you make that penetration, you voided the warranty. So if we have sleeves coming up through the rooftop, the boots are going to be installed by a roofer, not by the electrician. The electrician's bringing the pipe through the boot. And the same goes for when you're doing the racking. They're going to set the attachment points, and then we set the panels and attach the panels to those.
Yeah, no, that's helpful. That's what I wanted to sort of
Yeah.
hear, is sort of the each sort of piece along the chain of
Right.
house and stuff. So that's
And then the same thing you have with a large scale solar site. You're gonna have operating engineers that are gonna be digging trenches. You're gonna be, have laborers. They'll be loading and unloading the trucks. You're gonna have carpenters if they have to build forms, building the forms, or they could be sharing the racking with, or not the racking, but you know, building the stanchions. And then the electrician comes back, sets the panels, anchors them, does the wiring.
Again, everybody seems to have signed off on it. I just am trying to make sure
Yeah.
that there's not
No,
gonna be a fight
no,
down
no,
the road.
no,
So, okay.
I get it.
Other questions from committee members? Great, thank you.
Thank
Appreciate
you.
it. MJ?
Up next, I have Jennifer Jennings.
In person or on? Oh, great, thank you.
Good evening. It is still evening, even though I think most of us should be sleeping. So thank you, General Law Committee, for still staying with us and entertaining this. I've certainly learned a lot. I came here solely to provide some support for Senate Bill 135. But in the meantime, I've got some side notes. It's been an educational experience for me today. So first and foremost, thank you for the collaborative approach by allowing multiple people up at the same time in light of time. Secondly, Old Glory seems to be leaning a little bit behind your head there. I'm not sure if somebody is sitting on it. There we go. And then from an educational component, I sit on a local board of education. Oh, by the way, my name is Jen Jennings. I'm the executive director of the Connecticut Heating and Cooling Contractors Association. We represent about 85% of the interests of the heating and cooling contractors in the state of Connecticut. Sitting on a local board of education, I believe there needs to be significantly more exposure to the trades and getting more students to come into the trades. So with that, supporting Senate Bill 135, capping DCP's occupational license fees to $100. Outside of just the license fee, there's the schooling that they pay for. Possibly they didn't go in high school. They were never exposed to the trade schools. So they're going after school, whether they're doing an online program, paying $6,000 or potentially upward of $40,000 going to one of the private schools. Then they might have a license prep class before they sit for the license exam, costing anywhere between $300 to $600. Then they have the test fee to PSI, and then the license fee to the state of Connecticut. It's a barrier for young people getting into this trade. If we can cap it at $100, I think that would be a great avenue advocating for accessible pathways to employment and strengthening the workforce. So that's really what I came on. Despite all of the wonderful information I received tonight on cannabis, I'm going to segue into House Bill 5151. I did not hear any real feedback from my contractors directing me or guiding me in any direction on this particular bill. However, I do align with the thought that electricians should be doing electrical work. We do have photovoltaic licenses and solar thermal licenses, not many of which are actually out there in Connecticut. The PV is really done by the electricians, solar thermal by the heating license. However, I want to make sure that we are not limiting access to what is done in terms of the roofers have the opportunity to drill the holes still, and we are not making the electricians who probably don't want to drill the holes, and just clarifying scope of work. And if it does not directly detail that, maybe that's something that you may want to look at. I also wear another hat as a realtor, and Representative Brown mentioned some issues with his own installation. Being a realtor who has sold several homes with solar on them, I think we should take a deep dive into the solar contracts. It's a nightmare to sell a home with leased panels on them. So that possibly is something to provide some consideration. Again, that is not part of this bill either. And inside here, I heard quite a bit of conversation about how many are on these jobs and the work of the carpenters and the roofers and who's doing what work. It's interesting to me in the state of Connecticut that you can frame an entire home and roof it and make sure that the water's not leaking on you or the house isn't falling on you. And there's no restriction on how many roofers or how many carpenters can be on that job site. Matter of fact, they're not even licensed. But the 5 occupational trades that are restricted by a hiring restriction, I think that's something. I know this committee has little appetite to take it up. I know my friends don't necessarily agree with me. However, I think it's something to give consideration to. Workforce development is greatly needed. It's an industry that is booming, but a workforce that is stagnant. And some consideration when you start to look at how many roofers or carpenters can be on a job site, but you're limiting the amount of HVAC and electricians and plumbers. Wishing you all a great night and thank you.
Well done. Thank you. Questions? Great. Thank you.
Thank you.
Appreciate it.
Mhm. Up next, we have Jennifer Shu Weldon. Oh, sorry, Shirley.
Yeah, that's fine. Yeah, that's fine. Yeah. Evening.
And I live in Fairfield County. I'm here today before you as a cannabis investor that has a lot of different assets in multiple states, and I want to shed some light onto the conversation that I think we're having today based on my previous experience. The truth is that there are no beverage adult use manufacturers on the market. There's no product currently on the market, and there likely will be no product on the market, right? We have investments in California and Colorado's adult use market in the beverage space specifically. And I'll tell you, we just wish you didn't, because it just doesn't work in the adult use channel. In California and Colorado, beverage sales are still under 1%. It's some of the most mature markets that we currently have, but it's still not working. It's rarely ever the only ticket that is, it's rarely ever the only product that is purchased at a dispensary. That means that people aren't going to dispensaries to purchase these beverages, right? But as soon as you saw Minnesota, and our friends at Serena testified already, that as soon as you went into the larger scale channels for these beverage, it is absolutely successful. So the juxtaposition between a California and Colorado market and a Minnesota market for THC beverage is a real story, and it's very big difference. The dispensaries also have a hard time operationalizing these beverage. They're huge, they're voluminous, they're heavy, and for the contribution margin that they actually bring to it at $5 a can versus a vape at $80 for a tiny little thing is very different operationally to actually push that type of volume, right? It's hard to store, the profit margins are low, and customers who are going to dispensaries, there's two different types of consumers who are going to dispensaries and ones who are looking for beverages. The ones who are going to dispensaries are not looking for the 5 milligram beverage versus the ones who are looking at stores are not looking to get high either, right? They're two just completely different customers. And I'll also tell you that in order to make an investment in a beverage line, it's upwards of $1 million. To stand that up in an adult use market with 30, maybe 50 doors eventually at $5 a can to the consumer is not a good capital allocation decision. We've done it twice. We won't do it again in Connecticut, that's for sure. We've definitely considered it. All right. And so I wanted to give you guys that perspective as well. I understand the desire to separate the lanes and to regulate it separately, right? But I also think it's about protecting consumers' choice. Consumers who want THC beverages cannot get them legally in a dispensary because there's probably going to be no beverages produced because it's financially very, very hard to make that work in Connecticut. I personally have a very fatal allergic reaction to alcohol. And that's why I've been a cannabis consumer for a very long time. And when I discovered THC beverage about a year ago, on a trip to Massachusetts, it changed my life. Because as an adult, yeah, sure, when I was younger, sure, I can smoke. But as an adult with kids and family, I'm not going to go outside and smoke a little bit to take off the anxiety in a social setting. That's just not acceptable, right? But having a beverage in a social and family-friendly setting is. And so I urge you to reconsider the 0.5 milligram per container and to revert it back to the 5 milligram because it doesn't really, like our friends at Serene said, 5 milligrams, you have to drink 30, 40 of it to be equivalent to one joint that you can purchase. I don't know about you guys, but my bladder can't take 40 12-ounce cans. It's just not, that's not the purpose. When I'm drinking a THC seltzer, I'm not trying to get high. I'm trying to still get the benefit of the plant, but I'm not trying to get super psychoactive ingredient in my body, right? And by the way, I can also order all these hemp derived beverages, THC beverages online, and I do. They're not age gated. They're delivered by UPS or FedEx. So there's nobody at the door checking an ID of who they're delivering it to. I can order 50 to 100 milligrams per can. I have no idea what's in it. So I'm nervous to order something like that so I was very excited to actually see some of these beverages at Total Wines and, some of the liquor stores in Fairfield County where I live, because now I can have actually access to it. And it's safe. And it's, I think, because I do the I only buy ones where I can scan the QR code and get a certificate of analysis on it. Right. And that's important to me because I want to know what I'm putting in my body. And without an avenue for a 5 milligram, a low dosage THC drink, I don't have another choice but to go purchase it in the unregulated, untested online market. Forget even talking about the carbon footprint of shipping a case from Michigan to New York, right? But it's not safe. And I'd much rather not do that. I want to have, as a consumer, I want to have the choice, because as an investor, I know there's likely will not be that in the dispensary channel here.
So you're familiar with this, it sounds like you're familiar with the structure of this nationally in terms of how these products are produced and where they're
For the THC market, yes.
Yeah. Okay. So, I mean, if we chose to do this down the road,
Mhm.
both from a policy standpoint, we followed the alcohol architecture. It sounds like there's supply out there that we could turn this spigot on if we wanted to, basically is what I'm saying. Right. In other words, we don't have to spool up manufacture. The products are out there. It would come through our regulated alcohol feature system is what you're suggesting.
Yeah, likely.
All right.
But at the same time, I think, a lot of what's currently today is coming across state lines.
Yeah, well,
right?
but to be clear, none of that's really, I mean, the 50 milligrams a can is illegal right now, even under our current law. And yes, it may be coming across our state line. Again, we have to divorce in the conversation we're having, divorce enforcement from regulation. In other words, there's only so much we can do on
Sure.
enforcement, and we're trying to empower our enforcement officers. We started the day with the whole idea of an unfair trade practices violation and arming our regulators to be able to do that. So we're trying to arm people, our enforcement
Absolutely.
officers, with more ability to prevent exactly what you just described.
Right.
But okay, I mean, I hear what you're saying. It's similar to what we've heard before about having that bifurcated marketplace, and that's just a policy decision we're all going to have to deal with. My point of my first question to you was, if we didn't do that today, if
Yeah.
we did that 5 years from now, there will be supply out there that can serve our marketplace. Should we choose to do that? It's being done in Minnesota. Other states are not doing it, but the point is that there's a supply out there. Should we choose to avail ourselves of
Yeah,
it?
should you choose to allow that to cross state
Yeah,
lines?
okay.
Absolutely. Yeah.
Okay, all right. Questions from committee members? All right, and you,
Yeah, and Shirley and I worked together on a number of projects, and so we thought, in interest of time, we'll just try to combine our
introduce
discussion.
yourself to the committee.
Oh, yeah,
members.
I'm sorry. My name is Kirk Cameron, owner of the Thomas Hooker Brewing Company. Like many, I had a nice, concise testimony here, but in the interest of time, I have ripped it up, and we're going to just kind of go to the main points here. Like Shirley, I advocate for leaving the potency rules at 5 and not reducing it to 0.5. And if I could just introduce one or two thoughts along the lines, I'm glad people finally gave good examples of the difference in potencies. I mean, when you can compare a vape cartridge at 1,000 milligrams and a beverage at 5 milligrams, you'd have to literally drink 200 cans of seltzer to get the same active ingredient. I brought this argument up to a friend of mine who's in the pharmacy business, and he said, this is really the classic over-the-counter versus prescription argument. And it's really no different, right? We're looking at a product that at high dosage should absolutely be regulated. I mean, ibuprofen's a perfect example of it, right? You can get high dose ibuprofen prescribed from your doctor, or you can go down and buy 200 milligram caplets at the store. I also think that when we look at these products, we have to look at potency, product types, and customer types. And I think that those topics have been pretty well discussed tonight. I mean, customers are not going to buy these products in dispensaries. I mean, that's the practical truth of this. Product types, vape cartridges, pre-rolls, gummies, absolutely regulate those, put them in dispensaries. Beverage is just something that the consumer is gravitating towards, and they're gravitating towards it in retail stores that they're used to buying beverages at. So, I mean, I think we do have to look at these kind of things. The other thing on a more sort of macro level is I'm a beverage manufacturer in Connecticut, and I don't think it's any secret that beer is down, as are a lot of alcoholic products. And what I'm asking for is to allow guys like me to diversify my products into what consumer demand is demanding. I mean, we diversified 2 years ago into CBD seltzers, and quite honestly, it saved our company. To the point of regulation, we've self-regulated. Every single one of our cans has a label with a QR code on it. You scan that QR code, it takes you to an independent lab result that is a cannabinoid workup on 16 different cannabinoids. It shows at what potency level, it shows what's in it, and more importantly, it shows what's not in it. And with good common sense regulation, this can be transferred to these beverages as well. And it should be required because, like Shirley said, like nobody wants to drink something that they don't know what's in it, right? You can't just read a label that says, oh, 2 milligrams. Is that true? And I'll be honest, I've personally tested a lot of these products and they're all over the road. We do not let these products out our door until they've been tested. And once they are, that's when they're released. So I think good common sense regulation in these markets is something they could do well for the consumer, the state, and manufacturers.
Questions? Thank you both. Thank you.
I have up next Mercedes Alicia. All right, so up next online, I have David Barton. David?
I'm literally in.
There you go. You're on.
Vivian, you could go, please.
Okay. Yep, you're on. We can see and hear you.
Am I next?
Yep, you're up.
Oh, wow. Okay. Hello, my name is David Barton. I'm an owner of Health CBD store in Stratford, Connecticut. And there was a lot of things that were said. It's hard to actually really add more to what it was already said. I just can't help but wonder how we went from legalizing marijuana, calling it marijuana, and then in the laws begin to reword the definitions of marijuana into cannabis, and then start to incorporate and include the concepts of hemp being cannabis and then cannabis being marijuana, and all for the sake of controlling THC. It was an interesting process to watch over the last 2 years. But in the process of that, I'm just a small business owner. I follow the laws, and I've watched you guys make new law changes, and then when we abide by those laws, then basically defame us and use words like we found a loophole, rather than just respectfully coming out and never using that term, but to say that we're just abiding by the laws that you provided us within that guidance, and to trust and hope that as a business we can spend all of our money like Michael Goodenough spent $80,000 last year. I spent about $80,000 to adjust my business and reformulate all of my products, all of my CBD products throughout the summer. And I've only managed to get about 30 or 40% of them out by October 1st. And it was very detrimental considering that I'll just say it. You can look at my taxes. As a small business owner, people look up to me and ask me if things are good. And I have to say yes. But in reality, I've only made about $30,000 average over the last 5 years. And last year, spending $80,000 is a lot of money for me to do. That was my only option. I'm a high school dropout. I'm self-educated. And every single thing that I've learned, I've had to teach myself, and then put my money where my mouth is. And then to come out and just see a few months later, you guys continue to snowball and try to eliminate THC is a really tough thing to swallow. But more importantly, it's about the THC numbers and it's about my customers. Everything that I've done has been for my customers based off of their medical needs, their therapeutical needs for anxiety and stresses. Yes, too much THC can not help, and a little THC can help. There's sweet spots in all of that. And it's really tough making products year after year over the last 3 years, being one of the 19 hemp manufacturer licensee holders in Connecticut for consumables and edibles. And I've watched my products as I've increased it to make it a product for customers. And ultimately, I ended up getting to a point where my tinctures were about 250 milligrams of CBD and other therapeutic cannabinoids with about 4.5 milligrams of THC. And that was a level that did not create any intoxication. So that would be more like a 50-to-1 ratio. But that was also something that was for my nighttime products. For daytime products, it was a little bit different. It was about half of that in THC, to where my customers would have about 250 milligrams and about 2.25 milligrams per dose. And that would enable them to go throughout the day with the anti-inflammations, without anti-stress, anti-anxiety, but still be coherent and not allow the THC to create an intoxication. And so in the end, all I can just say is, while you guys are focused on THC on its own individually, you're completely negating the reality of THC with all of these other therapeutic cannabinoids. I did hear it was proposed out there, a 20-to-1 ratio. I think that's decent, maybe even 25-to-1, kind of like Colorado had just passed in June. And there is also
We're at 3 minutes though, so I was hoping you
Okay,
could wrap up
yeah.
if you could. Please.
Yeah, that's okay. I appreciate for your time. It's tough being somebody that has that just struggles. I'm just a normal American citizen. I'm a disabled vet that has served in the Army, and there's just a lot of things that are getting negated by this bill that are have already been affecting people at large just from the last passing of the 5 milligram to 1 milligram. And now what you guys want to do is push it into a dispensary where those people have the right to say no in carrying the product. So how can you create a system and say,
Like I said, if you wouldn't mind just wrapping
Okay.
up, because we're
Yeah.
well past the 3 minutes. Thank you.
All right. So, okay. So in summary, it's tough to hear you guys try to pass a law and tell us that all of the business community and consumers that we can buy this in the dispensaries, when those dispensaries are publicly or privately owned and they have the right to not carry our products. So how does that allow there to be a free market at all? And I do agree. I think that we should have
Thank
a
you
license.
so much. I appreciate your testimony. Thank you. Any questions from committee members? Okay. Thank you.
Okay. All right.
Up next, we have Stella Johnson.
No, if you could just stay out.
And then, all right. Up next then is David Salinas. He's online.
Can you hear me?
Yes, thank you. There you are.
Hello, everybody. Distinguished members of the General Law Committee, Senator Maloney, Chair Maloney, and D'Agostino. First and foremost, I don't envy you guys. I have a headache just having sat here. I was in front of you, and I had to leave, unfortunately, for an event. It's just been a very long day. And I think that the choices and decisions and the things that you have to listen to are very difficult. I stood before you last year against the hemp farmers coming into the cannabis space because we did not know what the licenses were going to come out to be, how many people were going to be growing, how fast that they would come online. And it's a difficult spot to be in even today. This market is changing constantly. There are ebbs and flows and optimizations needed. And I feel for you guys as the people that have to make the decisions. I also have, I'm the CEO, David Salinas. I'm the CEO of Let's Go Hartford LLC. We have multiple licenses in the adult use cannabis market. And we also have it sounds like we are the only people in the state of Connecticut that actually have $1 million canning line to produce cannabis beverages. As a person that really believes in the cannabis beverage market or the THC beverage market, I think having it in the most places makes the most sense because it should be easily available to a lot of people. I think it is a huge alternative to the alcohol market. I think that the market is going to grow in that space. And at the same time, I've done the things that I've not needed to do to go into that market on the adult use side, and we hope to be introducing our beverages soon. If we do make decisions to have THC products in stores like liquor stores and package stores and so on, I would hope that the cannabis manufacturers that are doing it, that paid the license, that can create THC beverages are permitted to participate in that market legally as well. I'm here to talk about Bill 5150. I'll get so Section 3 and Section 4 allowing the 149 cultivators to partner with the hemp farmers. I think that it is okay to do so at this point, but I would not go full steam in allowing all of the hemp farmers and all of the 149s or DIA cultivators to convert. I think limiting the cap to 3 DIA cultivators and 3 micro cultivators would be intelligent. I do think that and that's a small optimization that should be or could be looked at a year later once more people come into the market. I do think the supply issues and I do think some of the market issues and revenue issues that the state of Connecticut are having today are due to pipeline issues and just how long it's taken to allow the regulated market to open. If you look at Missouri, that is exactly a year old, as Connecticut is. They did $1.14 billion in adult use sales in comparison to Connecticut's 144 million, and they've only got double our population, so it's more in line with Massachusetts. So I do think supply issues will improve. But I do think that the market deserves craft cannabis, and having a bunch of MSOs and 149 and the large 149s, which are mostly owned by MSOs, come into the market only and not allow craft producers to come in is a mistake. I would say that the 149 DIA cultivator $3 million license partnering with the hemp farmers should be allowed to keep their EJVs. It's just, again, if we do 2 or 3 of them, it's just going to add 6 stores to the market, which I think the market can withstand. And I think it allows the social equity folks that are coming into this market or the equity joint venture owners to make money on the retail side, which is where I think the better part of the business is to be had. Moving on, I do think that the date should be changed from not allowing the Department of Consumer Protections to grant any provisional licenses post December 31st, 2025. I think that should be changed to July of 2025. I think that that's just way too much time. People have not come into the market yet. We see tons of people in the market right now that are raising capital that don't even have the money for the licensing fees, let alone opening the farms and going through all the processes. I think that it sends the right message to the capital markets that Connecticut is a safe place to do business, and I think that would just put everybody at ease and reduce some of the fears around some of the uncertainties of the business.
David,
Section 10.
Thank you very much. Your 3 minutes is up. Could you just summarize and then we'll see if there are any questions for you?
Yeah, just one thing I want to say is that one of the biggest issues that we're having right now in the business space in cannabis is that we're just not allowing general commerce to take place, not allowing discounting. The 4 Ps of marketing, product, place, price, and promotion. Discounting, I think we're just overstepping a lot in terms of the things that we're telling businesses to do. Our job is to get into the business and to create commerce, to create tax revenue, to create jobs. And I think that there are some oversteps in this bill. So I'm not for or against anything in particular. I sort of talked to a bunch of different pieces, and I would just hope that we just take a careful look at and use surgical precision to make the changes and not a hatchet. And I thank you guys for your time. And that's it. You have any questions?
Great. Thank you. Are there any questions? The only one, just, I guess, clarify. So allowing the 149s as a full cultivator to negotiate with a hemp farmer. So again, we did hear before some people proposed there should be a cap on a first come, first serve. So you're saying 3 of the larger cultivators and then 3 micros is your recommendation. And then I think you had also said to allow the larger cultivators to keep their EJVs. Is that what you're recommending?
Yeah, I honestly, if you're gonna charge $3 million, I think that they deserve the 2 EJVs. It's a very expensive price tag to come into the market, and I think if they can come up with it, they should be granted the full license the way it is. And then on the micro side, I think that capping the number of micros, at least in the first year, and then doing on a first come, first serve basis, whether it's, I think three micros is enough. And that's, again, surgical precision. It says, this is what we're allowing. And then maybe in the future, you allow, 2 or 3 more micros in.
Okay. Thank you very much. Does anyone else have questions? Okay. Thank you, David.
Yeah, thank you. If I'm a little disheveled today, I apologize. I'm sitting in the casino talking to you guys. I just didn't want to miss my opportunity to talk.
Hey, thanks for letting us know where you are.
Not to gamble for an event. Apologies. All right. Be well, guys.
All right. Thank you. All right. Mr. Clerk, who's next?
Up next on my list, I have Carolyn Marino. Oh, okay. Nice. Nicholas Tamburino. Amazing. Let me ask Linda, did she want Linda Morawski? I know she didn't go before.
Is she it?
I don't know if she's joining. Then next would be Wyatt Bosworth.
Okay.
Good evening. This is my first time before general law. I'm usually in insurance, and I thought that committee was
fun and entertaining, but this definitely takes.
As they say, it said in the movie, you have a funny sense of fun.
Yeah. Chris Davis, my boss, was originally supposed to testify. He had a scheduling conflict. So thank you to MJ and the committee for letting me testify in his place. My name's Wyatt Bosworth. I'm associate counsel with the Connecticut Business and Industry Association. We're the state's largest trade association. We have thousands of members, small and large, 93% of which have less than 100 employees. Really happy to be here today to support Senate Bill 135. The bill would establish a maximum annual fee of $100 for most occupational licenses granted by DCP. And just by way of background, in a recent study by the Institute of Justice in 2022, out of 102 occupations examined in Connecticut, Connecticut required 64% of these to have a license, which exceeds the 53% national average. Connecticut's also higher than the national average for fees totaling $290. These fees include charges for application review, license issuance, exams, background checks, fingerprinting, credit reports, etc. But they don't include the cost of the thousands of educational hours, like you heard before, that are required to even apply before you can obtain that license. Further, Advanced Connecticut recently stated in a report that licensing costs the state of Connecticut about 48,000 full-time jobs and shrinks the state economy by $400 million every year. So the financial cost for licensing is a major barrier to entry for many individuals, especially for those looking to raise themselves out of poverty through high-paying and in-demand careers. Additionally, the bill would lower the cost of doing business in the state for approximately a quarter of the state's workforce and make Connecticut a more attractive place to live and work. I'll just close by saying there's been a lot of positive movement in reforming Connecticut's licensing regime, with the governor's bills, getting rid of, the fees for nursing and childcare workers, right? Really in-demand areas of the workforce. Advanced Connecticut just put together a phenomenal report talking about ways we can streamline the licensing system in Connecticut. Was proud to sit on the Comptroller Scanlon's healthcare cabinet, where there was a series of recommendations made last month, one of which through the workforce subcommittee was to reduce licensing fees and streamline those licensing fees for the Department of Public Health. We're talking about DCP here. So, lowering the cost, great way to get more people into the workforce, but there's also other things we can do to streamline the system and make Connecticut a more attractive place to do business. So happy to answer any questions, happy to work with all of you, and really looking forward to coming back to this committee again.
Thank you. Would you be willing to send us that advanced CT report?
Yeah.
And then again, what was I think you said it costing 40,000 jobs, but what was the economic value you cited?
$400 million.
So that would be a potential new wages, I would assume.
Yeah. And
Okay.
ironically, the bill last year had the same exact number and did the same exact thing. Last year, Senate Bill 135, there's a fiscal note on the bill. It $30+ million, right, is what it would cost the state. I know there's some ARPA dollars laying around, but like I said, there's other things to do besides just lowering the fees that I think would go a long way. But lowering the fees would really make a difference for a lot of people, especially in low-wage jobs.
What are some of the other things you mentioned and lowering the fees? Like I know you mentioned streamlining the application process, or what are the other?
Yeah, so really going off the Advanced Connecticut which I'll share with MJ and the committee and all of you. They recommended consolidating licenses with similar requirements into a single license, adopting standardized language around occupational licensing, even having just one portal on the state website, right? I mean, there's so many different agencies that govern so many different licenses, which is confusing to a lot of employers and employees, right? So that would go a long way. Ensuring existing regulations are aimed at public safety and consumer protection, obviously. And going back to the fees too. Yeah, I didn't know this before, but a preschool teacher in a public school, that over $1,000 in fees. A sheet metal contractor, $705. That's on top of all the educational requirements. HVAC, $700. An optician, $800, right? It's really, we are not at a good competitive standpoint compared to other New England states around us.
No, thank you. And what I would appreciate is if you could, send that to us and then just look through. I think being cognizant that there is a fiscal note, right? It's going to generate new revenue in
Yeah.
the future that may offset. But short term, what are the fees we should start by lowering?
Yeah.
Right? Like preschool teacher, obviously that sounds way out of whack, $1,000 for preschool teacher in the public schools. But, you know, there are some professions that do make more money that are paying licensing. So that would be appreciated if you could send those recommendations.
Yeah,
along.
so I'll send you the advanced Connecticut report and
Yeah,
then I'll also set this, it's a 200-page, 42 megabytes, 200-page report that the Institute of Justice put out. It's a comparative analysis of Connecticut compared to other states and you know, our fees compared with, you know, other than the educational hours and the work experience required. I think it's just a good document for everyone to get read up on.
Great,
Yeah.
thank you. Yeah, we're just trying to get the most out of you in case you don't come back to visit us like you
No,
did.
I'll be back. I'll be back next week for the AI discussion, but
Okay.
yeah.
Great.
Yeah, so have a great night.
Okay, thank you.
I'll try to get louder than the sermon put on Urban Dictionary tonight. I think that's. Have a good night, everybody.
Thank you. Mr. Clerk, next.
On my list, I have Brian Ascenter next.
I think you
He already went.
Yeah, he did.
Okay. So then next we have Bonnie Stewart. Who's online?
Hi, I know you have had a very long evening. So I'm just going to start by letting you know that my name is Bonnie Stewart. I am the CEO of the Connecticut Society of CPAs, and we are representing approximately 6,000 people in the state of Connecticut, 6,000 professionals. I've pulled up a screen because I wanted to show you something so I could make my testimony fairly quick. If I can just get the sheet to change. In Connecticut, we have, there we go. We have quite a few CPAs, but many of them choose not to be licensed CPAs, which is completely legal. In any state, you're only required to be a licensed CPA if you do attestation work, so certain types of audits and financial statements. So the people that do taxes and client advisory services and many of the other things at CPA firms don't actually have to be licensed. However, those who choose to be licensed in Connecticut seem to be far fewer than those who choose to be licensed in the other states. And the reason for that is our extremely high licensure rate. So you'll see here that we go through the roof. If I looked at the country as a whole, Connecticut CPAs pay 182.5% higher than the closest state, which would be Wyoming at $200. But if you look at the rest of the states that surround us, we pay 602% more than Massachusetts, 1,036% more than Rhode Island, and 485% more than New York. The reason why these numbers matter so much is that people can practice in Connecticut, like I said, if they don't have a license here, and they can actually even perform audits and other certain types of attestation work without having a license in Connecticut because of the mobility rules around the country, which are extremely important to maintain. But it means that we could have a Massachusetts, New York, or Rhode Island CPA that is domiciled in that state or whose office is out of that state, perform those services in Connecticut without paying that $565 licensure fee. We can do work in their state without paying their licensure fees. So we're not advocating changing it, but we're just showing that somebody can choose to have their office somewhere else. And it's so easy in a state the size of Connecticut. And that just means that they save a huge cost. If you think about it, just having 10 people not have their license in Connecticut saves you $6,000. So it's really important that we think about that in terms of location, kind of what Wyatt was getting to before in terms of the competitiveness, loss of business activity, et cetera. Because remember, they're bringing those revenues back to Rhode Island, Massachusetts, or New York, not to Connecticut. I think another thing that's important to understand is that there's a real shortage of accountants across the country and CPAs in particular. And we really need to encourage more people to go into this area. And when you have a very high licensure fee, it's something that discourages people from going into that fee. In addition to that, it causes other problems in terms of people's willingness to pay for the other fees that come along with it as well. You have to have 5 years of college now to have your CPA. You have to have a certain number of years experience. And it is all something that in the end is very well worthwhile for the people who are entrusting these individuals. But we have a shortage, and it's going to become crisis before too long, not only in Connecticut, but across the country. But in Connecticut, we have a significantly high number of baby boomers that are going to be retiring in the next, I'm going to say, starting now, we're already starting to see it this year, right through the next 5 years, that will result in a real drop. And so our need to attract more people to this profession is even that much more important. And the licensure fee, we know for a fact, is a problem, especially when firms are choosing not to license these individuals because of the cost associated with it. It's one of the biggest complaints I receive from my members is the high licensure fee. You heard a lot from other people, and I thought that Senator Fazio did a great job earlier today. So if you have any questions, I'd be happy to answer them. But my concern is, again, our need to have more CPAs in Connecticut, not fewer. And I think this is a great proposal to put forward. And I appreciate the fact that you did this and that you're considering it seriously.
Thank you very much, Bonnie. Are there any questions? Okay, hearing none. Thank you for hanging in there and for your testimony.
Thank you.
Okay. Next.
Up next on my list, I have Joseph Raymond online.
Okay.
Hey guys, can you guys hear me?
Yeah, we can hear you. Please go ahead, Mr. Raymond.
Thank you for your time. I appreciate it. My name is Joseph Raymond Achitulo. I've been a lifelong resident of Connecticut. In 2013, I was arrested. Hold on one second. I was targeted by a corrupt statewide narcotic task force and subsequently arrested for marijuana cultivation. I fought the charges because I knew that things were not right about the case. I took the case to trial, and after 42 appearances in 2 years of my life, and my lawyer threatening a Franks hearing, the case and charges were dropped against me. Since 2013, I have been a legacy operator. There has been no opportunities given to me or people like me to enter into the cannabis industry. Instead, now the Attorney General in the state of Connecticut have a case against me, and they are trying to go through my banking statements. They're just trying to crush me. I'm asking the General Law Committee to make that right and have the state drop this case against me. I am a legacy operator who has not been given an opportunity to enter the market. You guys have sold it to corporate overlords, some of them from Russia, without giving the true people from the community an opportunity. You've taken opportunities away from small businesses and are giving them away to out-of-state corporations and now criminalizing me with civil penalties. That is not right. I'm going to fight this to the death. Please ask your state or whoever's putting this against me and High Bazaar to stop. We are the legacy community. I've been out here advocating for fair, equitable laws and policy for 10 years, while my own representative laughs and he's snarky to me, Representative D'Agostino. It's crazy and criminal what you guys are doing to me. I have a family. I lost a baby in July over this stress. You guys have no compassion.
All right. Next.
Up next, I have Jen Johnson.
Are you,
No.
is she online?
No.
Okay. Ms. Johnson? Nope.
Next.
here.
would be- Oh, he's back.
I'm trying to hear you guys.
Oh, yeah, we're sorry. Yeah,
I'm sorry. I'm upset. Like this has gotten too far. It's escalated. I've begged my representative D'Agostino for help for years with nothing, no entry, nothing. Just like, sorry, next year maybe, next year maybe. I don't know what else to do. I'm at my wit's end. I had to file a protective order against the state of Connecticut tonight through my attorney. This is insanity. Like, what is going on? Like, what can we do? Why are you guys doing this to me? Why are you targeting activists?
All right, thank you. Are there any questions? Okay, thank you for your testimony. And
Yep. Next on my list, I have Christina Capitan.
you. Great. Thank you. Just please press the button.
Good evening, respected members of the General Law Committee. Chairman D'Agostino, Representative D'Agostino, Representative Candelaria, it's good to see you. Representative Brown just left, of course, and Senator Kissel is no longer here. Representative Vertigliano, Senator Maroney, it's very nice to see you all. My name is Christina Capitan. I am one of the founders of CT Canna Warriors, a grassroots cannabis advocacy organization. Our organization is centered around supporting restorative justice for our communities, which we believe to be one of the most imperative pieces of ending cannabis prohibition in our state and across the country. Restorative justice is not achieved by simply infusing disproportionately affected areas with funds derived from legal cannabis sales, or allowing extremely limited number of equity licenses to enter the market only through an unfair, unjust lottery system. Restorative justice is certainly not continuing to invest time, money, and resources into investigations, raids, and arrests of nonviolent cannabis offenders, but actually quite to the contrary. It's having the hard conversations with diverse demographics of individuals, including those who are still unfortunately considered criminals, such as myself and my friend Joe, as well as working to help those that were arrested, incarcerated, and had their lives disrupted by cannabis prohibition adjust to new laws and help to integrate them into the market, the new marketplace that is set to replace the pre-existing marketplace. With that being said, the main reason I'm in opposition of 5150 is honestly just that it lacks any real substance within it to help heal the deep and painful wounds that are still festering from years of terror from the cannabis prohibition, which again should be taking precedent over things like securing revenue and implementing egregious regulations on hemp farmers and small amounts of THC. This bill instead seems to reinforce the rhetoric of the racist and harmful cannabis laws from the past, reiterating that cannabis is as an ominous and dangerous product requiring extensive regulations. It's a prime example of the overregulation that's stifling your current medical and adult use cannabis market today. Now, and these rules that you're suggesting will ultimately be more detrimental to the cottage hemp industry that has been supporting the needs of our people for years successfully, making more good law-abiding citizens into outlaws like myself, as well as creating more barriers to access for people in true need. Connecticut's obvious prioritization of securing revenue from cannabis over restorative justice is a disheartening reflection of skewed priorities. By prioritizing revenue and regulatory oversight Over addressing systemic injustices faced by marginalized communities impacted by the war on drugs, including those who were arrested and incarcerated for cannabis, Connecticut risks perpetuating inequities rather than fostering true healing and reconciliation. And I believe that your legal cannabis market will continue to suffer because of that. There is no love, there is no compassion. And it's unfortunate because as somebody who's worked in the underground, illegal, illicit market, as well as within the legal medical side of things, I do truly feel that that's one of the biggest things that we are missing out on. And that's why we are not as successful as I think we could be. I urge policymakers to reevaluate their approach, ensuring that restorative justice is at the forefront of every conversation going forward. Thank you for your time.
Thank you. Does anyone have any questions? Thank you so much for hanging in there and for your testimony. MJ next.
Next on my list, I have Brett Webb. He's not online, so. Then we will move to Bryce Chinall. He's online.
Okay.
Hi, I think I've made it in.
You're in, Bryce. Please.
Thank you, MJ. I'm sorry I'm not there in person tonight. I was there for most of the day and just left a municipal meeting here in Newtown and just sat down. So I'm glad I caught a bit of Wyatt's testimony from CBIA, and I just wanted to come in here and reiterate Yankee Institute's support for SB 135 to lower occupational licensing fees here in the state. A number of the points made by Wyatt just a moment ago, I'd echo those. You could also turn to the White House Council of Economic Advisors report in 2015 on occupational licensing and the significant costs they impose on individuals seeking employment in the regulated areas, how they increase costs on goods and services due to reductions in market competition, and often fail to demonstrate the supposed benefits that make them necessary in the first place. The Institute for Justice has great information on this, and there's a couple of reports that echo, again, what CBIA just expressed recently. I thought I'd perhaps take a moment, though, too, to share more of a personal narrative on this. In what feels like a past life at this point, I was once a therapist for kids with autism, and I didn't receive any formal training. A friend said, "Hey, this is an opportunity," and this is a point in my life where I was very broke. I had a broken ball joint on the front left tire of my car, and I had to scrap it for parts when it started smoking because the engine coolant all leaked out from a corroded part of my engine. But so I didn't have anything, but I became a therapist for kids with autism back in Wisconsin. And one of the kids that I helped oversee, I was the only therapist he ever had that he never hit. And I didn't know if that meant much, but my supervisor said that was really important. And so I just remember her saying, whatever you're doing, keep doing it. And I just think of how, if there was an occupational licensing fee for something like that, I was trying to look up the details for that here in Connecticut. It seems a little bit unclear to me, but there are behavioral analyst occupational licenses that are $380 here in the state. I would have never done that. And perhaps I wouldn't have made the positive impact I had on that young person's life. And so I wanted to tell maybe that personal one. And I also wanted to, I haven't submitted testimony on this. And actually, MJ, I noticed the testimony that I have for SB 135 is just a screenshot for some reason. I think it was a mistake on our submission, but I'll make sure that you get what you need for my written testimony to be there. But also in support of, or in opposition to HB, the 5151 on the implementation of, or imposing a new license for installing solar panels. I think the testimony from the Connecticut Solar and Storage Association, Mike and his colleagues there said it very well. And I think the people that are doing the hard work of installing solar panels, especially given all the other initiatives that we have to electrify everything, putting barriers in the way of adoption for solar energy, I think would be a mistake. Thank you.
Rep. Tigliano.
Thank you, Mr. Chairman. Thank you, Bryce. Bryce, I am reminded, and the chairman and I were speaking on the topic when somebody else was testifying. Years ago, we had a bipartisan group that we put together to study licensing in Connecticut. It wasn't just about the price. It was also about how many we have, how many do we need any? And it really was bipartisan. It was, I can't remember the name of the commission, but it was Sabira Gordon. Do you remember? You helped me out with that one. And then the Yankee Institute were at the table. But I don't know what happened. Time went on. My question to you is that I think the committee, and I'm speaking for myself, but I'm hoping I'm speaking for everybody, has an appetite, I believe, in trying to look into this maybe a little bit deeper. And I'm asking if Yankee Institute would be part of that, a part of the discussion. If we do decide to put a task force or whatever, I am only the minority ranking member on the committee, but I would enjoy having a deeper discussion about all occupational licensing and how we handle it in Connecticut. And I'm just wondering if there's an appetite at your organization to get involved.
Yeah, absolutely. Thank you for the question. Thank you for your work on this topic, and for your members of the committee. I know Senator Fazio, Representative Cheeseman have been working on these topics too for some time. That committee was before my time. I don't know that I could offer any details, but certainly on the spot on it. But maybe a recommendation that could go into this, or this could be part of this ongoing discussion, is there are a number of states that do some form of universal licensing recognition. So if you have a license, say in another state, it's an easy on-ramp for you to come work here. And I think this fits both what the business community is continuously telling us, that they're looking for the right type of people to hire, right? And our, initiative from the Lamont administration and elsewhere of make it here, right? In Connecticut, we want people that are fabricators and, whatever it might be. Making it an easy on-ramp to be a therapist, to sell real estate, all these things, I think the better. And I'd be happy to be a part of that.
Thank you, Mr. Chairman.
Great, thank you. And I think, I do agree, right, with the task force, but I also would like to see if we can do something this session. And so I think it's a combination of what can we do immediately, but recognizing the fiscal constraints. If you could help us prioritize where we would get the most bang, like which are the fees that we should start by reducing that will have the most impact on whether it's creating jobs or allowing new people to enter into the field. And then we'll look at what else we can do beyond that. But your help with that would be appreciated, Bryce.
I'd be honored. Thank you.
Thank you. Are there any further questions? Okay. Hearing none, Bryce, thank you.
Thank you.
I'm glad the timing worked out for you, that you got to go to your meeting and get home and then jump online. So
yes, and thank you for all the work that you do. I know this is very hard and being up late, so I'll stop talking so you can move on. Thank you.
Thank you. All right, Mr. Clerk.
Up next, I have Peter NA. He's not online, so we'll go to, we have Elizabeth LaPierre. She might have went before. All right, then Chad Simard. He's online.
MJ? Okay. All right. Please proceed.
Yes. Excuse me. Good evening, Representative DiAugustino and the General Law Committee. Thank you so much for hanging in there with everybody this evening. I fear that our testimony, at this late hour may go a little unheard. However, I do appreciate the opportunity to speak. And so with that, I'd like to start with, I've been asked to speak on behalf of our company, the Flower House. Our CEO specifically had asked us to testify today. We are a Section 149 cultivator. In regards to that Section 149 license, I know there's been a lot of discussion around cultivation, canopy, supply. And our concerns are specific to a few points. They're relative to Section 3, right? Section 4. Those are relative to overall canopy and the health of the industry. So I'd like to bring your attention to a few things that are related to our journey. And that journey starts initially being awarded the license. So when we were awarded the approval back in, July 12th of 2021, 2022, excuse me, we obviously attested to having to pay the provisional fee and background checks and move that licensure forward. And so we executed all that in the manners that we were asked to do so. And the reason why I bring that up is under the context of the original law that was created, we, as we navigated, the Public Act 21-1, we approached that with the confidence that we could execute. And I'd like to testify here today that we have successfully been able to navigate all of that statute 21-1. Our concerns lie with Section 3 and Section 4. But if you don't mind, let me elaborate on our journey a little bit more. After the state of Connecticut had lost our provisional license fee for the matter of about 3 weeks, we were unsure of where that wire transfer had gone and what the outcome of that would be. So as far as hurdles and the journey is concerned for a social equity applicant or for a cannabis licensee, we can attest to what some or others have not or may have experienced. Next, we can attest to the fact that we've navigated 13 to 15 disproportionately impacted area buildings, DIA area after DIA area, DIA landlord after DIA landlord. And so to no avail, over 8 months ago, unfortunately, we had a landlord that was unable to execute their responsibilities, even though we were in a position to move forward with them. And so, this brings me fast forward to a topic of where is the flower, flower shortage. So I rewind back to the fact that we then had to go back to and re-navigate additional buildings, and we were successful in finding another building in a disproportionately impacted area. And so I mentioned that just to frame the fact that a lot of individuals who have been navigating the space, I believe there's 12 provisionally licensed Section 149 cultivators right now here. I understand, their frustrations and concerns. My concern is that I don't hear anything that is relative of helping the existing provisional license individuals. I do hear about other licensed individuals asking and requesting for some assistance, but I don't hear from any individual that has not been able to pay the $3 million provisional fee, that they, number one, attested to when applying from the Department of Consumer Protection.
Your 3 minutes was up a little bit ago. Would you mind summarizing? And then I do have a question for you. So.
Absolutely. I will summarize to the fact to acknowledge the state of Connecticut, to let them know in the General Law Committee that we do plan and intend to be open in the end of 2024 and the beginning of 2025. And so I would have a few rhetorical questions to summarize. Do we know how many cultivators are planned to open? Do we know what the intended canopy is at this point for the state of Connecticut? So making the changes that are potentially vulnerable in Section 3 and Section 4 of Bill 5150, they pose a great threat to the industry and the overall health. And there are many other things that I have concerns over, and that's related to other licensees getting open, ways that we can assist those licensees in getting open with speed to market, et cetera.
Okay, thank you. Now, so did you already pay your 3 million? Is that?
Yeah, yes, we have.
Great. No, and I think it is understood, but in terms of the canopy that's overhanging the market, and that's part of the intent of the bill, is to give people the option, right, to convert down. So we're taking some canopy off to negotiate with, the hemp farmers again, to give them an option to get started. And then if they don't do that, unfortunately, right now, there's any 12 to 15 people who have won the provisional license, haven't paid their $3 million. That's over 3 million square foot potential gross space to come in, more than 2 to 3 times what we need, right, as a market. So we need to we need to eliminate that canopy, but we need to give people an option, right? And I understand that it may not seem fair that you've already paid your 3 million. That being said, what could the state do, right? We are going to charge a conversion fee. Should that go to low interest loans for the people who have already, executed their license? Are there things that we could do rather than just saying not to give these other people an opportunity?
So if you don't mind, I'll answer your question, but I will state, do you understand that our social equity CEO and our company and our 3 owners owe at this moment $23.8 million to build a facility here in the state of Connecticut? And so I understand that there was an initiative and this is an initiative to give an opportunity to other individuals. I guess what strikes me is that I'm not understanding the opportunity or the state's opinion to give an opportunity to the individuals who have already obtained those lottery licenses, who have paid the provisional fee. So we're looking to introduce other opportunities, other people, but we're not looking to help the existing folks. And so that's where, one concern, and we caution that based on data. Where is the data that says that if you allow the Section 3 and Section 4 amendments to pass, that you expect that opportunity and that flower to pan out? I say factually that I see no testimony being accurate today that says there will be any new flower or any new opportunity given until the year of 2025. And I say to you, at least factually, that we will be operational in 2025. And so I do have some insight and believe that there will be a handful of other fine fennel benzacs testified today, be operational in 2025. So there will be flower that's and cannabis and medical recreational products that are being brought to the market in the year 2025. So the solution in Section 3 and Section 4 is not a solution to fix a concern now. It will only be adding to what we believe, and it's just from data surveying the market in Massachusetts and other states that will actually, unfortunately, in that. So let's bring in the 7-year to a 3-year social equity applicant conversation, right? Reducing that 7-year to 3-year barrier so that they have an option to sell. I believe that that's only going to present a great issue before our state and our market even gets open and operational. I believe that there may be social equity licenses and applicants that will have to close their business. And I'm not sure that that's something that the state wants to have on their chest.
Okay. Does anyone else have questions? Okay. Thank you very much for your testimony.
Thank you, General.
And Mr. Clerk, next.
We have Josiah Schlee.
Yeah, thank you. Pardon me?
Oh, it's on, okay. Yeah, so I did have a testimony, but so much has been covered. What's really important to me that I would really like to hear an answer about and looked into is I've asked Attorney Tong, I've asked the DCP multiple times to look into explaining and disclosing remediation to us medical cannabis patients, and also explaining the mold situation, because in this bill 5150, there's a lot of language about remediation, and that proves the presence of mold in the cannabis. And nothing has been explained to the people about what this remediation process is. There's no studies on whether it's safe or not. There's no, we're guinea pigs as medical patients. I haven't been to a dispensary for years because of this, because the last time I went to the dispensary was when the DCP had raised the mold limits without notifying the patients to a dangerously high level at the height of the pandemic, gave me a respiratory infection, and I stopped going to the dispensary, and all of a sudden that respiratory infection cleared up. And I felt a lot better. And I've asked the DCP over and over, I've asked Attorney Tong about the mold situation, the remediation situation that patients deserve to know about. And I'm in the final pool for the ombudsman position for cannabis. I really care about patients, other than myself. And people really want to know what is going on here. I'm not sure if anyone has answers or knows about this, but it seems to be completely glossed over. Because there's all this labeling, safety, all this safety stuff, and then mold is just not addressed whatsoever. It's greed, it's overclouding of plants that creates mold. If they gave them a little more space, there wouldn't be mold. Yeah, do you have a question, or does anyone have answers?
I'm not sure what the question is.
What
What-
is the methods used for remediation to remove the mold from cannabis? And why is there no disclosure about the remediation?
Two good questions. We should get answers for those questions.
Because I've been asking the DCPs for 4 years, and Attorney Tong's response to me was get lost, basically.
Well, it's not his, he's not going to answer that question, but we
But-
we will ask that question of those two questions of DCP. Those are two good questions.
So, like, I know I'm backpedaling a lot, 10 steps back, because we're talking about stuff really far ahead.
No,
but this is the
this
basis of
this
the
is-
program and safety.
We will have to get answers to those. I don't know the answers to those
And those
questions. We
standards were
should.
part of regulations, not
Yeah,
legislation.
yeah.
It was,
But
but I
should
don't
know what the answer
Yeah,
is.
right.
So yeah.
Yeah, so we'll have to ask Rod, I think.
Yeah, we'll have to ask the regulators at DCP those questions.
Okay. And
maybe we can encourage them to post sort of a disclosure. of
well, I
what-
think we
sort of-
deserve more than a post, because there's been hundreds of people emailing the DCP for 4 years now with no response.
All right. We'll follow up with them.
I would very much appreciate that, because it's
And
very
as you mentioned,
concerning.
I mean, part of the creating the ombudsman position is also to have a dedicated office, to respond to these and have more of an avenue. I mean, I understand the
Yes.
Attorney General's office isn't going to be able to answer those questions, but that ombudsman position, it was created specifically to have an avenue to get answers to questions like that and have a more dedicated advocacy voice for exactly that. So that,
I hope
we-
so.
Yeah.
Because it is disturbing, it's dangerous. We don't.
Yeah, no, look, we don't
know whether it's
the
safe
whole
or
point
not.
of a regulated market was to make sure that the product was safe. If there's products not being produced that's safe, A, it shouldn't be sold, but B, there should be a process behind it to make sure, hey, he's got the floor. Okay, so all right, he's got the floor. All right, so, there needs to. So there needs to be answers to those questions. And obviously we want to make sure that the products that's being sold in Connecticut is, as mold free as possible, but certainly not causing respiratory illness or anything like that. And so that's that should be job number one for us. So if you're not
Yes,
getting
I
answers to
agree.
those questions, we will ask those questions of DCP tomorrow and make sure that there's some sort of public answer available with respect to what is being done about mold. And then I hope we see you up here next year as the ombudsman,
I would love that.
testifying as to what
I
you
would
want to
love
see.
that.
So-
Is there any way you could get like a promise that like people will be emailed within some certain amount of
You
time?
just got it.
or-
I'm talking to them tomorrow about
Okay.
other issues. I'm
Okay.
going to ask them about the
Thank
mold
you.
issue. Yeah.
I appreciate it. And no one has any more questions?
Mr. Chair, if I may, so you've just stolen my thunder because I have scheduled a meeting with DCP for next Tuesday, specifically to discuss the mold issue.
Thank
And
you.
they're getting their right people together to come to that meeting. Because you have emailed me about this and I have looked into it. And we do have, from what I can tell, the highest mold ratio in the country. And I for one want some answers, and I'm really grateful to Chairman Daxino for arranging that connection for me, so we can get those answers for you. But he's going to beat me to the punch tomorrow.
Thank you. Well, that might be the answer to the drop in sales too. So, help yourselves.
Sure. Why would you buy? Why would you buy product that you don't believe in? 100% makes sense.
Yeah. I appreciate all of you. Thank you very much.
Thank you.
No
Thanks
one
for
has
coming
any
in,
more
Josiah.
questions for?
Nope. I don't think there are any further questions. So
Yeah.
thank you for.
Thanks for
testifying.
picking it out. Thank you.
Up next, I have Cody Richard.
How you doing, guys? So I just wanted to be able to say I have a whole new respect for every single member of this committee for seeing what you guys deal with, because this is my first time attending and being a part of this type of environment. So yeah, a lot of respect for you guys. My name's Cody Richard. I own Cannabis Connection Delivery Service here in the state of Connecticut. I am a licensed, not fully licensed yet. I hold a provisional license that I won in the general lottery. I'm here not specifically to weigh in on current language within the law, but I'm here to be able to express the struggles that I have dealt with getting to the point of operations with this. So thank you for passing the initial bill that has allowed us to obtain licensing in the cannabis space here in Connecticut. Thank you guys for all of that. Wouldn't be here talking to you if it wasn't for that. My testimony is not to throw shots at the committee. It is to raise awareness as to the struggles and concerns I have experienced while starting my delivery service. A concern I have is changing current law specific to delivery, which would be detrimental to current and upcoming delivery operators in the state who have put their blood, sweat, tears, and in my case, my entire life savings, along with accruing an enormous amount of debt in order to start my delivery service. Another concern I have is introducing additional delivery licenses to the market at this time due to the fact that there are only 2 active delivery operators in the state of Connecticut out of the approximately 10 delivery licenses that were originally awarded. Additionally, under current law, hybrid retailers, micro cultivators, and dispensary retailers can effectuate delivery services until there are 5 delivery operators that have commenced public operations. But the current law doesn't cap the amount of drivers hybrid retailers, micro cultivators, and dispensary retailers can employ. This is very concerning for delivery operators because as a delivery operator, current law restricts us to 25 drivers. And obviously, given that there's nothing restricting any of those other entities to the amount of drivers, they can essentially have an abundance of drivers on the road, while us delivery operators are still gaining approvals and, looking for funding and whatever the case may be to get our businesses going. So it would be, there may be some additions maybe in the next session or something to do with the amount of drivers that those entities can be able to provide, given, the struggle that it takes to actually get these businesses off the ground, So that's all I got for you.
No, I think I thought what you said. So the current structure limits your number of drivers, but for example, if we allow a micro cultivator to deliver, I mean, it's probably unlikely they're going to have 25 or more, but you're saying there's no limit and that should be I can see what you're saying, and that's probably an oversight in drafting that we did on delivery. So that's a fair.
So I just wanted to raise
Yeah,
that.
I got you.
Because, yeah, currently, the current statute will allow micro cultivators and hybrid retailers and dispensary retailers to effectuate delivery operations right now.
With no limit on the number of drivers.
With no limit on the
Whereas you have
number
a
of drivers,
dedicated
too.
license
Right.
to that, and you're limited to the number of drivers.
Right.
Fair, okay, fair
Right.
point. Yep.
So there's that aspect to it. Maybe it's just the language or something that was, left out, but just wanted to raise that. So I appreciate your time. If there's anything else, I'm, more than
Hey,
happy to answer anything.
Yeah, thank you. I know I saw you, I think, first thing when I came
First
in
thing in the
here-
morning with MJ.
Came in here this morning, so.
Yeah.
And you held true to your word that you were gonna stay till you had your opportunity to testify.
yes,
So
uh,
I doubted you. I didn't know if you would still
Oh,
be
yeah. I mean,
here,
I
but-
expect that. Yeah. Well, this is my first time. It's not going to be my last.
Yeah,
So
great.
I appreciate it. And it's been a great experience so far. So thank you.
I'm actually glad you're here, someone from delivery. I've had someone bring an idea to me for doing a pilot program in regards to electronic verification for cannabis delivery.
I believe I've spoken with that individual also about that in terms of the age gate and how they can verify an individual prior to completing deliveries.
Yeah,
Yeah.
exactly. Is that just, I would love to get your thoughts on that. If you
So
thought
I've
it would
actually-
make sense to do a pilot like that, and is there value from your
Uh,
perspective?
Currently, I do believe that Drizzly, the alcohol delivery service, does utilize a similar technology to that. I have inquired to my DCP agents regarding utilizing technology to that, and they says, Cody, if you want, you can utilize technology like that, but we're still going to require you to visually verify the identification of the consumer at the point of delivery too. Do I believe a pilot would help to? It would help to, display the technology and possibly see the flaws in the technology, because without actually running a pilot, how will we actually know if it could potentially be beneficial towards us, to any of the retailers or delivery operators in the state. So I do believe it would be beneficial just to see how the technology it would, work in this space.
Okay, great. No, thank you very much for answering that.
Thank you.
Are there any further questions? All right, Cody, thank you very much.
Thanks, guys.
Mr. Clerk, is there anyone else?
Yes, we have Olivia Rinks online.
Thank you. Good evening, and thank you for the opportunity to testify. My name is Olivia Rinkus. I'm from the town of Northampton, Connecticut, and I'm also an undergraduate student at the University of Connecticut. I'm testifying tonight in opposition to HB 5150, an act concerning cannabis and hemp regulation. I am a longtime supporter of the destigmatization, decriminalization, and legalization of cannabis. Connecticut made important moves by legalizing cannabis in 2021, but unfortunately since then we seem to be making backwards movements when it comes to destigmatizing cannabis and repairing the harm that has been created by the war on drugs. Legalization has continuously prioritized large out-of-state corporations at the expense of the social equity applicants in the state who have been forced to compete for crumbs. Cannabis was legalized with the talk of removing cannabis convictions from individuals' records and releasing individuals incarcerated for cannabis convictions. Instead, now we're still seeing taxpayer money going to the arrest, investigation, and continued persecution of individuals over cannabis. Now this bill is suggesting even more legislative restrictions. These restrictions are being put in place supposedly to protect consumers from the dangers of an unregulated market, and yet while the THC is being capped in legalized cannabis, the legal threshold for mold is going up. Where is the concern for consumers in that respect? Please listen to the cannabis advocates and supporters and oppose this bill and other bills that will take us backwards in the process of legalizing cannabis. Please destigmatize cannabis now and repair the harms to the ineffective and community disrupting war on drugs. Thank you very much for the opportunity to testify.
Thank you for your testimony. Does anyone have any questions? No? All right, thank you. Thank you very much. Mr. Clerk?
Yeah, Mr. Chairman, I think we might have one more person if he wants to testify.
Yeah, when you come up, the red button's already on, so you just need to state your name, please.
Hi, I'm Tyler Lupacino. it's my first time doing this, so I just wanted to kind of make a couple points since we're already kind of on the subject and topic. Appreciate you guys for listening to me. It's such a wide spectrum and such so many different problems, but I don't know, I want to kind of specify on like a couple, especially the ones that are like most meaningful, I think, especially to me. Especially like, I don't know, for instance, like I'll just get to the point, like I find it's really funny that we're focusing on I feel like the wrong things in these percentages. I'm not saying they're wrong. It's just like I feel like there's more precedent issues, like I don't know, like loved and family ones sitting in jail and incarcerated over the same thing that they've been fighting for and been passionate about for the past 30, 40, 50 years. And yet those people get shut down and pushed away. Well, all these other corporations and people come in and like, I don't know, past 7, 10 years, it's like, I don't know, the cannabis industry or whatnot has been booming or going towards like, I don't know, like in like the wine or cigarettes or whatnot. It's like so regulated, but like it's not so regulated yet. So people are really trying to hold it back so they can get the taxes or get the loopholes in between or like pay the lottery. And like I get it's a pay to play game, but I feel like we're also like there's a certain part of the market that's just getting shut down immediately and not giving it an opportunity or a spotlight just because they're looked at as criminals and they don't have the ability to pay to play. Never mind, they have these things on their record or whatnot, and like there's nothing in between, and there's no like that just gets overlooked because the people come in and I mean I get it, it's the industry and like the supply and demand trying to come up and keep up with that, but yet again, like of course when you compare like someone who's been whatever trying and getting harassed and whatnot, then you got these millionaires or billionaires coming and it's like, oh, let's come in and capitalize off the market. Why wouldn't they want to? It's a smart thing to do. And like everyone, some people are here specifically fighting for the plant, the passion and the people. Some people are here to fight about their profits and to make sure because they already paid this money, and it makes sense, right? But it's such a huge thing. I feel like putting these limitations and setbacks on it, it's just like, I don't know, because there's still people like hiding in the shade and like whatnot, and like 7, 10, 20 years, but like how about the people that have been 30, 40, 50 years that have hide and they were stigmatized and just they don't feel safe because what the world is. Never mind, it's like a medicine, it's plant, it's like it's natural. Never mind, there's nothing, there's no testing, there's no actual in between. And like just because like the new regulations, it's like, oh, people can't smoke and drive, people can't do this and that, there's no testing, there's no anything in between, and people have been doing this anyways. So like what's the difference now that there's a law that says so? But like in the people's mind it doesn't make sense. But I mean I get it for safety and regulations and by the book, but like the book doesn't seem to make sense if it's supposed to put the people first. And that's just touching on like one thing specifically, but I appreciate you guys listening. Another thing too would generally be like I don't know, I feel like a lot of other states and spots have like good framework, and in between it's just like hard, and the state is difficult, and I get it, but I don't know, we fight. I feel like we try. I just feel like the wrong people don't listen to us, or it's just difficult to actually make an impact. And I don't know, I want to change that, especially because people shouldn't suffer. Never mind the mold and anything in between. It's like if you have the people that have been passionate about this come out of the shadows and stop hiding, but like they can't because it's not right yet. You feel me? Or maybe you don't, but it's just like the people that have like the passion and like the actual, like, I don't know, like, yeah, so people have been coming in because it's like, oh, you smoke weed, weed's cool, whatever, or cannabis, but like, it's a medicine. Some people are like, oh, like specifically this one strain, oh, it's the only thing I smoke because it's my medicine. I've been doing this for like the past, it's just, it's what works for them. It's like, that's not like anything in between. There's not in a lab. It's not made in a lab. It's natural. Never mind. That's what's so great. And like, everyone can do it too. Never mind, like, how you grow in your garden. You can grow a plant pot in your garden or whatnot if it's legal, but you can't grow it outside, even though you should be able to because electricity is expensive. But anyways, it's just these rules and regulations that like people have to play inside, but like, why? It's medicine. It's a plant. It's like it's natural, and like I don't understand why like people get, never mind, you get stigmatized because oh you smoke weed or oh you're it's a bad look, but why?
Does anyone have any questions? And Unfortunately, I don't know
No,
if
you're
anyone
good.
has answers for you. I'll
I
see
don't-
if anyone has questions.
Expect you
so-
to have answers for me. I just,
Yeah.
I hope you guys hear me. I appreciate you guys taking, I know you guys want to go home. It's the end of the night, whatnot, but I mean, it's just real things that are actually like, I'll never mind like the in between of like the legal and not legal and the like, it's a real thing that like saves people's lives. Never mind like you can't, how many people have died because of marijuana or cannabis. It's hard to find those facts, but yet again, whenever something gets or someone gets in trouble with cannabis because it's so new and unregulated and there's not the research behind it, that's the headlines because that's what they want you to see because they want to slow it down. They want it to, whoa, 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 it's the scary thing in between because they want to make the money off it, which I get it. Who doesn't want to make the money off it? But open it up so it can be free to the people because like the people bring the passion to it. So it's like people smoke weed, they're going to smoke weed, make it open. So people drink alcohol, give them the option. They don't have the option. But as the people, they should, because either way, people are going to do what they want to do realistically anyway. So it's just like end the war on drug wars. But like, you can't, because what if not? I get that. So it's like, open up, never mind. Like, it's natural.
Thank you very much.
Thank you. I appreciate you guys.
Thank you. Have a nice night. Is there anyone else here who hasn't signed up? Who, you've been sitting there all night?
Education on the marijuana.
All right.
Education.
So, Tuesday at, Mr. Clerk, when's our next meeting?
Early Tuesday, early.
Tuesday at noon, Mr.
Tuesday
Chairman.
at noon. It promises to be just as long, so.
Thanks.
But unlike today, Marcus will be here and we'll all be home. So, all right, thank you very much. We are adjourned.